Hello. Hello. Hello.
ಹೇಳಿ ಸರ್.
ಸರ್ ಕೇಳಿಸ್ತಿದೆ ಮೇಡಮ್?
ಕೇಳಿಸ್ತಾ ಇದೆ.
My lord, 20 matters.
First memos.
Lordship, one matter, my lordship, there is an office objection with respect to filing of the genealogical tree, my lord. What happened, my lord, the soup is for marking.
We can't hear you now. You file a genealogical tree. If you comply, it will come.
They have moved an FDP proceeding, my lord.
Good.
That's the reason, my lord.
Yeah, FDP, soon after they file FDP, nothing will happen. It's a long process.
With my lord's kind permission, one RFA, my lord said, my lord permitted me to withdraw the amount which was in deposit. But in the uploaded order, my lord, that last regarding permission for withdrawal is not appearing on the ground.
Kottiri.
Hearing, my lord, it has to, it is posted for final hearing. It has to come for tomorrow. My lord.
Have you filed any application or being spoken to in Hakivira?
But it could be for being spoken because application is already there.
Correct. Have you filed
I have not filed.
for being spoken and Hakivira?
I'll just make that correction, madam. I'm sorry. I'll make that correction tomorrow.
Adjournments, page wise, page 1, seal number 1 and 2, page 2, seal number 3 to 5, page 3, seal number 6 to 8,
Yes.
page 4, seal number 9 to 13, page 5, seal number 14 to 17,
Serial number 16, my lord. I'm appearing for respondent. I need 2 weeks time. And 16.1, I'm applying.
You are appearing for?
Respondent in serial number 16, I'm respondent. Ma'am.
Yes, you go after the release of the amount. Who has filed this release of amount application?
I have filed application for release of.
What do you want now?
I am 2 weeks accommodation.
2 weeks accommodation. Yes, who is Manmohan?
Manmohan PN,
Whether they had pressed the matter at any time?
No, ma'am, they have filed recently one more application for production of
Production
document.
of additional.
In the meanwhile, I'll file objections also on next date of hearing.
Requested by the agent at the request of counsel for respondent.
I'm responding.
Yes.
page 6,
16.1.
16.1, I'm the appellant, my lord.
You are the cross objector.
Cross objection.
R1 ಒಬ್ರೇ ಇರೋದಾ ಬೇರೆ ಯಾರು
Same part ಇದೆ.
ಅಲ್ಲ ಇನ್ನೊಬ್ರು ಯಾರು ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಮ್ರಾನ್ ಖಾನ್ ಸರ್ಡ್ ಅಂತ ಇದೆ ಅಲ್ಲ.
ಅವರು ಪಾರ್ಟಿ ಮಾಡಿದ್ರು ಸರ್.
ಓ ಇದು ಡಿಫಾಮೇಶನ್ ಕೇಸ್.
Defamation case.
They have filed appeal. You have filed cross objection.
Yeah.
ಇದರಲ್ಲಿ 16.2 ನಲ್ಲಿ ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದಾರಾ? Because we will not be having the file now.
Second respondent ಮಾಡಿದ್ದಾರೆ ಇಮ್ರಾನ್ ಖಾನ್ ದ ಪಾರ್ಟಿ.
Yeah, not made them party.
ಮಾಡಿದ್ದಾರೆ ಸರ್.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ ಹಾಗಿದ್ರೆ ಅದು ಚೆಕ್ ಮಾಡಿ ನೋಡ್ಕೊಳ್ಳಿ. 16 as requested agent at the request of first really counsel for respond number 1. 16.1 ನಲ್ಲಿ ಅವರು ಪಾರ್ಟಿ ಮಾಡಿದಾರ ಇಲ್ವ ಮಾಡಿದಾರೆ. ಇಶ್ಯೂ ನೋಟಿಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಲಿಸ್ಟ್ ಔಟ್
11-9.
Please.
is I think you are sailing together. Dispensation go ಹಾಕೊಂಡ್ರೆ ಆಗುತ್ತಲ್ವಾ? Order is passed against both of you. Right? Notice ಹೋಗಿದೆ. Yes.
Page 6, seal number 18, page 7, seal number 19 to 23.
22, my lord, serial number 22. My lord, I appear for the appellant, my lord. The respondent wife has filed an application seeking withdrawal of the permanent alimony which is deposited. My lord, the family court, without there being any application made, voluntarily at the time of passing of the final decree, my lord, of divorce, ordered payment of 25 lakhs of alimony.
Correct. If you want to file objection, you have to file objection.
That's what, my lord. I need 2 weeks time. I have no instructions from my client. The
Why
copy
2
was
weeks
served
time. Application is filed 2024 ಅಲ್ಲ?
24 legal. Recently, it was served upon me.
There are children.
There are 2 children, majors, my lord. One is major, the other is 16 years old.
Then you have to pay. Are you paying any other maintenance?
my lord, she has sufficient source of income is
That is not ground, let the other side counsel come. Yes, next portal mood
Lord,
ಬೇರೆ ಇದೆ.
I have no instructions, my lord. I will file my
Who has
objection.
moved this matter to our
But the
counsel?
other side has moved the matter, my lord.
Then we'll not adjourn it in their absence. Yes, next person.
Page 8, seal number 24 to 29.
Serial number 26, my lord, that I have undertaken to file paperwork and the synopsis. Certain certificate copies I have applied, my lord, that they are in civil court now. That arbitration center I could not get. That 2 weeks time I kindly.
At request 2 weeks time, 26 at request. Final 2 weeks time is granted to file the paperwork.
Please,
This start 2 weeks on the date.
9.
oblige.
Let serial number 29, my lord.
29.
My lord, in this case, my lord, the respondent has moved this matter. I have to inquire, my lord, the deposit details. My lord, can I request
ಅವ್ರು ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ನೋಡೋಣ ಏರಿ ಬರ್ರಿ.
disposal move ಮಾಡಿದ್ದಾರೆ ಕೇಳಿದೆ ಅವ್ರಿಗೆ ಬಟ್ ಸ್ವಲ್ಪ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಮಾಡಿ
Are you sure you have informed him?
ನೋ ಅಲ್ಲ ಇನ್ಫಾರ್ಮ್ ಮೈ ಲಾರ್ಡ್ ಸಿದ್ದೇಶ್ವರಿಗೆ ಮಾಡ್ತೀನಿ
ಇಲ್ಲ, ಮತ್ತೆ ಬಂದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾರೆ ಬೇಡ serial number 7. Now we have bus has gone.
Page 9.
Wait till again that is called.
Page 9, seal number 30 to 34. Page 10, seal number 35 to 38. Page 11.
My lord, 31 ಮಾಡಿ
30.
31 ಪಾರ್ಟಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀವಿ 2 weeks ಟೈಮ್ ಗ್ರಾಂಟೆಡ್.
ಯಾರಿಗೆ ನೀವು?
31 we have already called. Next ಕರ್ಸ್ತಾ ಹೋಗ್ರಿ.
Okay. Page 10, seal number 35 to 38. Page 11, seal number 39 and 40. Page 12, seal number 41. Page 13, seal number 42 to 45.
44, my lord. Appellate in this case, my lord. I'm getting considered as a first time interview. We'll have it next week, my lord. A date will be given. If ready the matter will be given.
Final hearing ಅಲ್ವಾ? As requested by the appellant's counsel, list on
49.
4.
Page 14, seal number 46 to 49. Page 15, seal number 50 to 52. Frauders, seal number 1.
Last 56.
Here for appellant in the connected matter, my lord. Lordship, insurance company appeal is dismissed for non-prosecution, my lord, for non-production of the deposit memo, my lord. This honorable court has granted stay to subject to deposit of 50%. I had to produce the acknowledgement, my lord. I could not produce it, my lord. Now I have produced it on 7/11/23, my lord.
ASA dismiss ಆಗಿದೆ. PF ಕೊಟ್ಟಿಲ್ಲ ಅಂತ PF ಕೊಟ್ಟಿಲ್ಲ.
Non-production of deposit memo ಅಂತ.
Issue notice to respondent. You are not given the PF for issuing notice on these applications.
Your lordship, they have appeared, my lord. The claimants have appeared. There is also connect.
ಆಗಿದ್ದಾರೆ ಅದರ ಸೈಡ್ ಯಾರು ಇಲ್ಲ.
They have appeared. Independent appeal ಇದೆ ಅವ್ರದ್ದು.
Are you going to take notice in this case?
Yes. For the
Yeah.
claimants, I will take note.
Once.
B. Pramod.
Claimants are. So respondents 1 to 5 are the claimants. B. Pramod. Shri B. Pramod, learned counsel, undertakes to appear for response 1 to 5. Copies serve ಮಾಡಿ ಹೋಗಿ.
ಕೊಟ್ಟಿದ್ದೀನಿ sir.
Submits that the copies of IAS ಕೊಟ್ರ ಎಲ್ಲಾನು ಕೊಟ್ಟಿದ್ದಾರೆ.
appeal ಕೊಟ್ಟಿದ್ದಾರೆ. Respect of recalling my notes, I don't have any.
ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಡೆಪಾಸಿಟ್ ಮೆಮೋ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇವಾಗ ಕೊಟ್ಟಿದ್ದೀನಿ ಅದನ್ನ 7/11/23 ನಾನು ಮೆಮೋ ಹಾಕ್ಬಿಟ್ಟು ಕೊಟ್ಟಿದ್ದೀನಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿರೋದು.
CD. ಎರಡು ಐ ಯಾಕೆ ರಿಕಾಲಿಂಗಿಗೆ?
ಡಿಲೇ
533 days. 6 sets ಈಗ ಇಬ್ಬರಿಗೆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6 ಗೆ ನೋಟಿಸ್ ಕೊಡೋದಕ್ಕೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Please make one submission. For the trial court, respondent number 1, he was arraigned as respondent number 1. He was placed ex parte and the insurance.
But that they have to do, no? They will not do. They invite all these orders
2014.
2017 or this case. Correct. He could have executed it. Execute ಮಾಡ್ಕೋಬೇಕಿತ್ತು ಅವಾರ್ಡ್.
Execution ಹಾಕ್ದಾಗ ಇವರು ಇವಾಗ recall ಹಾಕೊಂಡಿದ್ದಾರೆ. I don't have the benefit of even at least 50% of the amount.
Order dated ಎಷ್ಟದು? ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಯವರು ಈ ರೀತಿ ಮಾಡ್ತಾರೆ 25/1/2021. 3 weeks time is granted to comply the office
The
objection.
preemptive order ಆಗಿತ್ತು ನಾನು ನೋಡಿರ್ಲಿಲ್ಲ. Immediately when I came to know, I have filed this application, my lord.
Immediately ಅಲ್ಲ 2000 this order is passed in 2021. You have filed applications in 2023.
Yes, ma'am. Stay order,
How is that immediately you come to know?
ಅಲ್ಲ ನಂಗೆ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆಗಿದ್ದು preemptive ಗೊತ್ತಾಗಿರ್ಲಿಲ್ಲ ಅದು.
Will impose cost.
Your lordship may kindly see, my lord. Your lordship,
Verdict
I am ready for final disposal also, my lord.
Whether at least now we have given a process fee for respond number 6.
Yes, my lord, it is given, my lord. Okay. Your lordship, I am ready for final disposal also, my lord.
Not really clear the matter for finding it.
It may be urgent for you. See, there are so many complaints. ಅಲ್ಲ ಈಗ ಅವ್ರು ಒತ್ತುಕೊಂಡ್ರಲ್ಲ ಗಾಡಿ.
1 to 5.
5 years, 7 years ಇದ್ದವ್ರು. ಅವರು 300 1 to 5. ಈ ಕೊಟ್ಟಿದ್ದಾರೆ ತಾನೆ. All right, then we'll recall that. Third, orders on A number 1 and 2023. This is not office objection are complied. Though the appeal was dismissed for non-compliance on
For being spoken to ಬರ್ತಿದ್ಯಾ?
date of order is 25/1/2021. The above applications are filed after 2 years in 2023. Though the lower counsel for the corresponding 1 to 5 concedes to condone the delay. Having regard to the deficiency, negligence on the part of the appellant, we deem it proper to come down the delay of 533 days, imposing cost of rupees, on cost of rupees. ಎಷ್ಟು ಕೊಡಿಸ್ತೀರಿ ನಮ್ಮ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿಗೆ?
ಇಲ್ಲ ನಾನ್
ಕಂಪ್ನಿಯವರು ಬಿಫಿಟ್ಟಿಂಗ್ ನ್ಯೂ ಇಂಡಿಯಾ
ಇಲ್ಲ
ಅಶ್ಯೂರೆನ್ಸ್
ಕಂಪ್ನಿ ಅವರೆಲ್ಲ ನಾನ್ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ ಸುಮ್ಮನೆ ಅದಕ್ಕೆ.
ಮಾಡಬೇಕು ಅಷ್ಟೇ. 2000 rupees. 2000 rupees payable to the High Court Legal Services Committee. ಈಗ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6 he did not contest ಅಂತ ಹೇಳ್ತಾರೆ. ಒಂದು ಮೆಮೊ ಹಾಕಿ ಡಿಸ್ಪೆನ್ಸ್
ಇದ್ರಲ್ಲಿ ಲಯಬಿಲಿಟಿ ಇಶ್ಯೂ ಇರೋದ್ರಿಂದ ನಾನು ರಿಸ್ಕ್ ತಗೊಳಕ್ ಆಗೋದಿಲ್ಲ ಸ್ವಾಮಿ. ಲಯಬಿಲಿಟಿ ಇದೆ.
So, 2017 appeal ಇನ್ನೊಂದು he had not contested order 41 ಎಷ್ಟದು
Yes, my lord, but
it is
lordship,
that each-
if I insist for pay and recovery, then he has to be, notice has to be sent. Supreme Court judgment ಪ್ರಕಾರ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅವ್ರು ನೋಟಿಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಟೈಮ್ ಅಪೇರ್ ಆಗಕ್ಕೆ ಒಂದು ಚಾನ್ಸ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ ಅವಾಗ.
ಇಶ್ಯೂ ಅಪೀಲ್ ಆದ್ರೆ ಇನ್ ಟೈಮ್ ಇತ್ತ?
ಅಪೀಲ್ ಇನ್ ಟೈಮ್ ಇದೆ.
ನಿಮ್ಮದ್ರಲ್ಲಿ ನೀವು ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಡ್ಬೇಕು. ಇಶ್ಯೂ ನೋಟ್ ಎಲ್ಲಿದೆ ಕೊಟ್ಟಿದ್ದೀವಿ
July 2021 I have filed it.
ನಮ್ಮಲ್ಲಿ ಪುಟಪ್ ಆಗಿದೆ. ಇಶ್ಯೂ ನೋಟಿಸ್
ಸಿಸ್ಟಮ್ನಲ್ಲೂ ತೋರಿಸ್ತಾ ಇದೆ. I don't know why it is not.
ಅದು ರಿಕಾಲ್ ಮಾಡೋದೇನೆ ನಾವು 50% ಹಾಕಿ ಕೊಡ್ಬೇಕಿತ್ತ?
50% ಆಲ್ರೆಡಿ ಡೆಪಾಸಿಟ್ ಆಗಿದೆ.
ಎಲ್ಲಿದೆ ಡೆಪಾಸಿಟ್ ಬಗ್ಗೆ?
ನಾನು ಡೆಪಾಸಿಟ್ ಸ್ಟೇ ಆರ್ಡರ್ ಆಲ್ರೆಡಿ ಇತ್ತು ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
ಎಲ್ಲಿದೆ? ಅದು ಶೀಟ್ ಇದೆ. ಅಲ್ಲ ನಮಗೆ
ಡೆಪಾಸಿಟ್ ಮೆಮೊ ಕೂಡ ರಿಸಿಪ್ಟ್ ಹಾಕಿದ್ದೀನಿ, ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ.
7/11/2023. ಟ್ರಿಬ್ಯುನಲ್ ಎದುರಿಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ?
ಟ್ರಿಬ್ಯುನಲ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಆಸ್ ಪರ್ ದಿ ಸ್ಟೇ ಆರ್ಡರ್.
Rupees 2,21,679. ಎಷ್ಟೊಂದು ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅದನ್ನ 50% ಮಾಡೋದಕ್ಕೆ 4 ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ? 4,87,000, 88,672, 88,670. ಅಲ್ಲ ಇದರಲ್ಲಿ ರಿಲೀಸ್ ಆಗಿದೆ ಅಲ್ಲ ಅಮೌಂಟ್, ಅದು ರಿಲೀಸ್ ಆಗಿದ್ದಲ್ಲ. ಪಿಟಿಷನರ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಅಂತ ಇದೆ ನೋಡಿ. ಇಶ್ಯೂಡ್ ಚೆಕ್ ನಿಮಗೆ ರಿಲೀಸ್ ಆಗಿದೆ ಅಲ್ಲ, ಇಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅನ್ನ ಹಾಕಿದ್ದಾರೆ ಅವರು. ಯು ಆರ್ ನಾಟ್ ಅವೇರ್? ಅವ್ರು ಕೊಟ್ಟಿರೋ ರೆಕಾರ್ಡ್ ಪ್ರಕಾರ ಇಟ್ ಇಸ್ ರಿಲೀಸ್ಡ್. ಹಾಗೆ ಅಡ್ಮಿಟ್ ರೆಕಾರ್ಡ್ಸ್ ಇರ್ಲಿಲ್ಲ, ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ ಟಿ ಸಿ ಅಂತ. ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು ನಿಮ್ಮದ್ರಲ್ಲಿ.
9/7 ಅಲ್ಲಿ ಹಾಕಿ.
Nana counsel for the appellant submits that he has already submitted the second set. Registry shall verify and list all date. Notice will be
18/9.
Much obliged.
Number 2, V Pradeep.
Notice for
But it's considered waiting service.
Service of R5 ఉంటుంది. CRs are received in MF 1465. Connected appeal ಇದೆ ಅಲ್ಲಿ. ಮತ್ತೆ ಇದೇನು ನೋಡಿ TCRs are received in MF 1465 of 2019 ಅಂತ ನೋಟ್ ಹಾಕಿದ್ರೆ ಕನೆಕ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಹೇಳೋಣ. ನೀವು ಬೇರೆಯವ್ರ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ. As per the registry's note, TCRs of this case are received in MF number 1465 of 2019. List both the matters together on
22-8. Seal number 3.
Respondent, my lord.
Andanappa Gurappa. Gautamaaditya.
Mr. Lingaraj ಅವರೇ, ನಿಮ್ಮ ಹಿಂದಿನ ಕೇಸಲ್ಲಿ ಸಾರಿ ಜಸ್ಟ್
Please.
previous case respondent number 5 is a minor, 3 is a minor. Respondent number 1 is he or her or his guardian. She has served unrepresented with new court guardian.
They have to make an application for appointment.
You have to make an application. It is your appeal. Under Indian number from the appellant's counsel shall file necessary application for appointment of the court guardian for respondent. Please.
Seal number 3.
For the respondent.
And for the appellant, my lord, really, regarding the court fees concern, last date, my learned counsel respondent has offered for the settlement. I communicated to the appellants and actually they'll discuss and so
ಅದೇ ಏನೋ counter claim ಇದೆ, counter claim ಮೇಲೆ
the counter claim, there is a court fee has to be paid. But actually on the decretal amount, payment of decretal, there was stay was granted by this honorable court that we have complied. And last date of a hearing, we have to pay the court fee on the counter claim. But since the respondent
So you
has,
have challenged both counter claim and decree
Yes, my lord.
together in one appeal.
please. In the appeal, we have asked for the counter claim. On the counter claim, we need to pay the court fee.
In the
So-
appeal, how could you seek in the appeal counter claim?
So, yes, that is what the interim order was passed. Anyhow, their respondent side has offered for the
ಅವೇನ್
settlement.
ಖರ್ಚು ಸಹಿತ ಡಿಗ್ರಿಗೊಳಿಸಲಾಗಿದೆ. Was there a counter claim in the trial court?
Yes, my lord, they had filed a counterclaim.
But judgment ಅಲ್ಲಿ operative portion order ನಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ವಲ್ಲ? Counter claim is rejected ಅಂತ ಏನು?
Issue number 2.
Issue number 2, whether defendant proves that the plaintiff has to refund an amount of this 10 lakh, that is set off ಕೇಳಿರ್ಬೇಕು ನೋಡಿ probably.
Counter claim in the sense set off.
ಇರ್ಲಿಕ್ಕಿಲ್ಲ, set
set
off
off.
ಕೇಳಿರ್ಬೇಕು.
Number 4.
But here the,
Whether defendant is entitled for counter claim as paid for. ಇಲ್ಲ ಬಹುಶಃ set off ಕೇಳಿರ್ಬೇಕಲ್ಲ. ಇಲ್ಲಾಂದ್ರೆ ಇಲ್ಲಿ counter claim is rejected or granted ಏನು ಬರಬೇಕಿತ್ತಲ್ಲ. Now we are trying for a settlement.
no, yeah, they have offered last date, it is recorded in the order sheet, last hearing date. And I have communicated to the appellants also, so for the negotiation. So because we need to pay the court fee, any of 2 weeks kindly may given, meanwhile, I'll just, I communicated to them already. So I will just get back for the settlement. If it is not, we'll pay the court fee.
Yes, you have given the offer for settlement.
Yes, please.
Yes, my
The
lord. Yes,
respondent also
I have
offer.
given.
I
I've given
communicated to
the
them.
offer before the trial court itself, my lord, execution court. And they have not got back to us in any form. And on the previous date of hearing, before the Honorable High Court,
I communicated, my lord. So the thing is, I'll have to get back for the,
This one is private person, the other one is a partnership or a?
so
it's a supply of this pan, you know, the company.
In Parag. Stage Whitefield. Defendants appeal. So plaintiff has become generous.
yes, my lord, it's no matter of contesting in this.
But-
The reason I've given.
Learned counsel for the appellant submits that he has communicated.
Yes,
that
I
this-
communicated to the appellant.
ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ ಅದೇ I will, because as per their request I communicated, so 2 weeks may kindly be given.
Despite
If
you
they not
communicate-
come also, what is the procedure according to law, they will have to pay.
Correct, ಒಂದು ವಾರ. This is
But
outside to
this is going for a very long time. From a very long time, the same submission is.
See,
being-
Alla,
even
very long
you
time,
can-
if it is not ready, then I will take 1 week's
Correct,
time, I will
they
do that.
should tell, no?
Pardon?
Whether they are ready or not, they should tell.
No, they offered only last date of hearing.
And
the
that
order
means in
sheet-
execution.
Execution,
So
ಅದು
it is not-
ಹಿಂದಿನ date ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ. So this is I am requested to only 2 weeks. Meanwhile, I will
month,
just
my lord.
report that ಅಷ್ಟೇ.
Easily a month, because the previous date of hearing here itself was 9th of July.
Submits the seeks 2 weeks time to respond to the proposal given by the respondent. Compromise settlement proposal given by the respondent. 9/7/2024 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ.
ಅದೇ last
So
month.
almost 1 month is over. And why do you want some more time?
ಅಲ್ಲ, if they are not come,
There is
we'll-
interim stay, they are not withdrawn the amount.
No, my lord, my submission, if they are not come, next date of it, we'll pay the court fee payment, we'll go with the matter.
As a final charge, please down.
2 weeks. 3/9.
3/9.
Please.
Seal number 4.
Grateful, my
Sharat
lord.
Kogi, Prakash M. Patil, Harish Bhandari.
For the respondent, my lord, last occasion, my lord, this honorable court directed the office to post the matter for final hearing.
Complaints of office objections raised on IA 2 of 2020.
The IA filed by the
Staff
appellant,
IA
my
copy
lord,
to be
for
filed.
stay.
And ordered.
The matter is admitted and paper book is also filed, my lord. Last occasion,
Stay they are seeking. Who is seeking stay?
We have filed a stay application, your lordship.
They are not complied the officer.
Yes, your lordship, a week's time,
First
any day to.
respondent.
I am appeal for the first respondent.
The stay application is.
They are filed by the appellant, my lord. Previously, the interim order was granted subject to,
This is the amount.
Yes, your lordship.
ಅದು subject to result of final order ಅಂತ ಆಗಿದೆ.
So office objection is on this
O-
application.
Only first IA 1 for 2.
IA 1 of 2024 is filed by the respondent.
Yes.
You appear for the respondent.
I am
No.
for appellant. your
I am appeal for the respondent to release the, my lord,
Their position, no? Right.
my lord, actually, I am appeal for the respondent. I have filed application for a release of the deposited amount.
Learned counsel, there is office objection on your
Alla,
application.
that order, my lord, last occasion, this honorable court direct,
Dismiss
that
this
may be,
application.
my lord, IA may be considered at at the time of final hearing. I will comply, my lord.
Comply the.
I will
office
comply, my
objections.
lord. Within a week, I will comply.
Request finally, 1 week time is granted to file, comply the office objection on IA 1 of 2024 failing which the said application shall stand dismissed. IA 2 of 2024 ಈಗ appeal is filed in the year 2019, now you come up with a stay application.
No, it was, my lord, the previously interim order was granted subject to deposit of the decretal amount. They have deposited. But my lord, if they have not filed the paper book within 4 weeks, the interim order automatically vacated. Therefore, it is vacated. Again, they have filed one more application for stay.
Now whether they have filed paper books.
Yes,
Well,
your
yes,
lordship.
my lord.
We have filed.
ಅದಕ್ಕೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಗೆ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಆಗಿದೆ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಗೆ ಹಾಕಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ.
No, none appears for the appellant ಅಂತ ಆಗಿದೆ.
ಅಲ್ಲ, ರೆಸ್ಪಾಂಡೆಂಟ್ ನಾನು ಅಪಿಯರ್ ಆಗಿದ್ದೆ ಸರ್.
None
10/6 ಗೆ
ಮಾಡಿದ್ದಾರೆ.
10/6 kindly see, my lord, 10/6/2024.
Agree, no, that there was an interim order, they have complied now the
Oh.
office objection.
Yes, your.
It may be
It is
posted
submit-
for final hearing.
That interim order, conditional interim order.
my
was-
lord, one
stay of-
submission.
Was granted. With a direction to file the paper books. It is further submitted that since the paper books were not filed, the interim stay automatically was vacated. Since now the paper books are filed. ಯಾವತ್ತಾಗಿತ್ತು interim order? Subject to, this is on 26/2023.
Yes, ma'am.
The interim order granted earlier, interim stay granted earlier is extended till further order.
My lord,
Now,
once,
Final hearing list down, all right.
any date may be
Any
fixed, my
date.
lord, in this month, my lord, because
4/9.
only suit for recovery, my lord.
4/9. This month ಬೇಡ.
ಯಾವ್ದು? 4/9.
4/9.
ಮಾತ್ರ.
Seal number
Great.
5. SV Prakash.
Withdrawal of appeal filed by the appellant. Furnishing of the section.
Memo for withdrawal.
Withdraw the appeal,
Yes, madam.
appeal is by whom?
But because the appellant and respondents have been
Defendant,
amicably settled.
suit was for?
Suit for declaration, cancellation of sale deed and partition. Suit for declaration, cancellation of sale deed and the partition of their share in suitable property.
And he is related to the other respondents.
Yes, ma'am.
Uh,
I am the defendant, number one.
Considering the memo filed by the appellant's counsel for withdrawal of the appeal. Settled out of court.
Owner,
Settled out of court. The
intimation of the well-wishers and relatives.
dismissed accordingly. ಎಲ್ಲಿದೆ ಸೆಟಲ್ಡ್ ಅಂತ ಏನಾದ್ರು ಇದೆ ಹಾಕಿದಿರಾ?
ಮೆಮೊ ಫಾರ್ ವಿತ್ಡ್ರಾಯಲ್ ಹಾಕಿದೆ.
ಮೆಮೊ ಹಾಕಿದ್ರಿ ಏನೋ ಸೆಟಲ್ಮೆಂಟ್ ಇವಾಗ ಫಾರ್ ದ ರಿಫಂಡ್ ಆಫ್ ಕೋರ್ಟ್ ಫೀನಾ?
ಕೇಳಿಲ್ಲ.
ಇಲ್ಲ ಅದನ್ನು ಕೇಳಿಲ್ಲ ನೀವು.
ಅಲ್ಲ ಏನು ಕೇಳಿಲ್ಲ.
ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಹೌ ಮಚ್ ಕೋರ್ಟ್ ಫೀ ಹ್ಯಾವ್ ಪೇಡ್?
ಮಾಡ್ಬೋದು.
ವ್ಯಾಲ್ಯೂಡ್ ಅಟ್ 1,43 lakhs.
ಹೌದು.
35 2 ನಲ್ಲಿ ಮಾಡಿದ್ರಾ? ಇಲ್ಲಾಂದ್ರೆ ಕಡಿಮೆ ಕೊಟ್ಟಿರ್ತೀರಿ. Dismissed as with dismissed accordingly.
6 Srinivasan MY HS Lingraj.
Take process 2 weeks time.
R4.
R4.
That is finally just 2 weeks time. Total mood ಅಂತ ಇದೆ ಯಾರು ಮೂವ್ ಮಾಡಿದ್ರು? ಮತ್ತೆ ಪ್ರೊಸೆಸ್ ಬಿ ಕೊಡದೆ ಮೂವ್ ಮಾಡ್ತಿಲ್ಲ.
ಇಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಸೆಕೆಂಡ್ ಟೈಮ್ ಕೊಡಬೇಕು ಅಂತ ಬಂದಿದೆ.
Insufficient address. It requires finally 2 weeks time is granted to the Yes.
Seal number 7 Osmani Shakil Ahmad Vijay Kumar.
Non-compliance of office subsections.
Appear for appellant your end.
ಯಾರು ವಿಜಯ್ ಕುಮಾರ್ ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ? ಇನ್ನೊಂದೇನೋ
ಹಾಕಿಲ್ಲ ಸರ್.
ಇಲ್ಲ ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಇದೆ ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ. Other office subsection award under various heads to be stated at synopsis. Award amount to be corrected at synopsis.
Yes.
It requires 2 weeks time.
Kindly for 2 weeks time.
Apply the pending office subsection.
Seal number 8 Suyog Herle.
Process ಕೊಡಕ್ಕಿತ್ತಲ್ಲ. Connected matter is also filed by you. Sudesh Kumar Acharya. ಅವರಿಲ್ಲ. ಸುದೇಶ್ ಕುಮಾರ್ ಆಚಾರ್ ಯಾರಿದ್ದಾರೆ ಇಲ್ಲಿ? In the connected matter, Sudesh Kumar Acharya, you. The counsel has appeared for the very same respondent. Appellant's counsel is permitted to serve notice on him for the respondent in this case. Appellant's counsel is permitted to serve notice on him in this case also. His name shall be shown in the corpus to the memory. The said counsel shall file the wakalat in the registry. ಅದು 2021 ಅದ? Why after 2 years? Common judgment ಅಲ್ವಾ? Separately. List on date. You serve on his name shall be shown ಅಂತ ಹೇಳಿದ್ನಲ್ಲ.
5-9.
5.
Seal number 9 Ajitya Shetty.
For the appellant, my lord. My lord, we have complied the office objections. ನಾನು ಅವ್ರಿಗೆ ಹೇಳಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀನಿ, ಬಟ್ ನಾ ವಾಪಸ್ ಬಂದ್ಮೇಲೆ ಇನ್ನೊಂದೇ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ ರಿಗಾರ್ಡಿಂಗ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್.
Last time you have not appeared. No representation for the appellant.
ನೀವು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ ನಾನು August 2nd ಗೆ ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀನಿ.
Correctly stated. The temporary order dated 37/2024 is not complied. Therefore, appeal already stood dismissed. No further orders are required.
Seal number 10 Chetan DT.
Before the appellate counsel,
Hmm.
needful has to be done. Second set, a day's time.
ಅಲ್ಲ, ಅದು
Today,
dismiss
second set in ಹಾಕ್ಬೇಕು.
37. One
Second set index ಏನ್ ಹಾಕ್ಬೇಕಂತ.
application ಹಾಕಂತ ಹೇಳಿ. Temporary order dated 37/2024 is not complied. Hence, appeal already stood dismissed. No further orders are required. Yes.
Seal number 11 Parshuram R.
Appearing in favor of petitioner, my lord, two times appearing in favor of petitioner, two times notice serve ಮಾಡಿದೀವಿ and summons ಕೊಟ್ಟಿದ್ದೀವಿ ಅವ್ರು ರಿಸೀವ್ ಮಾಡಿ. ಹಾ ಸರ್.
Two times ಅಲ್ಲ, ಈಗ ಸೆಕೆಂಡ್ ಟೈಮ್ ಈಗ ಹೋಗ್ಬೇಕು.
ಹಾ ಮೇಡಮ್ ಅದೇ ಸುಭಿಷ್.
ಕೇಸ್ ಆಯ್ತಾ?
ಹಾ ಮೇಡಮ್ and summons ಕೊಟ್ಟಿದ್ದೀವಿ ಅವ್ರು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡು.
ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಹಾ ಮೇಡಮ್.
ಹಾಗಂತ ಬಂದಿಲ್ಲ ನಾನ್ ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF.
ಅದು ನೋಟಿಸ್ ಪ್ಲಸ್ and summons ಎರಡು ಅನೌನ್ಸ್ ಮಾಡಿ. 10th.
ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಕೊಡ್ತಾರೆ, ಅವರಷ್ಟೇ ಹೇಗೆ ಕೊಡ್ತಾರೆ? ಅಂಡ್ ವಿ ಡು ನಾಟ್ ಆರ್ಡರ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್.
ಇಲ್ಲ and summons ಆರ್ಡರ್ ಆಗಿತ್ತು ಮೇಡಮ್ ಸರ್ವ್ ಮಾಡಿದ್ವಿ.
ಎಲ್ಲಿದೆ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್?
10th ಜುಲೈಗೆ ಆಗಿದೆ. ಸಾರಿ ಒಂದ್ ಸೆಕೆಂಡ್ ಸರ್. 10th ಏಪ್ರಿಲ್ಗೆ ಅನೌನ್ಸ್ ಆಗಿತ್ತು ಮೇಡಮ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್.
ಅದು 10/4 ವಿಲ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ ಟು ರಿಪೀಟ್ ಇಶ್ಯೂಯನ್ಸ್ ನೋಟಿಸ್. ಬಟ್ ಬೋತ್ ಎರಡು ಆರ್ಡರ್ ಆಗಿದೆ, ಇದು ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು ಕೋರ್ಟ್ ಥ್ರೂ ಮಾಡೋದಕ್ಕೆ.
ಸಫಿಷಿಯಂಟ್ ಮ್ಯಾಮ್.
That request to which time is granted to the report. Yes.
Seal number 12, Venkatesh Somreddy, Dinesh Kumar, Rao K.
Very for responsibility. EC as per the.
My lordship,
Oh,
matter
yeah.
has been settled.
ಹಾ ಈಗ
ನಿನ್ನೆ ಮದುವೆ ಆಯ್ತು.
ಅಲ್ಲ ಇವಾಗ ಏನ್ ರಿಪೋರ್ಟ್ ಮಾಡ್ತೀರಿ?
My lordship, they are supposed to withdraw the petition. Stay ಕೂಡ ವೇಕೆಟ್ ಮಾಡಿದೀರಾ?
ಕರೆಕ್ಟ್, ಅವ್ರೇನು ವಿತ್ಡ್ರಾ ಮಾಡ್ತಾರೆ ಇವತ್ತು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. Let him come, then why should we keep it on file?
Will,
Inform ಮಾಡಿ ಅವ್ರಿಗೆ.
please, my lordship. Pass on.
Passed over. Seal number 13, Ananda K. B. Ajit.
Appear for the appellant. The office is right there, but my lord, the appeal is not maintainable. My lord, I filed a detailed memo.
Now what is the appeal? Appeal is under which provision?
Appeal under section 47 of the Guardians and Wards Act. Not what happened, my lord.
Trial court ಅಲ್ಲಿ it was section 10 of the Guardians.
Actually, trial court is though they have to file a petition under section 7 of the Act. Get section 10 is, there is no provision to file an application.
Act ನೋಡಲ್ಲ, Guardians and Wards Act.
10, section 10 is only a format in which they have to file.
No,
Section,
Section 7 appeal
Se-
lies.
if it is order passed under section 7, the appeal lies under section 47. The trial court have a power only under section 7 only.
Just wait, see. Because we didn't have the. It was for appointment of guardian, alva?
Please, madam.
Declaration. Power of the court to make order and the guardian should do that. Appeal lies under section 47.
47.
Yes, appeal lies. Okay. What is section 10? You said they have filed.
Section 10 only the format in which how the application is filed.
What it should contain and.
ಹೌದು. ಯಾವ್ಯಾವ ಏನೇನ್ ಇರ್ಬೇಕು ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಫಾರ್ಮ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್ಸ್.
19 ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಅವರು ಫಸ್ಟ್?
Office objection ಏನು?
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅದೇನೆ ಸುಮ್ಮನೆ ಸೆಕ್ಷನ್ 10 ಕೆಳಗಡೆ ಆರ್ಡರ್ ಆದ್ರೆ ಸೆಕ್ಷನ್ 47
ಎಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ ಅವ್ರ ಆಫೀಸರ್.
ಅವ್ರು ಏನ್ ಹೇಳಲ್ಲ.
Maintainable against the order passed before the additional senior civil judge. What the dated date?
even my lord, the relief is claimed.
Filed under section 10 of the GNL.
ಹೌದು.
In view of section 47. You have filed, you have made your written submission for that.
Yes, I did submitted my detailed memo. Please.
Yes, sir. You appear for the.
I appear for respondent number 1.
Yes, maintain.
ಅವರೇ ಕೇವೇಟ್ ಕೂಡ MFA ಅಂತ ಅವರೇ ಕೇವೇಟ್ ಹಾಕಿದೆ.
No, my submission is, my lord, they ought to have filed petition under section 7. They have filed it under section 10. One amendment application would have sufficed to rectify that error they have not made. The judgment is passed.
After now, he cannot correct it, no?
Please,
Because it was
no, I
filed.
leave it to this court.
ಅದು official places ಅಲ್ಲಿ ಎಲ್ಲ ಹಾಕಿರ್ತಾರೆ. Accepting the submission of the Appellant's Council in the memo dated 24/7/2024, office objections overruled. Yes, ಮತ್ತೇನೇನು you have filed a memo. ಇದು ಒಂದು ಸ್ವಲ್ಪ it's a strange case.
Please, ma'am.
Yes, at office objection. Interim stay ಕೇಳಿದ್ದೀರಾ?
Please, madam. Because there is a direction to hand over the custody of the child to the second respondent,
What do you say?
First respond.
first respondent.
No, I am the biological father, the natural guardian as per section 6.
Correct. When your wife died, this mother of the child,
At the time of the
ಒಂದ್ ನಿಮಿಷ ತಡಿ, ಯಾರು ಹೇಳಿ?
My lord, at the time of delivery,
ಅಲ್ಲಿ ಯಾವ ಇಯರ್ ಅಲ್ಲಿ? ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಹೇಳ್ದಂಗಿದೆ.
ಹೇಳಿದ್ದೀನಿ sir.
ಯಾವತ್ತದು? When she died?
7/6/2014.
7/6/2014.
14.
So now for 10 years child is in their custody.
no,
You said your biological father. ಅಲ್ಲಿ
lords, now the case is,
visitation right ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ರಾ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Interim measurement
No,
interim
there is no
measure ಅಲ್ಲಿ
visitation
ಕೊಟ್ಟಿದ್ರು,
rights.
but ಅದನ್ನ ಅವ್ರು exercise ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ.
ಇಲ್ಲಿ ಏನಾಗಿದೆ my lords, when the child was called to the court, when he was told in the open court about what does he feel that he should go with his father and with whom he is staying, the minor ward. He says that he is not staying with the appellant. This is a strange case, my lord. He's staying with someone,
Daughter-in-law, another daughter-in-law.
Daughter-in-law.
daughter-in-law. Now he says they are my
She is
father
the
and
She is, maybe daughter-in-law is staying with her. in
Yes,
Contempt.
same, joint family. They are done.
So she is.
Why the child has say the name of the daughter-in-law? Because she is only beginning in the ಆ ಮಗುಗೆ ಎದೆ ಹಾಲು ಕೊಡ್ಸುತ್ತೆ in the beginning in the she is only taking care of that child.
Okay.
Therefore the
But
child,
she is interested.
please ma'am.
Daughter-in-law, she is interested.
Please.
But she,
And moreover in the
grandmother is a de jure guardian. De facto is. You have mentioned that child expressed its view that it doesn't wish to go to.
ಹೌದು ಅದನ್ನ extract ಕೂಡ ಮಾಡಿದ್ದಾರೆ. Kindly see the page number 41.
Second wife and she also.
Left and the
my-
third
my-
wife is.
my lords, this honorable court in many occasions,
Right.
though there is
So
a,
the matter needs to be heard, we'll grant the interim stay.
no, my lords, it goes against my, because I am the biological father, I am ready to
Right,
take
you
care.
are the biological father, but for this 10 years, child was in their custody. He says even if visitation rights were given, you have not exercised that.
No, my lords, I
Matter
often
is
used to
different.
visit my child. In fact, I had confronted the photographs to the appellant during the cross examination, and she admits that I used to take care, I used to visit. Same has been extracted in this.
Visitation rights ಬೇಕಂದ್ರೆ ಮಾಡ್ಕೊಳ್ತೀವಿ. It needs to be heard.
It needs to,
ಮಾಡ್ಬೇಕಾಗುತ್ತೆ records ತರಿಸಿ ನಾವು we have to see the welfare of the child.
ಮಗುನೇ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದು ಹೇಳುತ್ತೆ, ತಂದೆ ಜೊತೆ ಹೋಗಲ್ಲ.
no, he's studying fourth.
Sir, what is the respondent doing?
No, he's running a business man.
Business.
He's financially capable to look after.
Financial capacity is not the sole criteria.
Please.
You had the grandparents.
Oh, yeah.
And
But
the
my lords, this is a
kids
case where father
But
is.
grandparents, generally they take care of the children. ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ದಿವಸ ಹಿಯರಿಂಗ್ ಆಗೋವರೆಗೂ ಅವ್ರ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇರುತ್ತೆ.
This is a
ಸ್ಕೂಲ್ಗೂ
case
ಹೋಗ್ತಾ
where
ಇದೆ ಈಗ.
Produce the child also on the next day.
ಅಲ್ಲ ಸ್ಕೂಲ್ಗೂ ಹೋಗ್ತಿದೆ ಮಗು ಇವಾಗ. ಅಲ್ಲಿ ಮಂಡ್ಯ ಮತ್ತು ಕೆರ್ಗೋಡೆಲ್ಲಿ ಹೋಗ್ತಾ ಇದೆ ಸರ್.
All parties here. Interim stay of the interim order. Till detail ತಗೊಳ್ಳಿ. The ward is for about 10 years in the custody of the appellant. And it is child aged 10 years. Yes. The schooling of the child is also being his schooling of the child is also in appellant's village alla Kerala.
Kerala. Nearby the appellant village. Appellant village is the Bidrugote, is nearby Kerala.
Stay as paid for interim stay as paid. Therefore, interim stay of the execution of the interim order till further orders. I have now 2024 is disposed of accordingly. ಏನು ಯಾವತ್ತು ಪ್ರೆಸೆಂಟ್ ಇರ್ತೀರಾ? Do you keep the parties present?
Please, ready. My lords,
Or interaction?
on submission, I don't know, I might ask this. My lords, if there is this visitation rights for the father to some extent so that he
Next
can.
time ಮಗುನ ಕರೆಸಿ ಇಬ್ಬರ ಹತ್ರನೂ
Please,
ಮಾತಾಡೋಣ.
Please, date may be fixed.
ಯಾವ ಕ್ಲಾಸ್ ಫೋರ್ತ್ ಇರ್ಬೇಕು?
ಈಗ fifth standard.
ಯಾವ್ದಾರ ಒಂದು ಫ್ರೈಡೆ ಅಥವಾ ಹೀಗೆ
Please,
ಇನ್ನ ಹಾಲಿಡೇಸ್ ಅಂದ್ರೆ ಈಗ ಸೆಪ್ಟೆಂಬರ್ ನಲ್ಲಿ ಯಾವ್ದು ಬರೋದಿಲ್ಲ, ಸಮ್ಮರ್ ವೆಕೇಶನ್ ಬರೋದು. ಬೋತ್ ಪಾರ್ಟಿ ಶಾಲ್ ಬಿ ಪ್ರೆಸೆಂಟ್ ವಿತ್ ಅವಾರ್ಡ್ ಆನ್ ಡೇಟ್ ಹೇಳಿ ಯಾವ್ದಾದ್ರು
5/9.
ಫ್ರೈಡೆ ಬರೋ
ಇಲ್ಲ, ಅದು Thursday, next in Friday.
13
Grateful.
9 at 1:30 PM. 1:30 ಕರೆಸಿ.
oh, please,
This can
39.
oh, please.
Hearing on IA, seal number 14. Nikit Bala, Shalini John.
I appear for the respondent, my lord.
Filed an IA, the respondent number 1 is substituted by virtue of a merger.
IA 1 of 2021 has been filed by me, my lord. Seeking,
Now the merged company itself has come forward.
yes,
For
my lord.
substitution.
Yes, my lord.
This SKM Investments is merged with
HCL Corporation, my lord.
correct. I mean, are you disputing that position?
We will take necessary steps to carry out the amendment.
You have to amend. IA number?
IA number 1 of 2021, my lord.
It is pending since 2021. Now, why you know?
On the last occasion, my lord, there was, they wanted to file their objections to the said application.
These applications. So last time,
That may be allowed.
as requested by appellant's counsel as a final stance on the. Shri Vikram Hilpal, direct senior counsel. Hearing for advocate on record for the appellant's service. Concedes for allowing IA 1 of 2021. That is for substitution of the first respondent. Then we have produced the resolution of the company, and what is that?
The resolution is the authorized, for the authorized signatory, my lords. The NCLT order is at annexure R2, page 11, my lord.
There is no page initiation here, it seems. ನಿಮ್ದಕ್ಕಷ್ಟೇ ಹಾಕೊಂಡಿದ್ದೀರಾ R2? Yeah, page initiated only your record.
I'm so sorry, my lords. I'll do the. The last page is the operative portion.
Transfer and transferee companies. Okay. Last page of
R2, my lord.
petitioner company shall within 30 days of the date of receipt of file. In so many companies are.
Yes, my lords.
amalgamated.
All were subsidiary companies, my lords. Joint.
SKN,
SKN is number 1, my lord.
number 3, number.
Number
three.
3.
Number 3 is there. What is this company? Your company, HCL, huh?
Now it is HCL Corporation.
HCL Corporation. As per the, the records produced by the proposed respondent show that respondent number 1 company is amalgamation, transfer.
Amalgamation, my lords.
No, transfer. Respondent number 1 company is transferred to the applicant. Merged with that. Therefore, the applicant. Request of the applicant to substitute for respondent number 1 on record is granted. Appellant's counsel shall amend the constitution of the appeal memo and furnish the copies of the amended appeal memo. Accordingly, IA number
1 of 2020.
is disposed of accordingly. What are IA number 3 of 2019? Or in
There is already an order by this honorable court on 25/3/2019.
Pair them together.
Yes, my lords.
Non-furnishing of bank guarantee from any other banks. What is this?
The interim order asked that directed the appellants to.
Guarantee the required to be furnished, for which the interim order was passed. And told me that the execution proceedings are going on. The appellant, for some reason, is not furnished bank guarantee.
So,
Interim order by one.
so now these 2 applications then need to be heard along with the main matter. 3 of 2019.
Main matter, yes.
Sir, 3 of 2019.
IA 3 of 2019, my lords, is for a direction. Yes.
Artifact produced. Please to direct the response 192 to deposit 79,72,598. Why the response should deposit that? They have succeeded. And what is the next IA? IA 1 of
I think
2000.
matter may have to be destroyed, these IAs, because of so much influx of time.
No, this is a section 10(2) on the Commercial Courts Act. What is this?
The second application is, my lords, are seeking.
Charges are filed by the appellants.
Yes, my lords.
Please to treat the above matter as commercial dispute. Commercial appeal and accordingly transfer the above appeal to the commercial division court.
What happened initially, Doctor, I also teach at the last day, I think what happened initially, subject to correction. Before the Commercial Courts Act came into was possibly these appeals were filed. So I think the objection was raised saying that now by virtue of the Commercial Court Division being set up, I'm sorry. Please.
No objection was raised, my lords.
No, I think Mr. Naganand, in the order sheet, Mr. Naganand is raised an objection. Can you see the very first
About
order?
the appeal, about the maintenance of the appeal.
Appeal itself.
Not about this.
I'll just get the instruction.
These appeals, whether these application can be disposed of. To listing the matter, see, one is to transfer to the commercial division.
Yes,
The other one is to deposit for direction for them to deposit.
No,
the-
that may not be relevant. At this table, we won't press it now.
Shri Vikram Hindwal, another senior counsel submits that IA 3 of 2019,
Yes, my
IA
lords.
3 of 2019 is not pressed, therefore the said application is disposed of accordingly. Now we want to take instruction in IA number 1 of 2020.
I'll just get some instruction.
The exam.
I'm sorry, I wasn't aware that was pending. I'll have it sometime next week. I'll just get instructions.
As it he further produces. Shri Vikram Hindwal, another senior counsel, further seeks time to clarify an IA number 1 of 2020 ಅಂತ ಹೇಳ್ಬೇಕು.
Great.
Otherwise 2016 ಇದ್ರಲ್ಲೇ ಹೋಗ್ತಾ ಇರುತ್ತಲ್ಲ ಇದು.
ನನಗೂ ಗೊತ್ತಿಲ್ಲ.
Why that should be?
ಹಾಕಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. I was in the impression that final hearing over. I'll get.
Are you pressing that contention if at all you had raised?
No, we have not raised that contention at all.
We can record their submission and dispose of that application also, then at least matter can be heard.
Very well, very well.
Right, what? do you
Yes, my lords.
Absolutely.
ಅದು ಬೇಡ, last IA number 3 ಬೇಡ. Learner counsel for the response submits that he is not pressing the contention. You have taken that such contention?
No, my lords.
He had not taken any contention regarding the jurisdiction of this court or the applicability of Commercial Courts Act. Having regard to the said submission, senior counsel submits that IA number 1 of Eshtadu
2020, my lords.
may be disposed of. Therefore, IA 1 of 2020 is disposed of accordingly. Okay. Then now it admit ಆಗಿದೆ.
Admit ಆಗಿದೆ.
Final hearing. We just take out steps in the meantime. Final hearing, any date subject to your lordship.
Take out steps for what?
Amendment.
Amendment ಒಂದೇ ಮಾಡ್ಬೇಕು ನೀವು ಅಷ್ಟೇ. The appeal amendment ಹೇಳಿದಲ್ಲ, the amendment for carrying out the amendment and furnishing the amendment copy and for final hearing list on. ಮತ್ತೆ address ನೆಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ ಅವರು ಅದಕ್ಕೆ. Next, next.
22/8.
22.
May I request the week after 22nd, my lords? I have some person.
ಹಾಗೆ ಮಾಡ್ತೀಯ.
ಇದು ಅದರ first week September 29th 30th already open.
All right.
First week of September.
Grateful.
5/9.
Fine.
Much obliged.
It madam.
Number 15. Zulfikar Kumar Shakti.
List for final hearing ಅಂತಾನೆ ಮಾಡ್ಬೇಕು.
Please, your. For the appellant, but there is an application for condemnation of delay. There's a delay of 4 days.
Vivekananda.
Maybe allowed.
4 days. Chief Engineer, Health System Development. Accepting. Reasons assigned for delay of 4 days in filing the appeal is condoned in it. I one of the secretaries disposed of accordingly. Yes.
Lord, there is one more IA for stay, but that can be argued at the stage of admission itself. I don't think I would want to insist on that stay application right now.
ಅಲ್ಲ ನಾವು admission ಮಾಡಿದ್ರೆ ಆದ್ಮೇಲೆ ಅದನ್ನ
Although, because it may become.
whether award is reversed or confirmed.
No, my lord, this is actually a second round. Initially, what happened, an award was passed in 2002.
Once it was remanded.
Yes. So a portion of the award was set aside and it was remanded for giving
Right.
certain.
We didn't have the benefit of that award. Here you are not produced.
Yes, my lord, by inadvertently, the old award is filed. I will correct that. I will correct that. What has happened is the earlier award itself is again refiled. I will correct that because 2010,
Both awards you have to submit. No, for
no,
award,
one award is filed, but that is the earlier one.
that is.
No, the supplementary award is.
The supplemental award is not produced.
You have filed.
Yes, but 2010 is not produced.
No. What was challenged in the AS was
The subsequent award,
award dated anotherly out. Ordinarily 33/2002 ಅಂತಾನೆ
that
ಬರ್ತದೆ.
is that's a mistake. I will correct that. So 2002, there was an award. I challenged that in a 34 proceedings. The award was confirmed. Thereafter, I filed a miscellaneous before this honorable court. And this honorable court partly set aside the award with respect to one claim. And with respect to 3 other claims, this honorable court was pleased to remand the matter for giving reasons, supplemental reasons. Based on that, 2010 supplemental reasons were given and a fresh award was passed.
Even that order copy is not here.
No, yes, that 2010 is not produced.
That award is not there. The order of this court, that is.
I will produce that. I will produce that.
Then we can have it some.
Yes, some other.
Clerk also for the applicant seeks time to produce. The 2010 trial court has arbitration court refers to award dated 33/2002.
Yes,
not
that's a mistake.
2010.
That's a mistake.
Operative portion ಅಲ್ಲಿ 9/11/2010 ಅಂತ
Yes.
The award dated 9/11/2010 and order of this court in MFA number. Copy, sir.
2537
of 2004.
MFA number 25
37 of 2004,
list on
67 to 2010.
13.
Oh,
39.
okay.
Cell number 16 adjourned, cell number 17, Nagaraja K, BP Swami.
17 minute IFA for the appellant KSRTC.
17.
I was required to amend the cost title.
Permission to withdraw the deposit on non-amendment of cost
I
title.
permitted to amend the cost title.
ಅವರಲ್ವಾ ಇದ್ರಲ್ಲಿ ನಾಗರಾಜ್ ಯಾರು?
I'm not.
Minute IFA for the appellant KSRTC. May I requested minute him only minute to amend the cost title. The reason, minute, what is the problem is not R1 dead during the pendency of the appeal. R2 to R4 are the LRs of the deceased R1. That's all minute. It is already on record. I have
But
also
you have to make an
filed.
endorsement to that effect in the appeal.
Please, madam, I am permitted to amend the cost title, the cross objection.
ನಿಮ್ಮದ್ರಲ್ಲೂ ಮಾಡಿ.
Control none, madam.
In your case, you were already permitted, you had done it.
Please, madam, please. ಆಗಿದೆ, order ಆಗಿದೆ.
In both the cases, madam, I requested my friend.
ಅಲ್ಲ ಬಟ್ ಅದ್ರಲ್ಲಿ ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಡಿ.
ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಂತ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
ಅಲ್ಲ ರೀ ಅಪೀಲ್ ಅಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ ಅದನ್ನ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ.
ಆಯ್ತು, ತೋರಿಸಿದೆ. ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್
ಅದು ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಂತ ಹೇಳಿ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಇದೆ, ನನ್ನ ಅಪೀಲ್ ನಲ್ಲೂ ಇದೆ.
17.1 ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್.
Correct. ಮತ್ತೆ why did you move it without doing the needful?
Permitted to withdraw the amount,
Correct. ಅವರು ಮಾಡೋದಿಲ್ಲ, ನೀವು ಮಾಡೋದಿಲ್ಲ.
permitted correct.
You are only the legal representative.
Please, madam.
Not the claimant.
I am the claimant, madam. I am the claimant. Claimant respondent.
ಯಾರು ತೀರೋಗಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ ಅಂತ ಹೇಳಿ.
Owner of the vehicle.
R1.
R1. That is driver of.
My appeal.
ಅಲ್ಲ ಇಲ್ಲಿ ನೋಡಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ವೈಡ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ 19/6/2024. 19/6/2024 ಏನು
ರಮೇಶ್
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 is ರಮೇಶ್.
Driver.
ಅಲ್ಲ ರೀ ರಮೇಶ್ ಅನ್ನೋರು ಡ್ರೈವರ್.
ರಮೇಶ್ ಅನ್ನೋರು
ಬೇರೆ ಯಾರು
ಫಾದರ್ ಆಫ್ ದ ಡಿಸೀಸ್.
ತಪ್ಪಾಗಿದೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ ನೋಡಿ. ಹೇಳ್ತಾರೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಅಲ್ಲಿ
ನನ್ ಕೇಸಲ್ಲಿ R5 is the driver, he has been dispensed.
Learner Council Shri Jagdish G. Kumbar for Learner Council for response to and so file memo praying to treat. ನಿಮ್ಮ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಕ್ರಾಸ್ ಬರ್ಕೊಳ್ಳಿ ಇದನ್ನ ಇನ್ನೊಂದ್ಸರಿ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬಿಡೋಣ ಅದನ್ನ. ಕ್ಲೈಮೆಂಟ್ ನಂಬರ್ 1 is respondent number 1 ಅಲ್ವಾ? 1 in MFA number 797 of 2019 and cross objector number 1 ಅದರಲ್ಲಿ.
ಹೌದು ಸರ್.
Cross objection
51 of 19. 51 of 19.
In cross objection number 51 of
19, 2009.
and cross objector number 1 in cross objection number 51 of 2019, he reportedly died and survived by the other claimants.
Yes. Go to.
The counsel for the appellant and cross objectors shall amend the cause title accordingly in appeal and cross objections and furnish the amended copy of the appeal list on. ಸುಮ್ನೆ ಲಿಸ್ಟ್ ಮಾಡೋದು ಇದು ಮಾಡೋದು ಮತ್ತೆ ಮಾಡ್ಕೊಳ್ಬೇಕು ಅಂದ್ರೆ
ಮಾಡ್ತೀನಿ ಸರ್.
ನನ್ನದ್ರಲ್ಲೂ ಅವ್ರಿಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ ಸುಮ್ಮನೆ.
ನಿಮ್ಮದ್ರಲ್ಲಿ ನೀವು ಮಾಡ್ಬೇಕು.
ಇಲ್ಲ ಅವ್ರಿಗೆ ಹೇಳಿದೀನಿ ಸ್ವಲ್ಪ ಹಾಸ್ಪಿಟಲ್ ಇದಿದೆ ಅದಕ್ಕೋಸ್ಕರ.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಅವ್ರು ಮಾಡ್ಬೋದಾ ನಿಮ್ಮದ್ರಲ್ಲೂ ಬಟ್ ಯು ಹ್ಯಾವ್ ಟು
ಮಾಡ್ಲಿ
ಸೈನ್.
ಆಯ್ತು ಮಾಡ್ಲಿ ಅವ್ರು ಯಾರ ಹತ್ರ ಸೈನ್
ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್
ಐ ರಿಕ್ವೆಸ್ಟೆಡ್ ಹಿಮ್.
ಲಿಸ್ಟ್ ಆನ್ 59
Please.
Please.
Bill number 18, G.A. Shrikantegowda, P.N. Rajeshwara.
For the respondent number 5, my lord. My lord, the application filed by the appellants is not required because, my lord, here, your lordship may kindly peruse my synopsis, my lord. I may be permitted to.
I filed the application,
Alla,
bring
one
the
minute.
legal aids of R2.
Not required, my lord.
R2.
Not required. I will demonstrate, my lord. I will demonstrate, my lord. Alla,
R2 was a party.
Only
the
to,
court,
my lord.
and he filed.
ಅವ್ರು ಮುಗಿಸ್ಲಿ ಮಿಸ್ಟರ್ ಕೌನ್ಸಿಲ್. ಅವ್ರು ಮುಗಿಸಿದ ಮೇಲೆ these are they his applications no.
Please.
Have you filed objections to those applications?
My lord.
File ಮಾಡಿಲ್ಲ.
ಏನಾಯ್ತು ನಿಮ್ಗೆ? why do you want R2?
My lord, I may be permitted to file this, synopsis. I will establish. Alla, ಇದ್ರಲ್ಲಿ ಹೇಳ್ಬೇಕು ಸ್ವಾಮಿ.
R2
Simha.
My lord.
He was defendant number 2.
He was a party to the proceedings and he filed written statement before the trial court and he contested the case. For that reason, I have made him as a party to the proceedings. So far as the other respondents who are not contested, I myself made a memo, submission before this honorable court to for dispensation of notice to all of them. Now only R2 and R5 are the contested persons. Now R2 it is my risk. I have to take the risk of the deleting the parties. They cannot say that I have to retain not to continue R2 as a party to the proceeding. Because it is my suit.
Who are the LRs of? They're not on record.
Yes, wife and children's wanted to come.
My lord, my respectful submission, my lord.
ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ತಿರ್ತೀರಿ ಅಂದ್ರೆ ಯಾರ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದ್ದವರೇ ಇದಾರ ಅಂತ. ತೇಜಾವತಿ, ಭರತ್ and ಅಮೃತ್. They are not on record, no?
ಇಲ್ಲ ಅವ್ರ ರೆಕಾರ್ಡ್ ಮೇಲೆ ತರಬೇಕು. ಅವ್ರ ರೆಕಾರ್ಡ್ ಮೇಲೆ ತರಬೇಕು.
ನಿಮ್ದೇನು why are you opposing?
Your lordship may kindly peruse page number 3, my lord, in the synopsis.
ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಡಿ.
Synopsis.
2 minutes.
Page number 3.
My lord, item number, page number 377, my lord. This MB Nagendra Simha, who is now my learned friend seeking for. He has sold the property in favor of M.R. Manikyam in 16/3/1980. In turn, Manikyam sold the property one Mr. Janardhan in 27/3/1987. From Janardhan, the respondent number 5 has purchased the property. Thereafter, my lord, the relinquishment deed has been executed by MB, the appellant, to the governor of the government of Karnataka
Janardhan is appellant's husband. ಏನು ಹೇಳಿದ್ರು?
ಅಲ್ಲ, ಜನಾರ್ದನ್ my vendor, my lord.
You are vendor.
My vendor. His vendor is one Manikyam, my lord.
He's
ಹೌದು.
vendor.
ಅಲ್ಲ ಮಾಣಿಕ್ಯ ಅಲ್ಲಲ್ಲ, ನಮ್ಮ ವೆಂಡರು ಜನಾರ್ದನ್, ಜನಾರ್ದನ್ ವೆಂಡರು ಮಾಣಿಕ್ಯಂ ವೆಂಡರು MB ನರಸಿಂಹ. ನಾವು ಅವ್ರನ್ನ ಪಾರ್ಟಿ ತರಬೇಕು ಅಂತ ಹೋಗ್ತಾ ಇದ್ದಾರೆ. ನಾವು after 25 years he has slept over, the my lord appellant has slept over, and now he wants to bring him on record. Now he is already 3 transactions has taken place. We are in the possession of the property.
When he died,
My lord, he died on
in their application they have stated.
He died on 19/12/2020 after filing of this petition.
4 ವರ್ಷ ಆಗಿದೆ.
Filing this appeal.
4 ವರ್ಷ ಆಗಿದೆ ಸುಮ್ಮನೆ. ಅದು ನಮ್ಮ ವೆಂಡರ್.
Correct.
Plaintiff arises out of suit for declaration of possession of the suit was dismissed. Plaintiffs have sought for temporary injunction. This court, by order dated 11/5/20, has granted an order of status quo. Learned advocate for defendant respondent number 5 submits that respondent number 5 is in possession of the property. Hence, he prays that status quo order may be modified and IO for injunction may be dismissed. To be a pointed query as to whether respondent number 5 would abide by the order of the court that he would not claim equities in respect of any construction which he may put up and would demolish the same in case he loses the matter. He says time to complete instruction granted, my lord. Interim order granted earlier is extended till next date of hearing. Injunction status quo order has been granted, not injunction order, my lord.
Status quo
my lord, kindly fix the date of hearing because after that.
Sir, ಒಬ್ರು ಪಾರ್ಟಿ ತೀರೋದ್ಮೇಲೆ ಅವ್ರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ರೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಯು ಆರ್ ಕಮಿಂಗ್ ಇನ್ ದ ವೇ ಆಫ್ ಕೋರ್ಟ್.
ಇಲ್ಲ ನಾನು ಅದಕ್ಕೆ ಬರ್ತಾ ಇಲ್ಲ ಸುಮ್ಮನೆ ಲೆಟರ್
ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿ.
ಅಲ್ಲ ರೆಕಾರ್ಡ್ ಬರ್ಲಿ, ಬಟ್ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಲಾಟ್ ಆಫ್ ಡೆವಲಪ್ಮೆಂಟ್ಸ್ ಹ್ಯಾಸ್ ಬೀನ್ ಟೇಕನ್ ಪ್ಲೇಸ್. 4 ವರ್ಷದಿಂದ ಸುಮ್ಮನೆ ಇದ್ದಾರೆ ಅಂತ ನಾನು ಹೇಳ್ತೇನೆ.
ಅಲ್ಲ ನೀವು ಅವಾಗ these applications are filed in 2024. Issue notice of IA 1 to 3 of 2023. Learn counsel for the respondent. So you are for only respondent number 5, na?
Please, Mal.
Learn counsel for respondent number 5. 6 dismissal of IA 1 to 3 of 24 in limine on the ground that defendant number 2 had lost his interest in the property long back. However, the records show that defendant/respondent number 2 had contested the suit before the trial court by filing the written statement. An issue was also framed with regard casting the liability burden on him to prove that he was a bona fide purchaser. Under the circumstances, his LRs need to be notified of the proceedings. Therefore, issue notice of IA 1 to 3 of 2024 to the proposed LRs of respondent number 2, deceased respondent number 2, list down extension of interim order there.
Yes.
ಅಲ್ಲಿ ಮತ್ತೆ ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ಮಾಡಿದಾರಲ್ಲ.
ಅದೇ ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ನೇ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಯ್ತು ತಾವು ಲಾಸ್ಟ್ ಮೇ ಕೈಂಡ್ಲಿ ರಿಮೆಂಬರ್ ಮಿಲಟ್ only because I have not filed application and for bringing LRs that interim order was not extended, though it was brought to your lordship's kind notice on the very same day. Your lordships asked me to bring the other side, but after he could not, I could not able to trace out him. And for that reason, I filed up.
Died according to in 2020.
ಅಲ್ಲ ಅವ್ರ ಮೇಲೆ ಇಲ್ಲ ಸರ್, ಓನ್ಲಿ ಅಗೇನೆಸ್ಟ್ R5.
ಅವ್ರ ಮೇಲೆ ಮಾಡಕ್ಕೆ ಆಗೋದಿಲ್ಲ, ಇಲ್ಲಾಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಬೇಕದನ್ನ.
R5 ಮೇಲೆ ಅಷ್ಟೇ ಸರ್.
You do not file LR application.
ಅಲ್ಲ R2 ಮೇಲೆ
Correct.
R2 ಮೇಲೆ ನಾನು ಎಂಟ್ರಿ ಆರ್ಡರ್ ಆಫ್ ಇಂಜೆಕ್ಷನ್ ಏನು ಕೇಳಿಲ್ಲ. R5 ಮೇಲೆ ಮಾತ್ರ.
ಬೇರೆಯವರು ಸಫರ್ ಆಗ್ತಾರಲ್ಲ ಆರ್ಡರ್ ನ, ಬಿಕಾಸ್ ಇಟ್ ಡಿಡ್ ನಾಟ್ ಡೂ ದ ನೀಡ್ಫುಲ್ ಫಾರ್ 4 years.
Milord, I have not, Milord, Lakshmi kindly remember, kindly consider, Milord, because they are staying, Milord, a different place.
ನೋಟಿಸ್ ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. ನೋಟಿಸ್ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ರಿ.
This order is being continued from, Milord, 6/5/2023 till this time.
Status quo order granted earlier is extended till next hearing date.
Much of this.
Fine. Emergency notice process ಎಲ್ಲ ಕೊಡ್ಬೇಕು ನೀವು.
ಈಗ
Want us to
ಅಲ್ಲ,
hold
ಅವ್ರು
it now?
ಅವ್ರು
Want us to hold it or you will give on the next hearing date?
ಆಯ್ತು.
Your synopsis.
ಅಲ್ಲ ಇಲ್ಲೇ ಇರ್ಲಿ ಸ್ವಲ್ಪ ರೆಕಾರ್ಡ್ ಅಲ್ಲೇ ಇರ್ಲಿ.
ಬರ್ಕೊಳ್ಳಿ. ಮೇಲ್ ಬರ್ಕೊಳ್ಳಿ. Now counsel for respond number 5 submits his synopsis, written synopsis ಅಂತ. ಇದು ಇನ್ನೊಂದೇನು ಉಳಿದವ್ರಿಗೆ ಸರ್ವಿಸ್ ಆಗಿದೆ ಅಲ್ವಾ?
ಇಲ್ಲ ಬೇರೆ
ಅವ್ರು ನಾನು ಕ್ರಾಸ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, ನಂದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೊದಲೇ ಕೊಟ್ಟಿದ್ದೆ, ಇನ್ನೊಂದು ಕಾಪಿನೂ ಕೊಟ್ಟಿದ್ದೀನಿ. ದಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೇ ಬಿ ಓವರ್ ರೋಲ್ಡ್ ಮೈ ಲಾರ್ಡ್.
Number 19.
My lord, objection may be kindly be overruled. Copy has been served. Cross objection ಅಲ್ಲಿ.
ಅದರಲ್ಲಿ there is a delay, Milord, I filing the cross appeal.
ಅಲ್ಲ cross objection ಕೊಟ್ಟಿದ್ದೀನಿ.
Counsel for the response submits that the copies are received, therefore office objections to complaint. Okay.
Cross appeal delay ಇದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಅವರು
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಿಮ್ಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋದನ್ನ ಓವರ್ರೂಲ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Still number 19, Sunil K.
I pay for the appellant, my lord.
I pay for the respondents, my lord.
My lord, I have filed a suit for specific performance of the contract against the respondent for a consideration of rupees 24,50,000. My lord, the
Willingness prove ಆಗಿಲ್ಲ, readiness and willingness prove ಆಗಿಲ್ಲ.
readiness and willingness, my lord, they have not
It's not
disputed
proved.
no, but the readiness and they have not disputed the readiness and willingness.
Here seeking,
My lord,
what is this TI not to alienate ಅಂತ?
not to alienate the suit schedule property. Their contention is, my lord, I have obtained on fraud, on the basis of fraud. And they have taken 3 different contentions in the 3 different stages of the proceedings, different contentions.
Correct, the trial court has held that you have failed to prove readiness and willingness.
I have not disputed they have not disputed the readiness and willingness of the party.
ಹೇಳೋದು ಪ್ರಶ್ನೆ ನೀವು ಒಂದು ಹೇಳೋದು, ಈಗ ಅಡ್ಮಿಟ್ ಮಾಡಿ ಅದನ್ನ ಮಾಡೋಣ. ಆದ್ರೆ though the trial court accepted that execution of the document, your suit was your specific performance relief was rejected on the ground of readiness and willingness.
Readiness.
Paper books ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ ಆಗ್ಲೇ admit ಮಾಡಿ. Yes, you are trying to alienate the property.
My lord,
Are you trying to alienate the property? They have started.
I have filed the objections to the IA.
Correct, now this has to be decided, alva now. But third, orders and I1 of 24. By the impugned judgment and order, the trial court though held that the execution of the agreement of sale is approved, rejected the prayer for specific performance. ಅದನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಟ್ಟಿದಾರ ಎಂಟೈರ್ ಸೂಟ್. ಮತ್ತೆ ಯಾಕೆ ರಿಫಂಡ್ ಯಾಕೆ ಕೊಡ್ಸಿಲ್ಲ?
Refund has not
Refund
happened.
ಕೊಡ್ಸಿಲ್ಲ.
Please, ma'am.
Yes, agreement on holding that agreement of sale is proved, at least refund ಗೆ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ.
Sorry, madam?
Refund.
After holding that agreement, execution of the agreement of sale is proved,
Yes.
at least refund ಗೆ judgment ಡಿಗ್ರಿ ಕೊಡ್ಬೇಕಿತ್ತಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವರು.
ಆಗಿಲ್ಲ. Execution is held in the affirmative.
ಅಫರ್ಮೇಟಿವ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ, ಅದಾದ್ಮೇಲೆ ಅಟ್ ಲೀಸ್ಟ್ ರಿಫಂಡ್ ಆದ್ರೂ ಕೊಡ್ಬೇಕಲ್ಲ, ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
I don't know.
The plaintiff proves his readiness and willingness, so the defense prove that plaintiff by playing fraud ಅದನ್ನು ನೆಗೆಟಿವ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
Please, my lord, the trial court is of the consideration, my lord.
First, readiness and willingness, to test it.
Consideration is proved and the agreement is also proved.
See, there are judgments, even if they have not taken that contention, you have to prove it independently.
Please, my lord. But my lord, there are judgments, my lord, where it says the dependent.
Consider that, ಬದಲು ಇದನ್ನ ಹೇಳಿ. And that dismiss the suit in its entirety. The matter is already admitted for hearing. Under the circumstances, the property in dispute needs to be preserved till the disposal of the appeal. Therefore, the respondents are hereby restrained from alienating the associated property in any manner till disposal of this appeal. Item number 1 of the response are anybody claiming through them and the weapon. Item number 1 of 2024 is disposed of accordingly. ಅವ್ರದ್ರಲ್ಲೇನು ಇಷ್ಟು ಫೈನಲ್ ಹಿಯರಿಂಗಿಗೆ ಹೋಗ್ಬೇಕು. ಪ್ಲೀಸ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆನ್
29.
Much obliged.
Number 20.
Madam, how did it?
Temparaju, B. Pradeep.
For the appellant side.
Pradeep, 44 days delay.
Delay may be condoned, my lord.
44 days delay condoned, my lord.
Case of death.
This is accidental case. Death announcement is to be
56 years.
24.
ಏನ್ ರೀಸನ್ ಹೇಳಿದ್ದಾರೆ? illiteracy, no knowledge ಅಂತ ಹೇಳಿ. I have no knowledge of the High Court. Deponent English ನಲ್ಲಿ ಸೈನ್ ಮಾಡಿದಾರಲ್ರಿ, no knowledge ಅಂತ ಹೇಳ್ತಾರೆ. Not considering the reasons assigned to extend the delay of 44 days in filing the appeal is condoned in the interest of justice. Item number 1 of 2023 is disposed of accordingly. Yes, what is the point involved? What is the error in the order?
ಏನಿಲ್ಲ
Error ಏನು ಇಲ್ವಾ? ಹಂಗಂದ್ರೆ appeal
One
dismiss
submission,
ಮಾಡ್ತಾರೆ?
madam.
ಇಲ್ಲ ಏನೋ ಇದು ಇನ್ಎಡಿಕ್ವೇಟ್ ಕಾಂಪನ್ಸೇಷನ್ ಮಾಡಿದ್ದಾರೆ.
Correct. ಯಾಕೆ inadequate ಯಾಕಾಯ್ತು? Why you find it inadequate?
ಫಾರ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಆಫ್
Correct. What is the error? ಏನ್ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ? ಮಲ್ಟಿಪ್ಲೈಯರ್ ತಗೊಂಡಿದ್ ತಪ್ಪಾ?
ಹೌದು,
ಇನ್ಕಮ್ ತಗೊಂಡಿದ್ ತಪ್ಪಾ? ಏನದು?
ಅದು ಇನ್ಎಡಿಕ್ವೇಟ್ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ಕೊಂಡು
ಫೈಲ್ ಓದಿಲ್ಲ.
ಹೋಗಿದ್ದೆ.
ಓದಿದ್ದೀರಾ? ಹಾಗಾದ್ರೆ ನಾನು ವಾಟ್ ಗ್ರೌಂಡ್ ಯು ಹ್ಯಾವ್ ಚಾಲೆಂಜ್ ಇಟ್?
ಚಾಲೆಂಜ್ ಫಾರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್.
ಕರೆಕ್ಟ್ ರೀ. ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? You say the compensation awarded is inadequate. On what ground it is inadequate?
173 ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಇದು ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
We are very sorry. ಎಷ್ಟು ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ್ದೀರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನನಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರಿಯಾಗಿ ಏನಂತ.
ಕೇಳಿಸಲ್ವಾ? ನೀವ್ ಹೇಳಿ ನೋಡಿ, ಹತ್ರದಲ್ಲಿ ಹೋಗಿ ಕೇಳಿ ನೋಡಿ ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ಚಾಲೆಂಜ್. ಸರಿ, ಇತಿಹಾಸ ಡಿಸಾಬಿಲಿಟಿ ಇವ್ರಿ ನಿಮ್ಗಾದ್ರೆ ಗೊತ್ತಿರಿ. ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ವಿ. 16,000. ಅಲ್ಲ, ಏನ್ ಮಲ್ಟಿಪ್ಲೈಡ್ ಅಪೀಲ್ ಮೆಮೋ ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ? ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗುತ್ತಾ ಅಂತ ಕೇಳೋದಕ್ಕೆ ನಾವು ಎಲ್ಲ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡ್ತೇವೆ. ಎಲ್ಲ ಅದರ್ ಗ್ರೌಂಡ್ಸ್ ಸರ್ ಕಾನ್ಸೋರ್ಷಿಯಂ ಎಲ್ಲ ಸರಿಯಾಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಕ್ಚುಲಿ ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ಆಫ್ ಡೆಡ್ ಬಾಡಿ ಅದೊಂದು ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮತ್ತೆ ಟುವರ್ಡ್ಸ್ ದ ಲಾಸ್ ಆಫ್ ಡಿಪೆಂಡೆನ್ಸಿ. What was the age of its?
Age of 23 years, madam.
23 years. Income proof ಏನು? Actual income proof ಏನು? 15,000 ತಗೊಂಡು ಅವ್ರಿಗೆ ನೀವು ಹೇಳಿದ್ರು ಕೇಳ್ತಾ ಇಲ್ವಾ? ಏನ್ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ವಾ? Counsel for the appellant is not in a position to argue with regard to the admissibility list after 4 weeks.
Number 21.
ಇವರೇ ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಥವಾ ಬೇರೆ ಯಾರೋ ಇದ್ದಾರೆ? ಮೊದಲು ಬೇರೆ ಕೇಸಲ್ಲಿ ಬಂದ್ ಮಾಡ್ತಾರೆ ಇವ್ರು ಸಂಪ್ರಾಶನ
My lord, the head under the with the compensation, Kemparaj is my senior because the loss.
ನಿಮ್ ಸೀನಿಯರ್ ಕರೆಸಿ, ಆಮೇಲೆ ಮತ್ತೆ ನೋಡೋಣ.
The head of the loss of defendants of the 30 lakhs. ಇದ್ರ ಮೇಲೆ
ಸೀನಿಯರ್ ಬರಕ್ ಹೇಳಿ, ಆಮೇಲೆ ಹೇಳ್ತೀನಿ.
One submission, madam. We have not yet filed wakalat, madam. We sent to company for.
ಅವ್ರ ಸೀನಿಯರ್ ಬರ್ಲಿರಿ,
Please, my
ಅವ್ರಿಗೆ
lord.
ನಮಗೆ ಎಷ್ಟು ಕಷ್ಟ ಆಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳಿ ರಾಜ್ ಅವ್ರು ಬರಕ್ ಹೇಳಿ.
Number 21. Rajshekhar K.
ರಾಜಶೇಖರ್ ಕೆ ಇಲ್ಲ. No representation for the appellant.
Well, serial number 22, I appear for the appellant. Seek 2 weeks time to file my statement of objections, my lord, in this matter. My lord, there's some, the court's mic is muted, my lord.
It is
number 21.
21, are you in 21?
No, 22, my lord, I'm sorry, my lord, 22.
Dismiss ಮಾಡ್ತೀವಿ ಒಂದ್ಸರಿ ಅಂದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. No representation for the appellant. ಹಿಂದಿನ ಸರಿ ಏನೋ ಬಂದು that request finally 1 week time is granted ಅಂತ ನಾವೇ ಮಾಡಿದ್ವಿ. Appeal is dismissed for non-prosecution. Claimants file ಮಾಡಿರ್ಬೇಕು ಎಲ್ಲರ ಮೇಲೆ ಹೋದ್ರೆ. Yes.
Number 22.
I'm appearing on behalf of the respondent, my lord, in this matter, my lord.
Lord, I
My
appear
lord,
for
we
the
have filed
appellant.
an application seeking to withdraw the amount that is deposited by the petitioner, rather appellant. I'm sorry, my lord. Appellant, as per the order of this honorable court dated 8/11/2023. This honorable court was pleased to pass an order on IA number 1 of 23, my lord.
8/11.
8/11/23, my lord.
Interim stay of execution of the interim judgment will be subject to deposit of 10 lakhs.
Please, my lords.
So 410. And 20,000 is towards litigation expense.
Please, my lords. If
My
I
lord,
may
seek
invite my
2
lord's
weeks
attention to
time-
the
2
application
weeks
that I
time
have
to
filed, my
file the
lord.
statement of objections in this matter, my lord.
And a statement of objection ಆಗ್ತೀವಿ time ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
To the application, my lord.
Application.
If I may invite my lord's attention to the application once, my lord.
We asked him, child is there ಅಂತಾರೆ.
Precisely, my lord. I've even affixed documents to that effect. The elder son of the parties is studying MBBS, my lord. I've even affixed the fee structure. If I may invite my lord's attention to page number 9.
Like 80,000.
It clearly mentions that I have to remit nearly 11 lakhs per year, my lord. And it is an admitted fact that ever since the petitioner and respondent have been living separately, the appellant has not, my lord, the appellant has,
2024. Let him file whatever he wants to file.
it is with respect to withdrawal of the amount so that I can remit it.
You have filed it now 8/8/2024.
Please.
Yes. And I consider the appellant 6 time to file counter to, or ಏನ್ ಹಾಕ್ತಾರೋ ಹಾಕ್ಲಿ, we will consider it later.
Please. A date may kindly be fixed.
1/24. List on.
2 weeks time may be granted, my lord.
2 weeks we can't grant. ಯಾಕಂತ 2/9 ಆಗೇ ಬಿಡುತ್ತೆ ಅಲ್ಲಿಗೆ 2 weeks. The appellant counsel shall file the objections positively on or before next hearing date. List on. You have to file it before next hearing date, 2/9.
I'm so grateful.
Number 23, Ashok B. Patil, Vijay Kumar K, Yashu Mishra.
Hearing for exponent number
They have deposited the amount. There is learner counsel, please. They have deposited the amount because there is office subsection on that.
Please, they have deposited, but they have not filed any acknowledgement to that.
Right now, we'll overrule that. ಅದರಲ್ಲಿ ಹಿಂದಿನ ಕೇಸಲ್ಲಿ ಮೊದಲು ಬರ್ಕೊಂಡು learner counsel for the response admits that appellant has deposited the amount. Therefore, office objections would comply. Yes.
Number 23.
Appeal, Lord. But this is an appeal of the plaintiff, where the plaint is rejected by the trial court, relying upon Order 2, Rule 2 CPC. And the previous suit was filed by the defendants in my suit. And but that suit was ended in compromise. Because we filed within 3 months before the Lok Adalat. Now there was a fraud played, and that decrease under challenge in the writ petition, which was brought to your lordship's notice on the last occasion. But the question is whether on Order 2, Rule 2 CPC, the plaint could be rejected when the previous suit is not filed by the plaintiffs.
But that was also for partition.
It was partition, no doubt.
You were.
I was a defendant in that suit.
So you were.
But there only 4 properties were involved. In the latter suit, 20 other properties which are left out were the subject matter of the second suit. And the person who filed the application for rejection of the plaintee, whom I had not impleaded, he files an application to implead himself, impleeds himself, files the written statement as well as the IA for rejection. Then, within a few months, he releases all his rights in favor of defendants 1 and 2. That is also part of the trial court records.
So who got included?
The fifth respondent herein,
It was defendant number?
6 in the suit.
No, he was.
In fact, one more development happened. When the suit was pending, first defendant and second contesting defendants, they leased one of the properties to a private party. I filed an application to implead that party. That application came to be dismissed. Then I filed a writ petition before this honorable court. Then my amendment of the plaint was filed. The court wanted to first hear the 7 to 11 application. Then I filed a memo before the trial court.
Where writ petition was disposed of or pending?
No, it was disposed of because the plaint came to be rejected with the liberty to. Subsequently.
So
with liberty.
that writ petition, this order was passed?
Yes.
There was no interim order in the writ petition?
No, I had not sought for any stay because my IA for impleading was rejected. So notice was sent to the proposed party. Then one more development happened.
Some other.
Because the dependency, the lease the property in favor of a third person.
Lease ಅಂದ್ರೆ permanent lease.
ಅದು lease ಮಾಡಿದ document ಕೊಡ್ಲಿಲ್ಲ court ಮುಂದೆ, but large extent of land.
Tenancy na, lease ಅಂದ್ರೆ.
ಬಾಡಿಗೆ.
Term lease or monthly tenancy, what is that?
Lease is for rent. I'm sorry.
Tenancy na, in permanent tenancy na, otherwise what interest they were getting, term lease or permanent tenancy?
No, it was given to a dealership of four-wheelers to park their vehicles, large extent of land outskirts of Bangalore. No, but anyway, I sought to implead them. One more development happened. When my application for amendment of the plaint was pending, and his application for rejection was pending, I requested the honorable court to consider my application for amendment first, and then the other application. But the court said, no, I'll consider the rejection first. If the rejection happens, everything goes. Then I challenged that order before this honorable court. This honorable court directed the trial court to first consider the amendment application and then the application of rejection. So in that sequence, it was considered. My amendment was allowed. Then rejection was also allowed. And the person who filed the application for rejection releases his right interest in the suit properties in favor of defendants 1 and 2. This we came to know before the IA was heard and disposed of. I filed that document along with the memo. Now that he has released his rights in favor of D1 and D2, his application for rejection may not be maintainable. He has no locus standi. That memo is not considered by the trial court, and not my plaint is rejected. Order 2, Rule 2 CPC. And this ruling which was relied upon by him says otherwise. In a partition suit, if certain properties are left out either by ignorance or oversight, and a subsequent suit is maintainable. And if they have any dispute with regard to the nature of the properties, etc., then the trial has to happen. Now, I have shown that these properties are the joint family properties of my maternal grandfather and their father, defendant 1 and 2's father. My maternal grandfather died, leaving behind only, his only daughter died before him. And he left.
Your mother predecessor grandfather?
Yes, mother died first. Then the grandfather died, leaving behind his wife and the grandchildren through the daughter. So that's how the.
When she died?
She died in 1993.
Before this.
Yes, before the father died. Father died in 1987.
Did you claim under section 6 or 8?
ಈಗ ನಮ್ದು ಅಂಡರ್ ಗ್ರ್ಯಾಂಡ್ ಅಂತಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಬರುತ್ತೆ. This is under, not under 8. We are claiming under 6 itself. Not under 6. Under 8.
Produce ಮಾಡಿದ್ವಿ. Our production of, we have filed an IA application for production of document.
Is IA number? No.
Application filed on 12/8. Last time we had used along with the memo.
Production IA 4 of 2024.
4 of 24. Page 6L.
Illi date of death of Madhav Rao is not stated. And the date of death of daughter is stated.
There in that plot, there are two branches. One is Madhav Rao Rangarao. The other branch is, which is not shown in the bold letter.
So properties belong to this Ashwatthaya.
Ashwatthaya. Now, in the compromise petition between.
They are the heirs of Madhav Rao.
Yes. We are not the heirs of
Plaintiff number
Rangarao. We are the heirs of Rangarao.
Our-
My learned friend is the heirs of Madhav Rao. This Madhav Rao and
Madhav Rao's wife.
Madhav Rao's wife is Savitramma.
Plaintiff number 1.
Yes.
Wife ಹೆಂಗ್ ಬರುತ್ತೆ?
ಅಲ್ಲ ಅಂದ್ರೆ when we filed the second suit, she was alive.
Like second suit ಹಾಕಿದವ್ರು ಯಾರು?
ಹಾಕಿದ್ದು ಸಾವಿತ್ರಮ್ಮ.
ಡಾಟರ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ,
daughter had died in 1993.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಯಾವ್ದು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಒಂದು ಟೇಬಲ್ ಮಾಡಿದೆ.
ಹಾಗಲ್ಲ. Now it was being submitted by the other side that they claimed in their maternal grandfather's property ಅಂತ ಕೇಳಿದ್ರು. ಮತ್ತೆ ಇಲ್ಲಿ ಸಾವಿತ್ರಮ್ಮನವ್ರು ಇದ್ರ ಪ್ರಕಾರ she is wife of son ಅಂದ್ರೆ
ಇಲ್ಲ, wife of Madhav Rao.
Wife of Madhav Rao becomes the daughter-in-law to this Ashwatthaya, alva?
Yes.
Was Ashwatthaya.
Correct.
Ashwatthaya had died long time back.
Ashwatthaya daughter.
Submitting is submitted that this plaintiff number 1 was the granddaughter of the
Madhav Rao. I'm sorry. Plaintiff number 1 is the wife of Madhav Rao. I stand corrected.
Wife of Madhav Rao.
6 ಅಲ್ಲಿ ಕೇಳಿದ್ರ 8 ಅಲ್ಲಿ ಕೇಳಿದ್ರ ಅಂತ ಕೇಳಿದ್ವಿ ನಾವು.
Our direct joint family property, that is their contention. Only joint family property. Madhav Rao and Rangarao are the brothers.
Madhav Rao ನೇರಾಗಿ ಕೇಳಿದ್ರೆ ಆಯ್ತು ಸೆಕ್ಷನ್ ಅದು ancestral ಇದನ್ನ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಅಂತಂದ್ರೆ
ಅಲ್ಲ ಈಗ ಏನಾಗಿದೆ,
compulsory ಪ್ರಾಪರ್ಟಿ ಆಯ್ತು ಒಟ್ಟು.
ಏನಾಗಿದೆ ಅಂದ್ರೆ the other branch plot have now filed a suit for partition where all of us are part and family ಮೇಲೆ ಕೇಳ್ತಾರೆ. That is the other branch, right hand side branch. They have filed a suit.
There is a very vast estate. There is a very vast estate.
Yes, that 20
cases.
20 properties were in the second suit.
Properties are.
And 4 properties were alone added in the previous suit of 2015 by the defendants.
Whereas these issues can be agitated in that suit also. There are several, they are filing repeated partition suits. Now in the partition suit, we are the heirs of Rangarao. According to us, the properties which are joint family have already been partitioned, compromise has been entered. My learned friend says, no, you have acquired some more properties. They are acquired out of the income from these properties is their contention. Our answer was this issue, you did not raise it. All properties joint family have been
Now
partitioned.
the only question is if once the once partition takes place by the, under a compromise. Second suit for partition is maintainable.
No, when the
Now,
other,
could be the applicant.
other
But
branch.
another point is,
Applicant ಯಾರಿದ್ರೂನು court,
ಅಲ್ಲ.
court has to see whether the suit was maintainable.
that's the question involved in the entire appeal. But the judgment say order to rule to when it can be.
The evidence is required or not?
ಅಲ್ಲ ಆರ್ಡರ್ ಟು ರೂಲ್ ಟು ಡಿಸೈಡ್ ಮಾಡಿ ಎವಿಡೆನ್ಸ್ ಬೇಕು, ಅದಕ್ಕೆ ಇಶ್ಯೂ ಫ್ರೇಮ್ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ.
Application was filed on the ground of. Application, what were the contents of the grounds taken in the application? Res judicata or?
And order to ಎರಡೂನು
ಎರಡು.
ಎರಡೂನು ಮಾಡಿದ್ರು. res judicata ರಿಜೆಕ್ಟ್ ಆಗಿದೆ because I placed a Supreme Court's ruling saying that res judicata cannot be a subject matter of 7 to 11. Similarly, my lords, order to rule 2, identity of cause of action, my lords, is the point. And you see the provisions of order to rule 2 CPC. It's a matter of, my lords, evidence.
Yes.
But order 2, frame of suit. Now, I'll read 1 and 2 both together. Every suit shall, as far as practicable, be framed so as to afford ground for final decision upon the subjects in dispute and to prevent further litigation concerning them. Suit to include the whole claim. Every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action. Kindly note my cause of action, but a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court. Then relinquishment of part of claim, where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. Omission to sue for one of several reliefs. A person entitled to more than one relief in respect of same cause of action may sue for all or any of such reliefs, but if he omits, except with the leave of the court, to sue for all such reliefs, he shall not afterwards sue for any relief so omitted. Explanation. For the purposes of this rule, an obligation and a collateral security for its performance and successive claims arising under the same obligation shall be deemed respectively to constitute but one cause of action. Now, normally a suit is filed by the plaintiff, making out some cause of action, both real and formal. That is the purport. Now, when the previous suit is filed by the defendants in the latter suit, and within the matter of 3 months after summons were served on us, we were made to settle that suit. And later it was discovered that several other properties of the joint family were not added. And I produced a copy of the plaint in the earlier suit along with my plaint. Now, based on that, the court comes to the conclusion that it is by order to rule to CPC because it's a partition suit. The law, lords, with regard to that, one of the rulings of the Bombay High Court.
Was 846 of 2016. What was the earlier suit?
Earlier suit is of 2015.
104 page number, my lord. Appeal.
Judgmental reference ಇರಬೇಕಲ್ಲ ಅದು 896 of
15. 3 ತಿಂಗಳಲ್ಲಿ ಲೋಕ ಅದಾಲತ್ ಮುಂದೆ ಸೆಟಲ್ ಆಯ್ತು.
Disposed of on?
It was disposed of.
T2
4 December 23 compromise record.
ಅಲ್ಲ
2023.
ಇಲ್ಲ 14/3/16. 14th March 16.
14/3/2016. This suit was instituted on?
This suit was instituted on 6th of December 2016.
846 of 2016.
16.
6th, no?
6th of December 2016.
2016. Yes. Yes.
But this is the basic question, whether merely seeing my pleading and their pleading and the decision in a partition suit, second partition suit can be dealt with under order 7 to 11 CPC on the ground of order 2 rule 2 CPC. Because the normal thing is, if the plaintiffs are the same in both the suits, and as per the letter of law, if a subsequent suit is filed without seeking leave, or this relief could have been sought in the earlier suit, then it is hit by order 2 rule 2 CPC. Now the latter suit is filed with the defendants in the earlier suit, who have, now brought out that they are the victims of fraud, and that decree is in challenge in a writ petition because it was decided before the National Lok Adalat. Though there is a delay, Milords, we have placed the records to show how, Milords, the parties were misled to enter into that compromise. In the light of all this
Was
was,
the prayer in the present suit?
yes. Your
Okay,
Lordships,
the plain copy is there?
yes, but at page 65 of the appeal papers.
You are so challenged that earlier decree in this suit.
ಅಲ್ಲ ಇಲ್ಲಿ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅದಕ್ಕೆ WP ಹಾಕಿದ್ವಿ ನಾವು. We can't challenge that.
Said that WP is disposed of,
ಇಲ್ಲ that WP challenge to the
pending,
that is pending.
declaring plaintiff is entitled to half share. So there you took the contention that decree was fraudulent.
Yes.
The writ petition is ಹೇಗೆ ಹಾಕಿದ್ರಿ ಇದನ್ನ dispose
Writ petition came subsequent. That writ petition is subsequent.
ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರಿ.
ಅಲ್ಲ ಈಗ ಪೆಂಡಿಂಗ್ ಇದೆ, ಇವತ್ತಿಗೆ ಪೆಂಡಿಂಗ್ ಇದೆ. That is 24544 of 2022, and those 4 properties are not added here. 24544 of 2022. There the notice is ordered to the respondent, they have entered appearance. But these 4 properties are not the subject matters of the second suit, which are the subject matters of the earlier suit. 4 properties are not the subject matters of this suit.
Yes.
Lords may kindly notice from page 85 till the end of the plaint, in all 20, page 89, 20 suit properties are involved. And the earlier, if you Lords may kindly notice, the plaint in the earlier suit at page number 104 of the appeal papers. At page,
No, according to the question is whether this could be decided without.
exact. That is, ಅಲ್ಲಿ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲೇನೆ ಒಂದು ಬಾಂಬೆ ಹೈಕೋರ್ಟ್ ರೂಲಿನ ಸೈಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಐ ವಿಲ್ ಪ್ಲೇಸ್ ಇಟ್ ಬಿಫೋರ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್. What else?
Companies again. ಅಲ್ಲ ಈ ಪ್ರಾಪರ್ಟೀಸ್ ಇರಲಿಲ್ಲ.
So before I take your lordships to that judgment, may I point out the affidavit in support of the application for rejection, which your lordships find at page number 140 of the appeal papers. At page number 142, para 4.
Yes.
I submit that the plaint is liable to be rejected on principle of order 2 rule 2 CPC. The plaintiffs in paragraph 4 of the plaint have made the submission that the suit shall properties here were left out without partition in the previous suit OS number 896/15. This submission of plaintiffs precisely hits order 2 rule 2 CPC. The plaintiffs herein as defendants had all the opportunity under law to include the suit scheduled properties herein in the previous suit in OS number 896/15 and to claim their respective legitimate share. The plaintiffs herein as defendants did not choose to do so and intentionally omit to claim the rights and share in the suit scheduled properties herein in the above said previous suit The observation of Bombay High Court in case of so and so is relevant to cite. Now that is the ruling which I passed on to lordships. On the second page, your lordships find the following substantial questions of law are involved. Whether the present suit is barred by Order 2, Rule 2 of the Code of Civil Procedure, as the respondent original plaintiff filed the suit for partition on the ground that he was not aware of the property when earlier regular civil suit number so and so was decided. Then no. Whether the second suit for partition is maintainable for the property left out in the earlier suit for partition for want of knowledge. Yes. Then kindly come to that's para 8 on the next page.
The suit is not barred ಅಂತ no ಅಂದ್ರೆ.
Suit could be filed, but that's what happens is continuous cause of action in respect is only the thing what is to be decided is the claim of the plaintiff and the returns, defense of the defense, whether these properties are ancestral or not, whether they're joint family property or not, whether they are self-acquired properties of so and so. These issues fall for consideration in respect of these properties, if at all they have got any case. Why they want to short circuit is they know that once the evidence is let in, earlier suit they managed to get the compromise. We are all lots of small children, and in fact we could not get to know their scheme.
Minors ಇದ್ರ
Minors ಇರಲಿಲ್ಲ, we are majors no doubt, but ಇದು ವಾಸ್ಟ್ ಪ್ರಾಪರ್ಟೀಸ್ ಇರೋದ್ರಿಂದ ಅದು ಮಾಹಿತಿನೇ ಇರಲಿಲ್ಲ ಅಷ್ಟೊಂದು. ಈಗಾದ್ರೂ ನಮ್ಗೆ ಕಷ್ಟ ಬಿದ್ದು compromise was in March 16. March 16.
14/3/2016.
ಹೌದು.
The 14/3/2016, what was the age of these
Yes.
children?
Children were majors. I am not, disputing that, but they yeah, I'll just give I'll give the age that is indicated in the
2024 ಅಲ್ಲಿ 33 ಅದೇ 16 ಅಂದ್ರೆ 8 years
8 years ಕಡಿಮೆ. 20, 24, 25 just now they are in and out of college. That was the situation.
Yes.
But all said and done, the submission is, the legal submission is, in a case like this, but courts have, it is, has to be tried. If they have got defense.
See, why we are hearing this in so much detail is, if we grant some interest, again, all these old matters will become still more
Okay,
old.
now ನಂದು ಅದೇ endeavor ಇರೋದು. This is the short point involved. Now we'll be able to assist the honorable court, and not decide, the matter could be, main matter could itself be decided. Then the trial court can take upon that. ಇದು ಅನ್ಹರ್ಡ್ ಆಫ್ Order 2, Rule 2 ನಲ್ಲಿ ಈ ತರ ಡಿಸ್ಪೋಸ್ ಮಾಡೋದು. ಯಾಕಂತಂದ್ರೆ ನಮ್ಗೆ ಕೆಲವೊಂದ್ಸಲ ಏನ್ ಅಪ್ರಿಹೆನ್ಷನ್ ಆಗುತ್ತೆ ಅಂತಂದ್ರೆ, ಟ್ರಯಲ್ ಯಾಕೆ ಅವಾಯ್ಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ವಾಟ್ ಈಸ್ ದ ಲೀಗಲ್ ಗ್ರೌಂಡ್, ರೆಸ್ ಜುಡಿಕೇಟಾ ಗಾನ್. ಇದನ್ನು ಐಡೆಂಟಿಕಲ್ಲೇ ಇದು.
You are submitting something, why they are short circuiting ಅಂತ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ.
ಅಲ್ಲ, ಶಾರ್ಟ್ ಸರ್ಕ್ಯೂಟ್ ಅಂದ್ರೆ ಟ್ರಯಲ್ ಆದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಅವ್ರಿಗೆ ಶೇರ್ ಕೊಡ್ಬೇಕು ಅಂತ. ಅದಕ್ಕೆ ನಮ್ದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಥಾಟ್ ಆಯ್ತು. I had to come to the High Court again. In a pending partition suit, there is some alienation. Release is also an alienation. Possession is given to a third party. It is always advisable to bring that party on record. That is rejected. ಆಮೇಲೆ ನಮ್ದು ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡು 7 to 11 ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ ಅಂತಾನೆ ಡಿಸೈಡ್ ಮಾಡಿದ್ರು. ಅದನ್ನ ಅಗೇನ್ ಐ ಹ್ಯಾಡ್ ಟು ಕಮ್ ಟು ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್. ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಸೆಡ್ ಯು ಡಿಸೈಡ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಫಸ್ಟ್ ಅಂಡ್ ದೆನ್ ದ ನೆಕ್ಸ್ಟ್. ಆ ತರ ಮಾಡಿದ್ದಾರೆ. ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲೌ ಮಾಡಿದ್ರು, 7 to 11 ಅಲೌ ಮಾಡಿದ್ರು.
Now you are referring to this judgment.
Yes.
Bombay Court.
This is borne out from the affidavit of the applicant. Now, when these glaring things are brought to the court, it is rather surprising how in respect.
We are referring to this judgment. You
Correct,
want to
correct.
say something in the judgment. What is it?
ಇಲ್ಲಿ ನಾನು para 8 ಅಲ್ಲಿ ಆನ್ಸರ್ ಮಾಡಿದ್ದಾರೆ questions
Correct.
which are raised on the as observed by the Supreme Court and considering the scheme of Order 2, Rule 2 of the Code of Civil Procedure, it is necessary that parties must claim all reliefs as available at the time of filing the suit and or claim. Any intentional omission bars the second suit and or claim. There is no dispute that a suit for partition of joint family properties must include the whole of the property jointly held by the parties. Therefore, fresh suit for non-included party omitted items is not permissible. However, it is subject to exception when the omission omission in the previous suit was due to inadvertence or through ignorance of the omitted items and or no knowledge or inadvertence, actually in view of the scheme and purpose of order to rule to itself, as observed by the apex court in the above judgment. The word omission itself means that the claim or property in the first suit. What happened in the present suit is recorded and observed by both the courts, and rightly so. Therefore, second suit after the knowledge about the said excluded joint property is not barred under Order 2 Rule 2 CPC. Order 2, there is no question of res judicata applies in the present manner.
But the trial court refers to this judgment.
Trial court ignores this. Adadella, they don't ignore.
This was cited by whom?
By the applicant, stated in the affidavit. Stated in the affidavit.
Yes.
And during my arguments, I brought it up. And the release of the property by the very same applicant before the order came to be passed was also placed on record before the trial court. That release is available on record here. May I request your lordships to kindly turn to page 139 of the appeal papers. I'm sorry, not 139.
Page?
No. Only one second. Page 151, I'm sorry, page 151. (151) is the memo filed by the plaintiffs on 24/3/2023 before the impugned order came to be passed, enclosing a copy of the release deed executed by defendants 4, 5, and 6 in favor of defendants 1 and 2. B.L. Narayan is a D6, we got himself impleaded.
They are all peripheral, but now.
No, I'm only trying to test bona fides of the applicant. Now, during the pendants, they suppress this. Kindly appreciate this. In a partition suit, if the right is gone, then their existence in the suit may not be necessary. If they are given it away, it was suppressed. And this was brought before the Honorable Court. And also an argument was advanced. In view of this, his application, he does not have locus standi to pursue that application.
We are trying to say that such omission intentional under order.
Oh, correct.
Rejected.
Rejected.
Ashtenimsa.
And I was the defendant in
the other things are all peripheral.
This is to show how the court proceeded.
You can, this is the interpretation of order to rule 2. Now you said you relied on this judgment. You say that if the omission should be intentional, questioning that the omission was not intentional, there was alva. There should have been trial to find out whether it was intentional omission.
Trial back evidence
So, order 7 rule 11
I was the defendant in the earlier suit, though it's a
see whether a defendant or a plaintiff.
kindly
In
appreciate.
partition suit, all the parties are in the
That is only for the purpose of raising contentions, not to invoke order to rule 2 CPC. They were the plaintiffs, and it was their obligation. Kindly appreciate order to rule 2. It is a very cause of action for filing the suit is attributable to the plaintiffs. Defendants now ಹೇಳ್ಬೋದಾಗಿತ್ತು ಇಲ್ಲ ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಿದ್ರೆ.
In a partition suit, all the parties are in the array of the defendants.
That is for the purpose of.
See, if there are any other family properties, defendants also could have joined that, but now you say that you claimed that there was a fraud played on you, these properties were not within your knowledge, so I have filed a writ petition challenging that compromise. So when pending that writ petition, whether the trial court should have decided
exactly.
under order 7 rule. See, this is the prime question.
Therefore, facts ondaitu law. These are the only two things. Facts of the case, as you also rightly put it, and the law. Now, whether in the case, though it's a partition suit, all are plaintiff defendants of the general rule, ide illa antilla. But person who comes to the court, if he himself does not add vital properties, I for my ignorance, I have failed to bring it, but ಮೂರ್ ತಿಂಗಳಲ್ಲೇ
ಅದಕ್ಕೆ ನೀವ್ ಹೇಳೋದು ಈಗ ಇಂಟೆನ್ಷನಲ್ ಒಮಿಷನ್ ಇತ್ತು ಅನ್ನೋದು it becomes a matter of fact. So there should be evidence for that. Order 7 rule 11 invoke ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ನಿಮ್ submission. ಅಷ್ಟೇ ಅಲ್ವಾ?
ಅಷ್ಟೇ ಇರೋದು, ಅದನ್ನ ಮಾಡ್ಬಿಟ್ಟು ಮುಗಿಸ್ಬಿಟ್ರೆ ಅಪೀಲೇನೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದು ತಾವು.
ಎಸ್ ಇವ್ರೆ ಏನ್ ಹೇಳ್ತೀರಾ? What do you say for this to invoke order 2 rule 2? Their evidence was required to show that there was an intentional omission.
I'll answer that.
ಅಲ್ಲ ಇಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ facts ಮೇಲೆ I have to demonstrate.
What is the scope of the litigation ಅಂತ
Yes,
ನೋಡ್ಕೊಂಡು
therefore we have to look into the plaint and
ನಾವು
the earlier.
12:30 ಇನ್ನು ನಮಗೆ IA hearing admission ಆಗ್ತಾ ಇಲ್ಲ. Admission reach ಆಗಿಲ್ಲ ನಾವಿನ್ನು.
On that issue, I will be able to show that they were aware of all these proceedings earlier also. It is not a question of without knowing those properties, they have not filed this suit. They knew about this earlier. And now also, Lord, there is no averment in the plaint that we did not know earlier. At that time, we did not know. Now we have come to know that averment is not.
ನಿಮ್ಮ application ಗೆ they had filed statement of objection.
Yeah, no, in the plaint itself, that point also we have said in our application.
Plaint also they had said that.
Plaint, Lord, if we have to ultimately look into the plaint itself.
Plaint order 7 rule 11 they have to look
Correct,
at the plaint
correct.
only, not your.
So, the two documents which are relevant is the earlier compromise
What
petition.
they had said in the plaint about
Yes, kindly see the plaint, which is at page 65. And after the compromise, Lord, they sell their properties also, that I also have produced. At page 70.
Now in the plaint you show what they have said about.
Yes, yes. Kindly see page 70 in the present plaint.
Page number 65 ಇಂದ ಶುರು ಆಗುತ್ತೆ ಅಂದ್ರಲ್ಲ plaint.
It starts from 65. I am pointing out the relevant portion, para 3B.
Para 3?
3 capital B.
D.
Page 70. The plaintiff submit that Madhavrao alienated 6 items of the above properties. Items 1, 3, 4, 5 and 6. Item
3D na?
para 3B.
B.
Capital B.
Yes.
3A is also.
That previous 3A in the name previous page, plaintiff 3A. The plaintiff submits that Madhavrao was granted 10 items of agriculture lands in Chagalatti village, Jala Hubli, Bangalore, North Taluk. Earlier, Devanhalli Taluk under the provisions of Personal and Miscellaneous Inam Abolition Act by the Special Deputy Commissioner for Inam Abolition in 59/1960. These are the items which are granted to Madhavrao. Those descriptions are there. Then in the next page, 3B, plaintiff submit that Madhavrao alienated 6 items of the above said properties, item number so and so. Item 1 was mortgaged in the year 1969, rupees 300. Later it was sold in the year 1982 for a consideration of 3,000. Item 2, below, all these transactions pertain to 69, 1980, 81. All these item 3. Item 2, 3 is in 1981, 4 is in 1962, 5 and 6 was sold by Madhavrao during his lifetime. Item number 7 was mortgaged in the year 1968. Item number 10 was sold by Rangarao to an extent of 68 for 5,000 in the year 1980. He says that on the basis of these transactions which had taken place from 1960 onwards till 1980, then expire at page 71, middle.
So,
Amounts raised by.
Purchaser or family member?
No, I am a family, I am Rangarao. He is referring to Madhavrao sold these properties.
These are also there in the suit?
These properties were earlier only sold. What was there, blood, was the remaining properties, remaining 4 items of properties, blood, which remained, was the subject matter of partition. What they now want to say is, these properties were sold in 1969. Out of that, you started a provision store. Out of the business from provision store, you have acquired. Provision store was started in 1975, general and provision store. All these have happened long ago, about 2 decades ago. Now, where is the question now? Now saying that I came to know now, he is part of the joint family only. ನಾಲೆಡ್ಜ್ ಇದೆ ಅಂತಾನೆ ಇದರಲ್ಲೇ ಗೊತ್ತಾಗುತ್ತೆ. ಇವರೇ ಹೇಳ್ತಾ ಇರೋದು.
They started practice in 1975, no?
1975, they started store business. Out of this is their case. This is not something which has happened recent. 71.
Yes.
Page 71 middle alley, the amounts raised by Madhavrao out of the aforementioned transaction were used for the purpose of establishing general and provision stores in or about 1975 and expanding the said business by adding hardware and fertilizer business. The said business was commenced at Bangalore. It was later shifted to bigger place at so-and-so, Bangalore Main Road, Bangalore, sometimes in the year 2009. The business is being carried out in the name and style of SLN Provision Store, SLN Fertilizer and SLN Hardware. The said business is also joint family business of Madhavrao and Rangarao, both having equal share. Therefore, the plaintiffs are entitled to half share of Madhavrao. Defendants are also liable to render accounts of the said joint family business at least for the last 3 financial years commencing from 2017 till date. Plaintiffs submit that initially they had sought for partition in respect of 6 items of property set out in the schedule to the plaint. Recently, the plaintiff learned that several other properties in all 14 properties belonging to the joint family are also available for partition. The said properties are added to the original schedule to the plaint as item number 7 to 20. Lord, what he wants to say is, this general provision store was there. This was a joint family business. Out of this, you acquired several properties. This was there. This business was being run from 1975.
But it is all matter of evidence, alva.
No,
Then they
Idral, on the face of the plaint he should demonstrate. Now, I am not referring to any other document.
Plaint, he said recently they came to know.
No, recently, that is, what he says is, out of this joint family business they have acquired. The joint family business was there in 1975 only. Now, what he wants to demonstrate is, this business was there. Out of this business, you acquired other property. Now, what does he say about this joint family business? He does not say anything about it. Now, Para 4, the defendants had filed OS number 896 of 2015 on the file of this honorable court against the plaintiffs herein for partition and separate possession pertaining to same property. The said suit was compromised amongst them, and accordingly they are in separate possession of the respective shares as allotted in the said compromise decree. Properties now included in this suit were left out without partition. Defendants who are the branch of Rangarao are managing the affairs of the joint family. Now, my lord, if your lordship look at the schedule at page 85, serial number 1 to 18.
Page number?
Page number 85. Plain schedule. There, my lord, serial number 1 to 18 are different properties which according to them is acquired out of joint family business in 19 and 20. 19 and 20, the joint family business. Now,
When they were acquired?
19 and 20 is the joint family business. According to them, out of this joint family business, you acquired other properties.
19 and 20 property, immovable property.
ಅದು ಬರೀ ಪಂಚಾಯತ್ ನಂಬರ್ ಅಂತ ಹಾಕ್ತಾರೆ, ಅದೇ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಬಿಸಿನೆಸ್, ದಟ್ ಈಸ್ ವೇರ್ ದಿ ಪ್ರಾವಿಷನ್ ಸ್ಟೋರ್ ಅಂಡ್ ದಿಸ್ ಒನ್ ಇಸ್ ಬೀಂಗ್ ರನ್.
Business ಅಂತ ತೋರಿಸಿಲ್ಲ, ಪ್ರಾಪರ್ಟಿ.
ಅದ್ರಲ್ಲಿ ಪ್ಯಾರಾ 3.0 ನಲ್ಲಿ ಅದನ್ನೇ ಹೇಳೋದು, ಪೇಜ್ 77 ಅಲ್ಲಿ. 3.30 at page 77. 3O, ಅದು 0 ಅಲ್ಲ, O. Which is where she described in 19 and 20 ಅಂತ ಹೇಳ್ತಾರೆ. 3O para at 77.
Correct. Business is being run there.
Run in 19.
What is included is a suit.
Yeah, this 19 and 20, what they say was there from 1975. They shifted their business to in 2009. Out of this, you have acquired the other properties. This I came to know now, but that is not the issue. Now, this family properties business is that they knew earlier also. There is no averment in this Plaint that about this family business, that is 19 and 20, schedule 19 and 20 read with 3O. They did not know about it earlier. There is no averment at all in the petition. Your lordships are right in saying that in so far as an intentional, they, without knowing the existence of the properties, if they say that after filing of the earlier suit, I came to know now, that averment is also not there. Whereas in the compromise petition,
Yes.
which is at page 249. There, 249 is the compromise petition.
Yes.
Plaint is there at para 3. Para 3. The first plaintiff have agreed to relinquish her right, title, interest, and possession of her share to the plaintiff number 2. First defendant have agreed to relinquish her right, title, interest, and possession of her half share to the defendants number 2 and 3. Plaintiffs and defendants have amicably agreed to take respective their half share in the suit schedule property, as Schedule A properties are allotted to the share of plaintiff 4 and 5. Schedule B properties are allotted to the share of defendant 2 and 3. Schedule C properties are allotted to plaintiffs number 2 and 3. Plaintiffs and agreed to get their mutation.
Mothers ಏನು ಕೊಡ್ಲಿಲ್ವಾ ಇದ್ರಲ್ಲಿ?
But
Mothers were not given anything. They relinquished that.
mother
ಸರಸ್ವತಿ and ಸಾವಿತ್ರಮ್ಮ
ಕೊಟ್ಟಿಲ್ಲ
ಅವ್ರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ ಬಟ್ ಅದರಲ್ಲಿ ಇವ್ರದ್ದೇ ಅಬ್ಜೆಕ್ಷನ್, ಈಗ ಅವ್ರದ್ದೇನಿಲ್ಲ.
ಇಲ್ಲ, ನಾವು ಅವ್ರ ಮೊಮ್ಮಕ್ಕಳು, ಅವ್ರ ಮಗಳ ಮಕ್ಕಳು.
ಯಾರ ಮೊಮ್ಮಕ್ಕಳು?
ಸಾವಿತ್ರಮ್ಮ is our maternal grandmother.
Now if you
Only daughter she had, who died before the father died.
Order to rule 2, my lord, your lordship may kindly have a look at order to rule 2.
Yes. Yes.
Every suit, order to rule, every suit shall include whole of the claim, which the plaintiff is entitled to make in respect to the cause of action. But a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court. Where plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. Omission to sue for one of the several relief. A person entitled to more than one relief, this will not arise. Omission to person entitled to more than one relief in respect of the same cause of action may sue or in any such relief. But if he omits except with the leave of the court to sue for all such relief, he shall not afterwards sue for any relief so omitted. So what is relevant is clause 2, where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of this. Now, in the present case, there is no averment in respect of this family business. He was not aware of it. What he says is, the properties acquired out of this family business, I have recently come to know. Even that recently word also is not sufficient to justify this act, because now he will have to say, after the filing of the previous suit. Now, I was not aware of it. Recently, my lord, does not mean anything. There are two judgments to that extent, which my learned friend has. Good one.
But what was the hurry for the trial court when that writ petition was pending?
What?
When that writ petition was pending,
No, writ petition, my lord, he files in 2022. His rights is science, the compromise takes place.
pending since 2016, right? And this application was also
No,
belated.
here pendency.
By that time, questioning that compromise decree, the writ petition was pending before the higher
No, but
court.
writ petition, there is no order passed till date.
No order passed, right? But still-
Notice was ordered to them.
Mere pendency of a case.
They have appeared in the case.
Mere pendency of a case does
No,
not.
whether they have appeared or not, it was within the knowledge of the trial court.
I'm not too sure.
Pendency of the writ petition
I'm-
was
I'm-
whether
I-
it was within the
Subject to
knowledge.
clarification, Lords, because the notice
Yes,
was ordered on.
judgment date. Right, the judgment source, what is this?
ಅಲ್ಲ ನಮ್ಗೆ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಮುಂದೆ ಗೊತ್ತಿತ್ತು.
Necessarily complicating the case. Yes. Order.
Pendency of a case, my lord, does not in any way.
We are aware of that fact, but it is the, if it was within the knowledge of the trial court, then when the matter was pending before the higher court, ಒಂದು ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಆಗ್ಬಿಟ್ರೆ ನಮ್ಗೊಂದು ಡಿಸ್ಪೋಸಲ್ ಸಿಗುತ್ತೆ ಅಂತ ಮಾಡೋದಲ್ಲ.
ಅಲ್ಲ ಅದು ಐ ಡೋಂಟ್ ನೋ ಬ್ಲಡ್ ಅದರಲ್ಲೆಲ್ಲೂ ಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಕಾಣ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ ಆರ್ಡರ್ ನಲ್ಲೆಲ್ಲೂ ರೆಫರೆನ್ಸ್ ಬಂದಿಲ್ವಾ ಅದಕ್ಕೆ?
ಇಲ್ಲ, I think.
ನೀವು ವೆದರ್ ಇನ್
I'll subject to correction. I will verify it. I will verify it.
affidavit somewhere whether it had come on record about pendency of this
ಇಲ್ಲ,
writ
it was
petition.
not brought to the notice of trial court. With regard
ಯಾರು
to
ಇಬ್ರು
pendency.
ತರ್ಲಿಲ್ವಾ ನೀವು? Both of you did
ಇಲ್ಲ,
not-
ನಮ್ಮ ನೋಟಿಸ್ ಬಂದಿದ್ದೆ later onwards.
ಅಂದ್ರೆ ಈ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ
Compromise, my lord.
ಯು ಆರ್ ಫಾರ್ ದ ಅಪ್ಲಿಕೆಂಟ್.
No, my lord, the applicant is my lord.
No, applicant was not the original defendant. Applicant came on record subsequently.
Subsequently,
Yes.
impleaded.
ಎಷ್ಟು
I will show some events, my lord, in the order sheet. I will,
ಸಾಧ್ಯನೋ ಅಷ್ಟು
I will show next.
things ಅನ್ನ ಕಾಂಪ್ಲಿಕೇಟ್ ಮಾಡೋದಕ್ಕೆ. Yes, yes, learned senior counsel, which paragraph you want to read in this
Lord,
statement?
this second judgment there,
Second judgment.
ಅದರಲ್ಲಿ
2014
2014
SCC.
6 SCC at para 9, after referring to these
Page number?
page, ink page 16.
ನಿಮ್
para 9.
ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಹಾಕ್ತಾರೆ, ಇಂಡೆಕ್ಸ್ ನಲ್ಲಿ ಹಾಕೋದಿಲ್ಲ.
ಅದರಲ್ಲೇ ಇಂಟರ್ನಲ್ ಪೇಜ್ 429.
ಅಲ್ಲ ಆಯ್ತು, ಇಲ್ಲಿ ಸಿಕ್ತು, ಇಂಕ್ ಪೇಜ್ ಒಳಗಡೆ ಹಾಕ್ತಾರೆ. ನಿಮ್ಗೆ ಇದ್ರಲ್ಲಿ ಹಾಕೊಟ್ಟಿದ್ದಾರಾ?
ಅದೇ ಇಲ್ಲ ಹಾಕಿಲ್ಲ.
ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ 16. yes.
Para 9, the above rules are offshoots of the ancient principle that there should be an end to litigation traced in the full bench decision of this court in Lakshmi versus Bulli and approved by this court in many of its decisions. The principle which emerges from the above is that no one ought to be vexed twice for the same cause. In light of the above, from a plain reading of Order 2, Rule 2, it emerges that if different reliefs and claims arise out of the same cause of action, then the plaintiff must place all his claim before the court in one suit, cannot omit one of the reliefs or claims except with the leave of the court. Order 2, Rule 2 bars a plaintiff from omitting one part of the claim, raising the same in a subsequent suit. Furthermore, this court in Alka Gupta versus Narendra Kumar Gupta stated, object of Order 2, Rule 2, the court is twofold. First is to ensure that no defendant is sued and vexed twice in regard to the same cause of action.
There is no dispute about this principle at all.
ಅಲ್ಲ ಪ್ರಿನ್ಸಿಪಲ್ ಯಾಕೆ ಅಂದ್ರೆ ಇವರು ಪಾರ್ಟಿಷನ್ ಸೂಟ್
Process of the court.
ಪಾರ್ಟಿಷನ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹಾಕೊಳ್ಳೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ನಾ ಹೇಳ್ತಾ ಇರೋದು. ಬಿಕಾಸ್
But we are asking whether we didn't accept that statement that he was plaintiff, he was defendant, because in our partition.
therefore, my lord, he cannot just casually say, no, recently I have come to know and all this. The foundation should be laid here. It is a lofty principle so that litigation will come to an end. If he wants to overcome this, there has to be a specific pleading as to how he can sue it second time in respect to the very same matter, which is lacking, my lord, in the present plaint.
So this 2016 ನಲ್ಲೇ ಆಗಿರೋದು 14/3/2016
But now,
Writ petition was filed in 2022.
22 ಬಿಕಾಸ್ ಅದು ಏನಾಯ್ತು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಸಿಗ್ಬೇಕಾದ್ರೆ ನಮ್ಗೆ ಸ್ವಲ್ಪ ಕಷ್ಟ ಆಯ್ತದು ಗ್ರಾಂಟ್ದೆಲ್ಲ ಅದು ತೆಗೆದ್ರೆ ಇಟ್ ಸ್ಟೇಸ್ ಟು ಮಾಧವರಾವ್ ಓನ್ಲಿ ರಂಗರಾವ್ ಹ್ಯಾಡ್ ನೋ ಇಂಟ್ರೆಸ್ಟ್.
Writ petition ಹಾಕಿ ಅದ್ರಲ್ಲೇ ಸಮನ್ ಮಾಡ್ಬೋದಿತ್ತಲ್ಲ.
ಅಲ್ಲ ಇವರು
ನಾವು ಕಷ್ಟ ಬಿದ್ದು ಡಾಕ್ಯುಮೆಂಟ್
ನಿಮ್ಮಲ್ಲಿನೂ ಸ್ವಲ್ಪ ಈ ಅಪೇರೆಂಟ್ಲಿ ಕಾಣಿಸ್ತಾ ಇದೆ. There is some
No, the documents are very clear. What annexes are produced in the writ petition, they originate.
2022ರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ, 2016ರಲ್ಲಿ ಆಗಿರೋ
ಹಾಗೆ ಅದು ಏನಾಗುತ್ತೆ ಅಲ್ಲಿ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲಿ ಬೆಂಗಳೂರು ಸುತ್ತಮುತ್ತ ಬಹಳ ಕಷ್ಟ ಆಗುತ್ತೆ ತೆಗಿಬೇಕು ಅಂತ.
ಇವ್ರು ಹೇಗೆ ಅಂದ್ರೆ ದಿಸ್ ಕಾಂಡಕ್ಟ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಯು ಲಾರ್ಜ್ ಮೇ ಕೈಂಡ್ಲಿ ಟೇಕ್ ದಿಸ್ IA ಫಾರ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ರೆಫರ್ ಮಾಡಿ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಬಿಟ್ಟು ದೆನ್ ದೇ ವಿಲ್ ರಿಯಲೈಸ್ ನೋ ದೇರ್ ಇಸ್ ಫ್ರಾಡ್ ಅಂತ ಅವ್ರ ಪಾರ್ಷನ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ.
ಸೇಲ್ ಡೀಡ್ ಯಾವಾಗ ಮಾಡಿರೋದು?
ಅದೇ ಕೈಂಡ್ಲಿ ಸಿ ನಾವು 2023 ಮಾಡ್ತಾರೆ. ಪೇಜ್ 89.
Page 89. 89 of sir.
IA 4/24 along with documents.
2018 ಅಲ್ಲಿ ಒಂದು ಮಾಡ್ತಾರೆ. 2020
93 ನ ಅಲ್ಲ ಪ್ರಮಾಣ ಪತ್ರ.
Page 89 is on
89 ನಲ್ಲಿ
2023.
18 of
IA 4 additional documents, my lord.
IA 4 ಅಂತ
A4
genealogy ನೋಡೋದು.
ಅದು IA4 ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ
Objection.
4127 ಹಾಕಿದೀರಾ ನೀವು. ಅದು ಅದು ಹೇಗೆ ಆಗುತ್ತೆ ಅಂತ ನಾನು ಹೇಳ್ಬೇಕಾಗ್ತದೆ.
A4
ಅದರಲ್ಲಿ
ಸೇಲ್ ಡೀಡ್ ನೀವು ಎಕ್ಸಿಕ್ಯೂಟ್
ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಅದಕ್ಕೂ ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿ.
ಐ ಆಮ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ದಟ್.
Page 89.
4 ಅಲ್ಲಿ page 89
I am not disputing the sale because the document is there. That way I mean,
Page 89 of that IA.
that is 31/1/2020.
There, my lord, this Venkatesh at page 93.
Relinquishment Vishwa.
Beside.
Writ is filed in 2022, 2023.
31/1/2023.
At page 93,
Page 90. Yes.
relevant portion at page 93, second para.
Yes.
At page 93,
Yes.
second para, whereas the sellers had acquired scheduled property with final decree passed in OS 896 of 2015. Senior civil judge generally registration dated 23/6/2016. Registered as document number so and so, registered before the compromise is also registered. Originally scheduled property was 38/2 agriculture land, newly numbered as so on.
Then now we have included these properties in the partition suit.
No, not included. 4 properties which are there in the early.
Correct. ನೀವು partial partition ಆಗಿತ್ತು ಅಂತಂದ್ರೆ
The submission is this. I mean, as a matter of fact, I'm making.
Page
submission.
101.
The 4 properties which were there in the earlier suit are not part of the second suit.
but there are now new parties also in the suit. There are no new parties also in the suit.
No,
ಯಾರು
new-
ಹೊಸದಾಗಿ ಇಂಪ್ಲೀಡ್ ಆಗಿದ್ದಾರೆ ಅಂತ
ಅವ್ರು
ಹೇಳಿ
ಇಂಪ್ಲೀಡ್ ಆಗಿದ್ದು ಯಾರು ಅಂತಂದ್ರೆ he is the branch of the sister of defendants 1 and 2. Sister children were parties.
ಅಂದ್ರೆ ಅವಾಗ they were left out.
ಇಲ್ಲ ಅವರು ಪಾರ್ಟಿ ಇದ್ರು.
Partition
Children were parties. But their mother had died. So husband claims through the wife her share, whatever she gets.
ಆ partition suit ಅಲ್ಲಿ ಎಲ್ಲಾ branches ಇನ್ವಾಲ್ವ್ ಆಗಿತ್ತಾ?
ಎಲ್ಲ branches ಇದ್ರು except the husband of their sister. Only the sister children were parties in the earlier suit.
Children were there.
Yes. And the husband is claiming through the share of his wife who died
Yes.
earlier.
Yes, you wanted, what you wanted to
Then
show
my
from
lord,
the
at
sale
page
deed.
88,
Page
101 is another sale deed. Executed on 11/4/2018.
Yes.
There,
11/4.
in the page 103,
Yes.
about 10 lines from the bottom, at 103, they refer to this OS 896 of 2013.
Page 103.
Page 103, 103. ಅದರಲ್ಲಿ ಬಾಟಮ್ ಇಂದ ಒಂದು 10 ಲೈನ್.
Seniors.
OS 896 between Saraswati and 4 others and Savitrama
Yes.
before the senior civil judge. As per this compromise decree executed by the Honorable Court of the Senior Civil Judge JMSC, to an extent of 16 good laws.
ಸ್ವಲ್ಪ ಕಾಣ್ತಾ ಇಲ್ಲ ಯಾಕಂದ್ರೆ
ಅಲ್ಲ ಅದು
having filed writ petition regarding the same property, how could they sell this property?
the
The
concept.
31/1/2000.
I fully agree with the Honorable Court's view, but
They want to make the courts as their picnic spots. ತರ ಅಲ್ಲೊಂದು ಕೇಸ್ ಹಾಕೋದು ಪ್ರಾಪರ್ಟಿ ಕೋರ್ಟ್ ಪರ್ಮಿಷನ್.
submission is only this. Submission is only this. Fraud will be decided on a different plane depending upon what I establish.
See.
Now in the
See.
coming to the present suit,
ಅಲ್ಲ ನನಗೆ ಇದೊಂದೇ ಕೇಸಲ್ಲಿ ಕೇಳಿ ಅಂತ ಹೇಳ್ಬಾರ್ದು ನೀವು, ಯಾಕೆಂದ್ರೆ you said you have filed a writ petition questioning that, and pending that writ petition your client sell the property
but
without
that
link of
is
the court.
that is one thing, lords. After I came to know of it, but the point,
You have to defend that action also.
that in the other proceeding, I'll certainly do that, and what was the circumstance?
When you are before the court,
I understand. Party has to be fairness, honest and truthful. I'm not disputing that. Now the only question is, so much of material is there and a compromise is in 3 months' time hurriedly, my lord, that
ನಾವ್ ಹೇಳಿದ್ವಲ್ಲ writ petition pending
pending
ಇದ್ದಾಗ
the
ಅದ್ writ petition pending ಇದ್ court notice ಗಿತ್ತ ಅಂತ ತೋರಿಸಿ ಅಂತ
I'll
ಹೇಳಿದ್ವಲ್ಲ.
I'll just I'm obliged.
Because parties choose to show only what they want to show.
No, I understand.
This
Blood, one more submission is, now at page 144,
140.
the suit filed by one Mr. Ashwatha.
Ashwath is
Ashwath is
plaintiff, huh?
is the father of plaintiff 2 and 3. He files another suit now,
He was not a
including
party
all
in
other parties.
He was not a party in that earlier 896 of 2015.
ಎರಡು suit ಅಲ್ಲಿ ಇಲ್ಲ ಅವರು.
ಅದ್ರಲ್ಲಿ ಇರ್ಲಿಲ್ಲ.
Earlier 2 suits ಅಲ್ಲಿ ಇಲ್ಲ ಅವರು. ಇದು ನಮಗೆ ಈಗ ಗೊತ್ತು.
His suit only, to him only.
Same property.
ಅಲ್ಲ genealogy ತೋರಿಸಿ ಅದನ್ನ.
ಅದ he is the father of Venkatesh and
Genealogy.
ತೋರಿಸಿ ಸ್ವಲ್ಪ ನೋಡ.
Genealogy ತಗೊಂಬಿಡಿ, page 6.
Page
6 of the same document, IA4.
IA4 ದಲ್ಲಿ.
ಅದೇ ನೀವು ಇಟ್ಕೊಂಡಿದ್ದೀರ, ಅದರಲ್ಲೇ page 6.
Page 6.
Page 6 ಅಲ್ಲಿ this Madharav's daughter is Ashwath Lakshmi. Ashwath Lakshmi's husband is this Ashwatha. He is the father of Venkatesh and
Plaintiffs ಯಾರು? ಈಗ present suit in plaintiffs genealogy.
he is the father of Venkatesh and Vishwa, who are the plaintiff 2 and 3.
ಅಲ್ಲ plaintiff 2 is Venkatesh, Vishwa is plaintiff number 3.
Ah.
They claim through the same Ashwath ಅಲ್ವಾ? ಈ Ashwath
Same.
Lakshmi husband.
ಹೌದು. Same property, same.
Ashwath is claiming through his wife.
The suit in OS number 896 of 2015 was between.
Same properties.
No.
ಎಲ್ಲ ಯಾರ್ ನಡುವೆ?
That was.
ಆ plain copy ತೋರಿಸಿ ಎಲ್ಲಿ?
ಅಲ್ಲ, it's on record. It's on record.
That is
In the appeal papers.
Savitrama, Venkatesh and Vishwa.
ಅಲ್ಲ plain copy ತೋರಿಸಿ ಅಂತ.
Yes.
Same copy ಇದೆ ಇಲ್ಲ.
Page 65.
Page 65 of this appeal memo ಅಲ್ವಾ?
Yes, my lord. First party Savitrama.
ಒಂದ್ ನಿಮಿಷ.
Page 104, old suit, 15 suit ಅಲ್ಲಿ, 15ನೇ suit ಅಲ್ಲಿ.
ನಾವ್ ಹೇಳ್ತಿದ್ದು ಈ ಸೂಟ್ ಅಲ್ಲ, ಮೊದ್ಲಿಂದ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ 896 of 2015.
ಅದರಲ್ಲಿ page 104.
Earlier suit ಇದೆ.
ಹೌದು.
ಆ ಸೂಟ್ ಸರಸ್ವತಿ.
ಅದು 232 page.
ಸರಸ್ವತಿ
VN
and ಸಾವಿತ್ರಮ್ಮ ಇವರು ಇಬ್ರು ಕೋ ಓನರ್ಸ್, ಮಹಾದೇವರಾವ್ ಅಂಡ್ ರಂಗರಾವ್. ಸರಸ್ವತಿ ಅಂಡ್
ಸರಸ್ವತಿ ಚಂದ್ರಶೇಖರ್.
ಅದರಲ್ಲಿ
Defendants ಅವರೇ ಇಲ್ಲ.
ಯಾರು?
Defendant Savitrama, Venkatesh, Vishwa.
Who is this Chandrasekhar?
He is a son of D5, the grandson of.
ಅಲ್ಲ ಈ C degree ತೋರಿಸಿ ಇದನ್ನ ಕೊಟ್ಟಿದಿರಲ್ಲ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಅಂತ ಪೇಜ್ ನಂಬರ್ 6 ಅಲ್ಲಿ. ಅವ್ರ ಅದ್ರಲ್ಲಿ ಇಲ್ವಾ ಅದ್ರಲ್ಲಿ?
ಇದರ D4 ಅಂತ.
D4 and D5 ಅವರು.
D4 and D5.
They are
the branch of Rangarav.
They are the branch of Rangarav. The opposite Savitrama, Venkatesh, Vishwa are branch of Madhura.
ಈಗ ಸಾವಿತ್ರಮ್ಮನ್ನೇ ಪಾರ್ಟಿ ಮಾಡಿದ್ಮೇಲೆ ಅದ್ರಲ್ಲಿ ಮತ್ತೆ ವೆಂಕಟೇಶ ವಿಶ್ವ ಇವ್ರು ಈ ಸೂಟ್ ಇಂದ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ತೋರಿಸಿದ್ ಈ ರಿಲೇಟಿಂಗ್ ಟು ದ ಪ್ರೆಸೆಂಟ್ ಸೂಟ್ 2016 ಸೂಟ್ಗೆ ಅದು
ಹೌದೌದು. ಇದು 16 ಸೂಟ್ ಅವ್ರು ತೋರಿಸಿರೋದು.
2015 ಸೂಟ್ 15 ಸೂಟ್ ಅಲ್ಲಿ ಇವರು ಎಲ್ಲೆಲ್ಲಿ ಬರ್ತಾರೆ? ಚಂದ್ರಶೇಖರ್ ಚಂದನ,
ಅವರು ಇದ್ದಾರೆ.
ಚಂದ್ರಶೇಖರ್ ಚಂದನ.
Our plaintiff 2, plaintiff 3 in old suit.
P2, P3.
Also.
ಅಲ್ಲ ಇದರಲ್ಲಿ
Ashwath Narayana and CR
They are
Nagesh.
4 and 5 of the old suit.
P4 and Nagesh, P5. Then defendant Savitramma, Venkatesh, Vishwa. Savitramma, Venkatesh, Vishwa.
That is first branch, Madhavra's branch.
D2, D3 idru.
Yes.
And Savitramma was D1. D1. ಇವ್ರು 3 ಜನ ಅಷ್ಟೇ ಇದ್ರು. ಇನ್ನೊಂದು ಬ್ರಾಂಚ್ ಡಾಟರ್ಸ್ ಬಿಟ್ಬಿಟ್ಟಿದ್ರ? ರುಕ್ಕಮ್ಮ, ಲಲಿತಮ್ಮ, ಲಕ್ಷ್ಮೀ ನರಸಮ್ಮ, ವಿಜಯಲಕ್ಷ್ಮಿ. ಅವ್ರು ಇನ್ನೊಂದ್ ದಿವಸ ಅವ್ರೊಂದು ಸೂಟ್ ಹಾಕೊಂಡ್ ಬರ್ತಾರೆ. ಆಮೇಲೆ
Already ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದ್ದಾರೆ.
ಅವರು ಒಂದು ದಾವ ಹಾಕಿದ್ದಾರೆ.
This is clear accuse of the process of.
ಅಲ್ಲ ಇದು ಅದಕ್ಕೋಸ್ಕರನೇ ಈ ದಾವಾಗಳು ಇರ್ಬೇಕಾದ್ರೆ ಆ ದಾವಾಲೇ ಇವರೆಲ್ಲ ಅಜಿಟೇಟ್ ಮಾಡ್ಕೋಬಹುದು. ದೇರ್ ಇಸ್ ನೋ ನೀಡ್ ಫಾರ್ ದಿಸ್ ಸೂಟ್ ಅಟ್ ಆಲ್.
My suit I will
ದಿಸ್ ಅದರ್ ಬ್ರಾಂಚ್ ವಿಜಯಲಕ್ಷ್ಮಿ.
ಹಾಗಲ್ಲ ಮೊದಲೇನ್ ಸೂಟ್ ಹಾಕಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡ್ರು ಅದ್ರಲ್ಲಿ ಇವನ್ ದ ಡಾಟರ್ ಶುಡ್ ಹ್ಯಾವ್ ಬಿನ್ ಪಾರ್ಟೀಸ್.
No, correct. They are not parties. Vijayalakshmi has now filed.
They also filed a suit.
In Vijayalakshmi, that is in the other branch of suit, all of us are parties.
Vijayalakshmi's?
That is below the other branch.
What is the
Ashwatthayya's other branch.
ಅಲ್ಲ, ಈ
Rukminamma,
Vijayalakshmi-
Lalitamma, Lakshmi Narasimha,
Correct.
Vijayalakshmi.
Now what is the suit filed by the daughters?
That suit, that is also suit for partition.
ಎಲ್ಲ ಏನಿಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್ ಮಾಡಿ ಅಬ್ಯೂಸಿಂಗ್ process of the court ಅಂತ ಎಲ್ಲರಿಗೂ they should be dealt with properly. ಇಲ್ಲ this is so much of diversion of the court's time. Public time. Court's time means public time and public resources. Now what is the suit filed by the daughters?
Now this daughter is OS 764 in the application or production of documents, it is
OS
at page 17.
764 ಬಲ ಯಾವ
Seven- 764 of 2019.
ಈಗ ಇಷ್ಟೆಲ್ಲ ಆದ್ಮೇಲೆ ನೀವು ಯಾವ್ದು ಸೂಟ್ಸ್ ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ ಒಂದಕ್ಕೊಂದು, ಎಲ್ಲ ಬೇರೆ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲೇ
ಇಲ್ಲ,
ಇರ್ತದೆ.
ಇಲ್ಲ, I will first 15 ಅಲ್ಲಿ ಒಂದು suit filed, my lord. First suit was filed in 2015.
Now
That was compromised.
not pending now.
Not after compromise, second suit they filed in 2016.
Present suit.
The present. That was pending consideration.
Like
The writ petition, they sold some properties in 2018.
ಹೇಳಿದ್ವಲ್ಲ,
ಅಲ್ಲ,
ಅವ್ರು
ಒಂದು
ಕೇಳಿದ್ವಿ. ಹ.
Subsequently, 22 they filed writ petition. After that, my lord, they filed this application. In the meantime, we filed the application.
ಎಲ್ಲ ಯಾವ್ಯಾವ ಸೂಟ್ ಇದೆ ಎಲ್ಲ ಒಂದು ಟೇಬಲ್ ಮಾಡಿ.
ಅಲ್ಲ ಡಾಟರ್ಸ್ ಸೂಟ್ ಹಾಕಿದ್ದು
ಅದು 19 ಅಲ್ಲಿ later onwards.
ಕರೆಕ್ಟ್ 19 ಸೂಟ್. ಈಗ ದಿಸ್ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ಡ್ ಇನ್ 2022 ಅಲ್ವಾ? ಸರಿ, ದಿಸ್ ಪ್ರೆಸೆಂಟ್ ಆರ್ಡರ್ ಅಂಡರ್ ಚಾಲೆಂಜ್ 2009 ಬರ್ಕೊಂಡಿದ್ದೀವಿ ಆರ್ಡರ್ ಅಲ್ಲಿ. ಅಲೋಡ್ ಆನ್ ಸಪೋರ್ಟ್ 2000 ದಿಸ್
That
7 is
is allowed on 4th December 2023.
23 ಅಲ್ಲಿ.
ಹೌದು.
So by this order, by the time of this order, this daughter suit was pending. ಅದನ್ನೆಲ್ಲ ತಗೊಂಡ್ ಬಂದು ಸೇರಿಸ್ಲಿಲ್ಲ.
ಅದು ಇಲ್ಲ.
ಆ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ ಇನಿಷಿಯಲಿ.
ಇಲ್ಲ ಇದೆ
ಡಾಟಾ ಸೂಟ್ ಅಲ್ಲಿ
ಇದೆ ಇದೆ ಇದೆ.
ಆಮೇಲೆ ನಾವೇ ಆಡ್ ನಾವೇ ಇಂಪ್ಲೀಡ್ ಆದಂಗಿದೆ ಅದು.
ಈ6 ಅಳಿಯ ಒಂದು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಈಗ. What is that?
ಅಲ್ಲ, all of us are parties. I have produced the plaint at page 17.
06 of 2019.
1061 of 2019.
ಅದನ್ನ ಈಗ ಮೆನ್ಷನ್ ಮಾಡಿದಿರಲ್ಲ 106. ಇಲ್ಲ, ನೀವೀಗ ಕೊಟ್ಟಿರೋ ಲಿಸ್ಟ್ 06 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರ?
ನಾರಾಯಣ ಯಾರಿದು?
ಇನ್ನೊಂದು 8026 of 2023 ಅಂತ ಒಂದಿದೆ ಅಂತ.
That is recent suit filed by father of the plaintiff 2 and 3.
ಇದ್ರಲ್ಲಿ ನಮಗೆ ಸಮನ್ಸ್ ಬಂದಿಲ್ಲ ಇನ್ನ ನಮಗೆ.
ಈ ಎಲ್ಲಾ ಕೇಸಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಗಳಲ್ಲಿ ನೀವೇ ರಿಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತೀರಾ? ಅಂದ್ರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಆನ್ ರೆಕಾರ್ಡ್?
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ, ನಾವ್ ಯಾರು ಇಲ್ಲ, ನಾವೆಲ್ಲ ಹೈಕೋರ್ಟ್ ಅವರು ಅಷ್ಟೇ.
ಅಲ್ಲೇ ನೀವು ಅಡ್ವೊಕೇಟ್ಸ್ ಆನ್ ರೆಕಾರ್ಡ್
ಇಲ್ಲಿರೋರು ಹೈಕೋರ್ಟ್ ಮಾತ್ರ ಅವ್ರು ಇದ್ದಾರೆ.
I was representing the plaintiff
We are
in the
not
second
there.
suit. In the second suit, I came in the middle. Then we filed application for amendment and also argued the 7 to 11. Place the case law.
ಈಗ ಇನ್ನು there are another host of cases.
ಅದು ಬೇರೆ ಕೇಸ್ ನಮಗೆ ಇನ್ನೂ ಸಮನ್ಸ್ ಬಂದಿಲ್ಲ. ಯಾವುದು 2023 ಸೂಟ್.
ಅನ್ನೋರು ಯಾರೋ
ನಮ್ ತಂದೆನೆ ಹಾಕಿದ್ರು.
19
ಅದು ಇದು ಬಂದಿಲ್ಲ, ಅದು ಈಗ ಇವ್ರಿಗೆ ನೆನ್ನೆ ಕೊಟ್ಟಾಗ ಗೊತ್ತಾಯ್ತು ನಮ್ಗೆ.
ಒಳ್ಳೆ ಗ್ಯಾಂಬ್ಲಿಂಗ್ ಮಾಡ್ದಂಗ ಆಗುತ್ತಲ್ರಿ. ಅಲ್ಲೊಂದ್ ಕೇಸ್ ಎಲ್ಲಿ ಎಷ್ಟು ಸಿಗುತ್ತೆ ಸಿಗದೆ ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ನಾವು ಈ
ಅದು-
the guise of deciding this application, now we direct all the cases to
To be brought to one court.
No. And why action we request the Chief Justice to initiate contempt proceedings against all these parties.
I think in some case it is required, certainly.
ಅಂದ್ರೆ ಮತ್ತೆ ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗ್ಲಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಒಬ್ಬರೇ ಇದಾರ ಬೇರೆ ಇದಾರ? Are you aware of this?
I am representing the plaintiffs. in
Other
trial
side
court.
representing for this branch for all suits.
All suits ಅಲ್ಲಿ ನೀವು represent
ಹೌದು, ನಾನು ಈ plaintiffsಗೆ.
ಅಶ್ವತ್ಥನ್ ಕೇಸ್ ನಲ್ಲೂ ನೀವೇ ಇದೀರಾ?
ಅಶ್ವಥ್ ಕೇಸ್ ನಮ್ಗೆ ಇನ್ನೂ ಸಮನ್ಸ್ ಬಂದಿಲ್ಲ ನಮ್ಮ ಕ್ಲೈಂಟ್ಸ್.
ನಿಮ್
Next.
ತಂದೆನೇ ಆದ್ರೆ ಹಾಕಿ
ಹಾಕಿದ್ರೆ ನಿಜ,
ನಿಮ್
ಆದ್ರೆ ನಮ್ಗೆ ಇನ್ನೂ ಸಮನ್ಸ್ ಬಂದಿಲ್ಲ.
ಅಲ್ಲ, ನಿಮ್ ಜೊತೆಗೆ ವಾಸ ಇದಾರೆ ಬೇರೆ
ಇಲ್ಲ, ಬೇರೆ ಇದ್ದಾರೆ.
ಅಲ್ಲ, ಸಮಸ್ಯೆ ಇವ್ರ ತಂದೆನೇ ಹಾಕಿದ್ದಾರೆ. ಇವ್ರು ಏನು
ಕೇಳೋಣ, ಯಾಕಂದ್ರೆ ನಾವು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಮಾಡ್ತೀವಲ್ಲ ಅದಕ್ಕೆ.
ಸೂಟ್ಗೋಸ್ಕರ
ಇಲ್ಲ, ಅದರಲ್ಲಿ
It's very bad.
Yes.
It's very, it should be discouraged, these kinds of litigating.
ಅದು ನಮಗೂ ಗೊತ್ತಿರಲಿಲ್ಲ. We went on collecting it, then we came to know all
ಇವರು
this.
ನೆನ್ನೆ ಕೊಟ್ಟಾಗ್ಲೇ ಗೊತ್ತಾಯ್ತು ನಮ್ಗೆ.
ರಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ರು ಅವ್ರಿಗೇನು ಮತ್ತೆ ಇದೇ ರೀತಿ ಮಾಡ್ತಾ ಇರ್ತಾರಲ್ಲ ಅಲ್ಲಿ. ಇನ್ನೊಂದ್ 4 ಕೇಸ್ ಹಾಕೊಳ್ತಾರೆ ಇದನ್ ಬಿಟ್ಟು.
The rule is
Order to
lateral suit.
The Contempt of Courts Act's provision.
Very
But request,
Yes.
if at all it is permissible, will request to initiate the proceedings against all these parties for contempt.
Being a party in one suit without disclosing, filing another suit in another court.
ತಂದೆ ಮಾಡಿದಾರೆ ಅಂತ
ನಿಮ್
ಹೇಳ್ತಾ
ಅಲ್ಲಿ ನಮ್ಮ ತಂದೆ ಮಾಡಿದ್ರೆ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ, ನಾನು ಈಗ ನನಗೂ ನೆನ್ನೆ ಗೊತ್ತಾಯ್ತು ಇವ್ರು ಕೊಟ್ಟಾಗ.
ಇಲ್ಲ. ಇಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡು ಅಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡ್ತಾರೆ ವಿತೌಟ್ ಪರ್ಮಿಷನ್.
ಎಲ್ಲ
ಮಾಡೋದು.
ಎಲ್ಲಿ ಅವರಿಂದಾನೆ ಸ್ಟಾರ್ಟ್ ಆಗಿರ್ತದೆ. ವಿಲ್ ಶೋ 1 by 1 ಮಿಲಾಡ್ 2 minutes ಮಿಲಾಡ್ ಮೇ ಕೈಂಡ್ಲಿ ಲುಕ್ ಅಟ್ ಮಿಲಾಡ್
ನೋಡಪ್ಪ.
ಪ್ಲೀಸ್ ಮಿಲಾಡ್.
ಈಗ
ಇಲ್ಲ ಮಿಲಾಡ್ ಫ್ಯಾಕ್ಚುಯಲ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ ವಾಟ್ ಆರ್ ದೇರ್.
ಈಗ
ನಾನು one of
It's
the
a mechanism.
parties
All
representing
this
here
will be
in the
tried.
court. I
wherever
will show
parties
before
have
the
been
court, Milord, how these things have happened, Milord, may kindly look at Milord. Only 2 minutes my argument. Supporting my senior's argument, Milord.
Yes.
Continuation. Milord, may kindly look at the first suit filed on 896 of 2015 on 7/12/2015. Milord, suit for partition and separate possession filed by Saraswati LRs in respect of 4 properties. Milord, wherein the defendants, Milord, and voluntarily, all the defendants and plaintiffs, Milord, appeared before the court and entered into the compromise petition, agreed the terms of compromise petition. These are the properties available. These are the scheduled properties available for partition. The only they mentioned, Milord, in paragraph 5 of the compromise petition, only paragraph 5 may kindly look at, Milord, page 249. The plaintiffs and defendants have amicably agreed to take their respective off shares in the suit scheduled properties as to a scheduled properties.
I'll ask you one question. Why did you left out the daughters there? You are trying to justify that decree, compromise decree. This suit was filed in 2000. By that time, this Amendment Act 1990 had come into force.
But these are the properties of only Madhavrau's, Madhavrau's self-acquired properties are there and Rangarau's self-acquired properties. Partition was affected between the Madhavrau and.
Property and here partition ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
Your lordship may kindly look at one pleadings may kindly look at in the plaint. That plaint may kindly look at, Milord. Para
ಯಾವ plaint?
896.
896 of 2015 ಮೊದಲಿಂದ. Where is that plaint copy?
The earlier suit plaint is at 104.
Page number 104.
104.
Your lordship, para 3, it is referred and stated that it is respectfully submitted the husband of the first plaintiff, late Rangarao, and his younger brother Madhavrao constituted joint family and genealogical so and so produced.
So
Please,
the joint family.
one minute, please kindly look at next. The lands which are acquired by both Rangarao and Madhavrao remained as a joint status. The lands which remain joint family properties are mentioned herein. Milord, please kindly appreciate this. Only Madhavrao and Rangarao have jointly acquired these properties. Please kindly ascertain.
Acquired ಅಂತ ಹೇಳಿ ಹೇಳಿಲ್ಲ ನೀವು.
ಇಲ್ಲ ಹೇಳ್ತಾರೆ. Lands which were acquired by both Rangarao and Madhavrao.
Miscellaneous Inam's abolition ಕೆಳಗಡೆ ಆಗಿದ್ದು.
Allah, those lands are Milord next part, next in their contention is that Milord may kindly look at here. Some of the lands which are acquired. Para 3.
Madhavrao and now shows that pedigree,
Genealogical 3, Milord may kindly look at Madhavrao and Rangarao.
ಅಲ್ಲ ಡಾಟರ್ಸ್ ಅನ್ನು ಸೇರಿಸ್ಕೊಂಡಿದ್ದೈತಲ್ಲ ಇಲ್ಲಿ.
At page 94 of the appeal papers, you'll also find 94. There is a G3, the part of
ಮಾಧವರಾವ್ ಅಂಡ್ ರಂಗರಾವ್.
ಹೌದು.
ಇದರಲ್ಲಿ ರಂಗರಾವ್ ಇವ್ರಿಗೆ ಡಾಟರ್ಸ್ ಇಲ್ಲ, ಈಗ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಕೊಟ್ರಲ್ಲ ಡಾಟರ್ಸ್ ಹೆಸರು ತೋರಿಸಿದೊಂದು.
ಇದ್ರಲ್ಲಿ ಇದ್ದಾರೆ.
ಅದು IA along with production of documents.
2024.
IA 4 of 2024, one document family tree produced. Your lordship may kindly look at that page number.
That needs to be verified by us, Lord. We have not just got it yesterday.
IA 4 of 2024.
Yes.
Madhavrao Rangarao.
Rangarao.
Madhavrao Rangarao has the sisters. This
They are the sisters.
Lalitamma. ಈಗ you claim to have acquired the property through Ashwatthaya or?
No. These are jointly brothers have acquired these properties, only brothers.
What is the record for they acquiring it jointly? What is the source of their title?
Milord, for that they stated that Milord in the suit schedule properties, some deeds have produced before the court, Milord, documents.
What is your case? These were inherited from this Ashwatthaya or they are?
No. Ashwatthaya is concerned, there is no role at all. The only we shown before the court who are the branches of family. For that Ashwatthaya name has been referred in the family tree. But the entire case before the parties, Milord, these are acquired by brothers jointly, and out of these properties, Milord, as the joint family properties, Madhavrao died, Milord, is on 1/9/1997. Please kindly note down, Milord, para 4 of the plaint, page 106.
ಅಂದ್ರೆ ಜಾಯಿಂಟ್ ಎಕ್ಸರ್ಷನ್ ಇಂದ ಅಂತನಾ ನೀವು
Yes,
ಹೇಳೋದು?
yes, Milord, for that purpose only. When the properties have been,
One second. At page number?
page 106, para 4. Please kindly look at 106. Appeal memo. Para 4.
Yes, one.
I want to show before the court, Milord, is the date of knowledge and acquisition.
Suit, 2015 suit.
Earlier suit, Milord, my entire argument before the court.
Yes, para 4.
Yes, Milord. The respectfully submitted that Madhavrao died on 1/9/1997. After the death of Madhavrao also, aforementioned properties remained in joint, it became joint family property, which were disputing regarding the joint family properties. Thereafter, the parties have settled their dispute properties remained as a joint family properties. After the death of, yeah, Milord, my contention before the court is that as on the date of filing of the suit, the properties are, these properties are available for partition in the earlier 2015. Till 2015, when I filed the suit in respect of these properties is concerned, that is the branch of Rangarao family filed a suit for partition. These are only the properties available for partition which were not affected between the family members. Insofar as other properties is concerned, earlier there was a acquisition and the properties have been divided and they have sold independently to their respective shores. That is forthcoming from the further pleadings in their own second suit. Milord, in 1960, 65, 69, 70s, their properties have been sold. While selling the properties, yes, Milord, while selling these properties, what was the right to sell the property if it is a joint family property? The moment of the selling of the property itself, there is an aware, they were very well aware about the knowledge regarding the source of title. Therefore, they sold the properties. Once they sold the properties, in 2016 come and saying that these are properties are available for partition. By oversight, we have not able to implead those properties in the earlier suit. That cannot be a case before the court. In the second suit, they cannot take such a contention. Therefore, order 2 rule 2 is there, Milord. Milord, once moment they filed in.
Which of the defendant in this case?
I represented for respondent 1 and 2. That is plaintiffs in OS 896 of 2000. Plaintiffs 4 and 5.
846 of 2016 ಅಲ್ಲಿ ಯಾವ defendant?
8 and 2. Yeah, I am representing for 1 and 2 and 3 now. 1 died ಆಗಿದ್ದಾರೆ, 2 and 3 alone.
Ashwath
Narayana and Nagesh.
Contesting defendants.
That is Rangrao Children's, my lord, I am representing. But my submission before the court is entire argument is only that point. Once they filed a suit,
Kindly excuse my.
my lord, earlier they filed a suit. In that suit, my lord, which are the properties are not divided, not available, only available properties are made as a parties. And the parties, my lord, has very well within the knowledge, therefore they affected the partition in terms of compromise.
ಅದೀಗ ನಾವು ಅದೆಲ್ಲ ಹೇಳಕ್ ಆಗೋದಿಲ್ಲ ಯಾಕಂದ್ರೆ ರಿಟ್ ಪಿಟಿಷನ್
Allala.
ಇಲ್ಲ ಹೇಳಕ್ ಆಗೋದಿಲ್ಲ.
Madam, my submission before the court, writ petition filed in after lapse of selling the properties.
You can question that.
Allah, we are questioning, your lordship question before the court is.
And you get that.
My argument before the court, my lord, is only with regard to the knowledge of the parties in the second suit while filing, while and including these properties is concerned.
Evidence alva knowledge ಎಲ್ಲ order.
Allah, knowledge is concerned. When the property sold by your father in 1965, 1969 and 70, 72.
See, order 7 rule 11, you can't go into the evidence. You have to look at the plaint and based on that you have to decide.
Plaint, that's why.
7 rule 11, order 2 rule 2 they have invoked.
Therefore.
Means your
2 rule 2.
ಬೇರೆ ಇನ್ನೊಬ್ರು ಯಾರೋ ಹಾಕಿದ್ರು ಅಂದ್ರಲ್ಲ.
ಹೌದೌದು ಇವರಲ್ಲ.
Your lordship now kindly turn to page number 69 of the present plaint, which is arising out of order 2 rule 2 or 7 rule 11 application.
Page
That
69 is.
Plaint. Please kindly look at the what they stated before this honorable court, my lord, is in para 3. Plaintiffs Madhav Rao was granted 10 items of agriculture lands in so and so under the provisions of.
Para 3.
Para 3A.
3.
These property, your lordship may kindly see, Madhav Rao was granted 10 acres. My lord, not by the other branch or sisters filed a suit. That is concerned my submission before the court. Lakshmaman yaak party madilla, others daughters yaak party madilla. This is my answer. Not here, granted the person who cultivating the.
We do not know because we do not know what has happened and ಯಾಕಂದ್ರೆ we are seeing these cases. We are seeing that both parties are joining each other whenever it is convenient for them. Whenever it is not convenient, they are resigning.
My submission before the respectable submission before the court is that from the reading of plaint amendments, I am pointing out before the court which are the properties who acquired under the undisputed point of time. Why the others are not required to make as a parties in the suit for partition is concerned my submission. Here the contention before the court is that Madhav Rao was acquired, granted the lands.
So what is their contention? Their contention is it's father's property.
Under the, they are saying not father property. These are the properties acquired under the Inam Abolition Act, not an individual capacity. It is a joint family on behalf of Madhav Rao filed.
If that is the case, that father must have been Inamdar.
That is a matter of trial.
See.
It's a matter of trial.
For that is concerned.
Personal Inams.
This is a.
Hereditary officer.
Not that. This is a personal and miscellaneous Inam Abolition.
In his individual name, it was granted. ಅದನ್ನ ಇವ್ರು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತೇಳಿ ಅವ್ರ ಬ್ರದರ್ಗೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ರು. ಅದರಲ್ಲಿ ಅವ್ರದ್ದು ರೆಕಾರ್ಡ್ ಅವ್ರು ತೀರೋದ್ಮೇಲೆ ರೆಕಾರ್ಡ್ ತಮ್ಮ ಹೆಸರು ಸೇರಿಸ್ಕೊಂಡು 1 second. ವಾಟ್ ಇಸ್ ದಿ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ WP ನಲ್ಲಿ ಅದೇ ತಮ್ಮ ಹೆಸರು ಸೇರಿಸ್ಕೊಂಡು ಅವರು ತೀರೋದ್ರು, ಅವ್ರ ಮಕ್ಕಳು ಈಗ ಅದ್ರದ್ದು ಅಡ್ವಾಂಟೇಜ್ ತಗೊಂತ ಇದ್ದಾರೆ.
My submission.
The Personal and Miscellaneous Inams Abolition Act 1954 ಅಂತ ಇದೆ.
My submission before the court.
This is not hereditary Inam.
Not hereditary. It is an individual capacity who cultivating personally.
During his lifetime, it was granted to him. Therefore, it became his property. Madhav Rao.
ಅವ್ರು Madhav Rao ಅಂತ ಒಪ್ಕೊಂತ ಇದ್ದಾರೆ.
ಇದು ಅರ್ಲಿಯರ್ ಕಾನ್ಸೆಪ್ಟ್ ಜಸ್ಟಿಸ್ ಸ್ವಾಮಿ ಅವ್ರ ಜಜ್ಮೆಂಟ್ ಇದೆ ಅಲ್ಲ, ಅದು ಬರ್ಬೇಕು ಅಂತಂದ್ರೆ ಇಟ್ ಶುಡ್ ಹ್ಯಾವ್ ಬೀನ್
ಅಶ್ವಥ್ ನಾರಾಯಣ ಹಾಕಿರ್ಬೇಕಾದ್ರೆ
ಹೆರಿಡಿಟರಿ ಆಗಿರ್ಬೇಕಾದ್ರೆ
ಅಶ್ವಥಯ್ಯ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ಆಗಿ ಡೆತ್ ಆಗಿದ್ರೆ ದೆನ್ ಸನ್ಸ್ ಆರ್ ಎಂಟೈಟಲ್ಡ್. ಹಿಯರ್ Madhav Rao himself has filed. But my submission before page number 69 is enough, my lord, my argument. 69 shows that in the my submission only while 2016 second suit filed, they are
ಯಾವ್ದಾದ್ರು ಜಜ್ಮೆಂಟ್ ನೀವು ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ನಾವು ತಾವು ಒಂದು ಪ್ರಶ್ನೆ ಕೇಳಿದ್ರಿ, whether this WP pendency of WP was brought before. Yes, it is part of it. It is applicant himself has filed written submission pointing out that on 7th of October 20,
ರೆಫರೆನ್ಸ್
reference ಇಲ್ಲ, impugned order reference ಇಲ್ಲ. But ಇದು ಅವ್ರ ಗಮನಕ್ಕಂತೂ ತಂದಿದ್ದಾಗಿದೆ.
ಏನಿತ್ತು?
This is the, ಇಲ್ಲ ನಾನು ತಮ್ಮ ತೋರಿಸ್ತೀನಿ certified copy. It is the written submission filed by the applicant under 7-11 stating that such a writ petition is filed.
Challenging the.
I'll make copies and that. That is the written submission.
You don't require defendant number. That was, he was the applicant ಅಲ್ವಾ?
He was the applicant at 7-1. ಅವ್ರದ್ರಲ್ಲಿ ಅವರೇ.
ಫ್ಯಾಕ್ಟ್ಸ್ ಏನಾರ ಇದ್ರೆ ಕೇಳ್ತೀವಿ ಹೇಳಿ ಅಷ್ಟೇ.
Very well.
Challenging the rejection of the claim. Exercising the powers and the order 7-11. D. The plaintiffs in OS number 846 of 2016 put on the file of senior civil judge and JMFC Devanhalli have preferred the above appeal. One Savitramma and the present appellants filed OS number 846 of 2016. Initially against ಯಾರು record ಅಲ್ಲಿ ಬಂದಿರೋ initially suit was filed against who?
Response 1 to 4.
1 to 4. ಅಲ್ಲ
ಹೌದು.
ಚಂದನ ಅನ್ನೋರು ಇದ್ರಲ್ಲಿ this Narayan BL who subsequently got impleaded?
Himself he applied for impleadment.
Narayan.
ಹೌದು.
He subsequently. 1 to 5. Initial against response 1 to 5. ಏನ್ ನಿಮ್ದು relief? Prayer in the plaint ಅಲ್ಲಿ?
Page 104 earlier suit plaint.
Earlier.
ಈ suit milord is prayer 84. Page number 84 milord.
Seeking declaration that they have half share in plain scheduled properties
Did.
for partition and separate position of the half share, etc. Subsequently, respond number 6 hearing got impleaded himself as defend number 6.
ಹೌದು. Response number 5.
Number 5.
Under present response number 5.
Respond number 5 got himself impleaded. ಆ ಸರಸ್ವತಿ ಅನ್ನೋರು ತೀರೋಗಿರೋದ್ರಿಂದ ನಂಬರ್ ಕಡಿಮೆ ಆಗಿದೆ. ನಾವಲ್ಲೇನೋ ನಂಬರ್ ಅಲ್ಲ ಅಲ್ಲಿ ಡಿಫೆನ್ಸ್ ರೆಸ್ಪಾನ್ಸ್ 1 to 5 ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ರೆಸ್ಪಾನ್ಸ್ 1 to 4 and one ಸರಸ್ವತಿ ಅಂತ.
He is the father of respond number 3 and 4.
Respond number 5 got himself impleaded as defend number 6. The subject matter of the suit were all 20 properties, 20 immobile properties, 20 immobile properties. The plaintiffs claimed that their grandfather, alva? The plaintiffs.
Grandfather.
Plaintiffs claimed, admittedly, that relationship is not in dispute.
No.
The plaintiffs and defendants claim through the two brothers by name Madhavrao and C. Rangarao. Savitramma was the plaintiff number 1, Savitramma, and defendant number 1, Saraswati, are the wives of Madhavrao and Rangarao respectively. Plaintiffs 2 and 3 are the sons of Madhavrao and Savitramma. Defendants 2, 3 and 6 are the children, are the children of Rangarao. Defendant number 4 and 5 are the children of define number 6. Define number 6. And his wife Padma. The plaintiffs contended that Madhav Rao and Rangarao constituted joint Hindu family. They possessed several immovable properties. Out of the income of those immovable properties, they alienated. ಅದು ಯಾವ್ದೆಲ್ಲ ಎಲ್ಲೋ ತೋರಿಸಿದ್ರಲ್ಲ ನೀವು
Page 69.
69.
17 alienation has been shown. Para 3B, my lord.
Please take your seat.
Yes.
ಎಷ್ಟು ಪ್ರಾಪರ್ಟೀಸ್ ಅದು?
6 items properties sold by Madhav Rao, page 73B, para.
3A ನಲ್ಲಿ ಅವು ಯಾವ್ದು?
ಯಾವ್ದು ಇದೆ ಅಂತ ಗ್ರಾಂಟ್ ಆಗಿರೋದು. 10 properties acquired under the Inam Abolition Act and sold 6 items out of them.
Family, joint family. They possessed. They jointly acquired 10 properties shown in para 3A of the plaint under by way of grant under Personal and Miscellaneous Inam Abolition Act. In case number 4 of 1959-60. 59-60. Ask your parties to take their seat. ಯಾಕೆ ನಿಂತ್ಕೊಳ್ತಿರ್ತಾರೆ ಅಲ್ಲಿ? ನಿಮ್ ಪಾರ್ಟೀಸ್ ತಾನೆ? ಏನಾದ್ರೂ ಎಲ್ಲರೂ ಸೇರಿ ಎಲ್ಲ ಬ್ರಾಂಚ್ ಇಂದ ಸೆಟ್ಲ್ ಮಾಡ್ಸಕ್ ಆಗತ್ತಾ? ಎಸ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಪಾಟೀಲ್,
I'm sorry.
ಎಲ್ಲರನ್ನು ಕೂಡಿಸಿ ಏನಾದ್ರು ಸೆಟ್ಲ್ ಮಾಡ್ತೀರಾ? ನಾವಂತೂ we are going to make an observation. These parties are abusing the process of the court. They should be dealt with ಅಂತ. ಅಲ್ಲ ಹಾಗಾದ್ಮೇಲೆ ಮಾಡ್ಕೊಳಕ್ಕೆ
In the general interest of the litigation, the multiple suits ಅಲ್ಲಿ ಹಾಕೋದು ಇಲ್ಲ ಹಾಕೋದು ಕೆಲವೊಂದು ಹಾಕೋದು ಕೆಲವೊಂದು ಬಿಡೋದು ಒಂದ್ ಕೇಸಲ್ಲಿ ಆಚೆ ಬರ್ತಾ ಇದೆ. ಇಂಥವು ಸಾಕಷ್ಟು ಇದಾವೆ.
ಇಂಥದ್ದಿದೆ ಸಾಕಷ್ಟು. ನಮ್ ಡೇ ಇನ್ ಅಂಡ್ ಡೇ ಔಟ್ ವಿ ಕೀಪ್ ಸೇಯಿಂಗ್ that too when these urban properties value has ಇದು ಇವ್ರೇ ಹೊಡೆದಾಡ್ತಾ ಇದ್ದಾರೆ. ಇನ್ನ ಕೆಲವೊಂದು ಕೇಸಲ್ಲಿ 4 ಜನರಿಗೆ ಒಂದೇ ಪ್ರಾಪರ್ಟಿನೇ ಸೇಲ್ ಮಾಡ್ತಾರೆ. Subsequently, they alienated those properties out of the income derived from such alienation. They carried a joint family business. They further claim that out of such joint family income, income from such joint family business, the suit schedule properties were acquired. They 8 ಮೊದಲಿನ ಸೂಟ್ ಹಾಕೊಂಡಿದ್ದ ಯಾವುದು 896 of 2050.
So lordships find the plaint.
Next paragraph. Admittedly, branch of Madhav Rao ಅಲ್ಲ ರಂಗರಾವ್ ಹಾಕೊಂಡಿದ್ದು ಸೂಟ್ ಮೊದಲಲ್ವಾ?
Rangarao branch.
The wife and children, that is plaintiff number ಯಾರು ಈ ಕೇಸಲ್ಲಿ ಇರೋರು ಎಲ್ಲರೂ ಬರ್ತಾರೆ.
ಈ ಕೇಸ್ನಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ 1 to 4
present defendants 1 to
5.
1 to 5. Filed OS number 896 of 2015 against the present plaintiffs
Yes, ma'am.
for partition and separate possession of ಏನ್ ಕೇಳಿದ್ರು ಅದರಲ್ಲಿ half share.
Half share in the
ಅದರ ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲಿದೆ ಅದರಲ್ಲಿ?
4 items.
only 4 items A, B, C, D. A, B, C, D.
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿಲ್ವಾ?
Page 108 schedule.
ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಕಾಣ್ತಾ ಇದೆ. ಶೆಡ್ಯೂಲ್ ಅಂದ್ರೆ 108.
108 also.
They are not part of this plaint.
ಇಲ್ಲ 108 is
Schedule properties.
ಏನಾಗಿದೆ ಅಂದ್ರೆ ನಮ್ದು
108 schedules ಇದೆ sir.
very small print.
ABCD.
ಏನ್ ಬಿಟ್ಕೊಂಡ್ರಿ? Separate possession of ಏನ್ ಹೇಳಿದ್ದಾರೆ? their half share in the suit schedule properties. Subject matter of that suit were only 4 immovable properties. 4 immovable properties. Subsequently, the parties to the said suit entered into a compromise on 14/3/2016 ಲೋಕ ಅದಾಲತ್ನಲ್ಲ
ಇಲ್ಲ ಇದು ಫೈಲ್ಡ್ ಕೋರ್ಟ್ ಅಂಡ್ ರೆಫರ್ಡ್ ಟು ಲೋಕ.
ಅಲ್ಲ ಕೋರ್ಟ್ ರೆಫರ್ ಮಾಡಿದ್ದು ಲೋಕ ಅದಾಲತ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿ ಅವಾರ್ಡ್ ಆಗಿ ಬಂದು ಡಿಗ್ರಿ ಮಾಡಿದ ಕೋರ್ಟ್ನವರ ಅಥವಾ ಅಲ್ಲೇ
ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಲೋಕ ಅದಾಲತ್ನಿಂದ ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ.
ಅಲ್ಲ ಸರ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಮಾಡಿ at the request of the parties the said suit was referred to Lok Adalat. Before the Lok Adalat they filed the compromise petition. Before the Lok Adalat
At page number 253.
So OS number 896 of 2015 filed compromise petition on 14/3/2016. And that matter was settled. In terms of that settlement, decree was drawn. The suit was decreed on 14/3/2016. Subsequently, the plaintiff side OS number 846 of 2016 claiming that when the settlement took place in OS number 896 of 2015, they were not aware of the present suit properties also being the joint family properties, and that decree, that compromise was fraudulent one, etc. Questioning the said compromise, Lok Adalat, so compromise decree entered into the Lok Adalat. The plaintiffs filed WP number 24,544 of 2022 before this court. In this suit, they claim that since the said decree was fraudulent one and all the properties were not included in the suit, they filed this second suit. They filed this suit for partition. Subsequent suit for partition. Subsequent to his impleadment in the suit, defendant number 6 filed IA number 6. Number 6 in OS number 896 of 2016. Seeking under Order 7 Rule 11 CPC, seeking rejection of the plaint on the ground that the same was barred, the suit was barred by Order 2 Rule 2 CPC. That was contested. Order 7 Rule 11 Rule 11D. Barred by law 11D. Two Rule 2 6. Okay. The plaintiffs filed their counter to the application and contested the application. The trial court, on hearing the parties by the impugned order, rejected the plaint on the ground that the suit was barred by Order 2 Rule 2 CPC. The said order is challenged in the above way. We'll continue in the afternoon. We'll continue in the afternoon.
Very well.
ಅಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ ಯಾರ್ದು ನೋಡಿ ಎಷ್ಟು ಕೋರ್ಟ್ ಟೈಮ್ ಹೇಗ್ ಹೋಗುತ್ತಲ್ವಾ ಇಂಥದ್ರಲ್ಲಿ ಜೆನ್ಯೂನ್ ಲಿಟಿಗಂಟ್ಸ್ ಯಾರು ಬಂದಿರ್ತಾರೆ ಅವ್ರಿಗೆ ದೇ ಡೋಂಟ್ ಗೆಟ್ ದ ರಿಲೀಫ್. ಅಲ್ಲ ನಿಮ್ಮದೆಲ್ಲ ನಾವು ನೋಡಿ ಇರೋ ಕೇಸಲ್ಲಿ ಹೇಳ್ತಾರೆ. ನಿಮ್ದು ಯಾವ್ದು ಕೇಸು? ಸೀರಿಯಲ್ ನಂಬರ್ 24.
Identical cases might not have ordered, say, not subject to condition 50% deposit, I will do that.
So you want the relief, you want the adjournment, both now? Or ಯಾರು ಅದರ್ ಸೈಡ್ ನೋಟಿಸ್ ಹೋಗಿಲ್ವಾ? ಏನ್ 50% ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ? Issue notice to the respondent, issue notice of I order 24 to the respondents. interim stay of the impugned award subject to the appellant depositing 50% of the award amount with accrued interest. The accrued statutory benefits before the trial reference court within ಯಾವ್ದು ನಿಮ್ BWSSB ನವರ within 4 weeks from the date of this. ಅದು 4 weeks ಬಿಟ್ರೆ 6 weeks ಕೊಡ್ತೀವಿ. Within 6 weeks from the date of this order, list all
27/9.
Before the reference court ಅಂತ ಹೇಳಿದ್ನ 27.
Your Worship, my lord, sir,
My lord,
small-
serial.
sorry for the.
ಡೆಮೋ
My lord, sir.
ಈಗ ಆಗೋದಿಲ್ಲ
For
ಮೆಮೊ
reporting settlement, my lords, tomorrow, my lord, sir.
ಈ
That's 2:30, my
132
lord. I'm very sorry, my lord, but morning I was.
ಈ ಪಾರ್ಟೀಸ್ಗೆ ಗೊತ್ತಾ ಅವ್ರು ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ರೆ ಅವತ್ತಿಂದ ಅವತ್ತೇ ಅವ್ರು ಯಾವಾಗ ತರ್ತಾರೆ ಏನ್ ತಗೊಂತಾರೆ ಅವಾಗ್ಲೇ ಕೇಳ್ಬೇಕು. ನಾವೇನಾದ್ರೂ
Lordship.
court ಹಳೆ ಕೇಸ್ಗಳಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಮಾಡೋದಿಲ್ಲ. ಫೇರ್ ಸೆಟ್ಲ್ ಏನ್ ಕೇಸ್ ಅದು ಮೆಟ್ರಿಮೋನಿಯಲ್ ಕೇಸ
The partition suit, the brothers and sisters have out of the court settled their matter and they want to.
Why did you not move in the morning?
My lords, I was 5 minutes delayed, my lords, so by that time I.
ನಾಳೆ move
the
ಮಾಡಿ
first matter
ತಗೊಳ್ತೀನಿ.
was- My lords, kindly for.
Lordship, serial.
ನಾಳೆನೇ ಯಾಕೆ ಹಾಕ್ಬೇಕು?
My lords, I had told all of the persons, they are coming from different places and tomorrow they have. Please, my lord.
ಕಾಸ್ಟ್ ಹಾಕಿ ತಗೊಂಡು ಕಳಿಸಿ.
Lordship, serial number 45.
Much obliged, my lords.
ಅಲ್ಲ ಅದೇ ಡಿಕ್ಟೇಷನ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಿದ್ವಲ್ಲ ಇದನ್ನೆಲ್ಲ ಕೇಳ್ಕೊಂಡು ಕುತ್ಕೊಳ್ಳೋದಾಗಿದ್ರೆ ಆಫ್ಟರ್ನೂನ್.
Much obliged.
ನಾಳೆ ಲಾಸ್ಟ್ ಕ್ವಶನ್ ಬಿಡಪ್ಪ.
Court officer. ಸಾಯಂಕಾಲ ಬರ್ತಾನಂತೆ ನೀರು ಸಾಯಂಕಾಲ ಬರ್ತಾನಂತೆ ವಾಟರ್ ಕ್ಯಾನ್. Court officer. Court officer.
Yes. 36. ಆಯ್ತು ಇರ್ಲಿ, ವಿಲ್ ಟೇಕ್ ಇಟ್.
Serial number 27, my lord.
Oh.
And they have kindly have it next week. ನಾನು papers ಕೇಳಿದ್ದೇನೆ.
Portal mood ಅಂತ ಇದೆ ಅಲ್ಲ, who has moved it?
I'm for respondent.
You had moved it.
ಅಲ್ಲ ಅವ್ರು ಮೂವ್ ಮಾಡಿದ್ರು, ನಾನು ಅವರು ಇದ್ರು 1:30 ಇದ್ರು, ಕಾಪೀಸ್ ಕೊಡ್ತಾರೆ.
Response council list on, I think.
Next week.
Next month.
March.
28.
28. You are for? Right, but they have sought a stay in that case. Jadhav, Avaru.
Chetan Jadhav, still number 31.
There is a divorce decree. Then let them come. Let them settle, then we will grant an interim stay till next hearing date. See, he is not there. They have sought a stay and they have moved the matter. In their absence, how can we give that? Otherwise, you undertake that you will not marry till next hearing date. You don't want that? What is that? You are undertaking or not undertaking? ಆಯ್ತು ಬರ್ಲಿ ಹಾಗಿದ್ರೆ ನೋಡೋಣ. Yes.
With your lordship, kind leave, may I please also.
28.
So it is connected with MFA 2505 of 2022.
ಇದು ಕೋರ್ಟಲ್ ಮೂಡ್ ಅಂತ ಇದೆ.
ಅಯ್ಯೇ ಇದೆ ಸುಮ್ಮನೆ ರಿಲೀಸ್ ಆಫ್ ಅಮೌಂಟ್. I moved that.
You have filed the appeal.
Yes. 2505 of 22.
Matter is connected to MFA number so and so. List both the matters together on after
Next week.
27.
Negligence ಇದೆ. Records ಬೇಕಾಗುತ್ತೆ.
ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗುತ್ತಾ?
Please.
ರೆಕಾರ್ಡ್ಸ್ ಬೇಕು ಅಂತಾರಲ್ಲ ಅವ್ರು ರಿಲೀಸ್
ಇಲ್ಲೇ ಬೆಂಗಳೂರೇ ಸರ್. ಅಲ್ಲ ರಿಲೀಸ್ ಆಗ್ಬಿಡ್ಲಿ ಸುಮ್ಮನೆ.
ಎಗ್ರಿ ಆಗ್ತಾ ಇಲ್ವಲ್ಲ ಅವರು.
Let the records come, let the case itself.
Heard it. All parties here. It is submitted that this matter is connected with number 7. So list both the matters together. September first week.
39.
With your lordships, kindly may I please make a mention serial number 30.
Which matter?
Serial number 30, your lordship. The counsel on record Teja AP Senior K. Jairam passed away, my lord, and hence I'm praying for a week's accommodation in this.
You are seeking on behalf of Teja?
Yes, my lord, yes.
Who has moved this matter? You had moved it?
No, we had not moved it. The petitioners had moved it.
SP Total C.
There rejection is as requested by response council list of
28.
ಅದೇನು admission ಅಲ್ಲಿ ಇದೆ. Admit ಮಾಡಿ records call for ಮಾಡ್ಬೋದೇನಲ್ಲ. Matter can be admitted and records can be called for. There is no interim application in that. Word admit call for TCRs. List on
25/9.
25. Yes.
Grateful, your lordship.
25/9. ಯಾರ್ದು ಒಂದು ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು.
Still number 36 for reporting settlement. Ismail Zabiullah, Prakash T. Hebba.
Amendment of cost item.
Lord,
Permission to produce the non-compliance of office subsections and memo for deletion of respond number 8.
Lord, this compromise is only in respect of 2 items of the property. Regarding the rest of the items, the the challenge will proceed.
No, whether all of them have agreed for the settlement? What is the settlement?
Lord, the appellants and respondents, all together, they intend to compromise only in respect of 2 items of the properties in RFA number 2325 of 2019. Both the appeals are clubbed. No, these are the.
This appeal arises OS number 75/58 of 2008.
Yes.
ಮತ್ತೆ ಈಗ ಇದು ಮುಗಿದ್ರು ನಮ್ ಕೇಸ್ ಏನ್ ಮುಗಿಯೋದಿಲ್ಲ.
Case ಮುಗಿಯೋದಿಲ್ಲ.
ಹಾಗಿದ್ರೆ ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ? ತಗೊಳ್ತೀವಿ ಬಿಡಿ. ಹಾಗಾದ್ರೆ ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ತಿರೋದು ಮುಗಿಸಿದ ಮೇಲೆ ತಗೊಳ್ತೀವಿ.
ಆಯ್ತು. My learned friend moved it so therefore.
number
ಈ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ನಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡುವಾಗ ನಾವು ತುಂಬಾ ಹುಷಾರಾಗಿರ್ಬೇಕು. ಈಗ ಪ್ರಾಬಬ್ಲಿ ಜಸ್ಟ್ ಇಟ್ ಅಕರ್ ಟು ಅಸ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ನಾವು ಚೇಂಬರ್ ಹೋದ್ಮೇಲೆ ನೀವೇನೋ ಹೇಳಿದ್ರಲ್ಲ ಅರ್ಥ ಕೊಡಿ ಅದೆಷ್ಟೊಂದು ಸೂಟ್ಸ್ ಇದೆ ಅಲ್ಲ. ಪ್ರಾಬಬ್ಲಿ ನಾವು ದೀಸ್ ಪಾರ್ಟೀಸ್ ಮೇಟ್ ಆಫ್ ಸೋಲ್ಡ್ ದ ಪ್ರಾಪರ್ಟೀಸ್ ಟು ಅದರ್ಸ್. ಯಾರೋ ಬಿಲ್ಡರ್ ಡೆವಲಪರ್ ಬಂದಿರ್ಬೇಕು, ಅದಕ್ಕೆ ಈಗ ಡಾಟರ್ಸ್ ಮತ್ತು ಫೈಲ್ ಆಗಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿರ್ಬೇಕು. ಹಾಗಿದೆ ಅವ್ರೆ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಹೌದು ಅದು ನಮ್ಮ ತಂದೆಯವರು ಹಾಕಿದ ಸೂಟ್ ಅಲ್ಲೇನೆ 23 ಹಾಕಿದಾರೆ ಅಂತ ಕಾಣುತ್ತೆ. ಅದು ನಮ್ಗೆ ಇನ್ನೂ ಸರ್ವಾಗಿಲ್ಲ ಸಮನ್ಸ್. ಬೆಂಗಳೂರು ಸಿಟಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದೆ.
ತಂದೆ ಸೂಟ್ ನಾಲೆಡ್ಜ್
ಸೂಟ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಈಗ ನಾವು ಯು ಹ್ಯಾವ್ ಸೋಲ್ಡ್ ದ ಪ್ರಾಪರ್ಟಿ ಪ್ರಾಬಬ್ಲಿ ದೇ ಟು
ನಾವ್ ಇಟ್ಕೊಂಡಿದೀವಿ. ಅವರು ಸೇಲ್ ಮಾಡಿರೋದು ಕಾಂಪ್ರಮೈಸ್ ಆಸ್ ಪರ್ ದಟ್ ದೇ ಸೋಲ್ಡ್.
ಯು ಹ್ಯಾವ್ ದ ಕಾಪಿ ಆಫ್ ದಟ್ ಪ್ಲೇಂಟ್.
Which plaint, my lord? 7. That is there, my lord.
Along with
ಯಾವ್ದರ alienation ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು ಏನು?
page 35 of the application.
Page 35 of the
IF1.
additional documents.
Daughter's plaint.
Problem started, my lord, for seconds. This one, we started construction in portion of property. For therefore, they
Page
come
17.
before and.
Apologies. Page 17.
Page 70 na?
17 of the IA.
Page 17. IA for production. IA 4 of it.
IA4 along with they filed.
17 is daughters have filed this suit.
Please.
ಇದರಲ್ಲಿ ಪ್ರೇಯರ್ ನೋಡಿ ಏನಾದ್ರು ಬೈಂಡಿಂಗ್ ನಾಟ್ ಬೈಂಡಿಂಗ್ ಅಂಡ್ ಅಲಿನೇಷನ್ಸ್ ಆರ್ ನಾಟ್ ಬೈಂಡಿಂಗ್ ಎಟ್ಸೆಟ್ರಾ ಇದೆ ಅಂತ. ನೋಡಿ ಇದೆ ಅಲ್ವಾ, ನಾವು ಅನ್ಕೊಂಡಿದ್ದು ನಮ್ಮ ಅನುಭವ ಸರಿಯಾಗೇ ಇದೆ. ಟು ಡಿಕ್ಲೇರ್ ದಟ್ alleged compromise decree is not binding, ಅದು ಒಂದು. ಎರಡನೇದು
And sale deeds also.
Sale deed executed by defendant number 7, 6 and 7 in favor of defendant number 8. 6 and 7 ಯಾರು ಅದರಲ್ಲಿ? defendant number 6 and 7.
ಅದೇ purchasers very same. They what the compromise ನಲ್ಲಿ ಸೇಲ್ ಆಗಿರೋದು.
Plaintiffs ಇರಬೇಕು.
6 and 7 are the plaintiffs. 8 is the subsequent.
ವೆಂಕಟೇಶ್ and
That's the appellants in the present.
ಅದೇ ಅವ್ರು ಸೇಲ್ ಮಾಡಿರೋದು.
ನಾವ್ ಹೇಳಿದ್ವಲ್ಲ ಯಾವ್ದೋ ಒಂದು ಸೇಲ್ ಸೆಟ್ ಅಸೈಡ್
Correct, my lord.
That is the normal
Presumption 100% it is a truth.
ನಾವು ನೋಡಿದ್ವಿ ಇದೇನು ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್ಸ್ ಆಕ್ಟ್ ಕೆಳಗೆ ಇದು 2DC ಅಂತ 3ನೇ ಕ್ಲಾಸ್ ಏನೋ ಬರುತ್ತೆ ನೋಡಿ, ಅದ್ರಲ್ಲಿ ಬರುತ್ತೆ ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್ಸ್ ಆಕ್ಟ್ ತೆಗಿ ಒಂದ್ ಸ್ವಲ್ಪ ಅವ್ರಿಗೆ ಓದಕ್ ಕೊಡಿ. To declare that the alleged sale deed dated so and so executed by 2018 and another registered agreement of sale executed by defendant number 8 in favor of defendant number 9. ಯಾರೋ ಬಿಲ್ಡರ್ ಡೆವಲಪರ್ ಬಂದಿರ್ಬೇಕು 8 and 9 ಅಂದ್ರೆ.
ಮತ್ತೆ ಈ ಸೆಕೆಂಡ್ ಸೂಟ್ ಫೈಲ್ಡ್ ಬೈ ಫಾದರ್ ಲೇಟೆಸ್ಟ್ ಸೂಟ್ ಅದರಲ್ಲಿ ಓನ್ಲಿ ದೇ ಆರ್ ಸೀಕಿಂಗ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಅಂಡ್ ಕಾಂಪ್ರಮೈಸ್ ಡಿಕ್ರಿ null and void, not selling, setting aside sales. Father filed, the father of the who are the appellants herein. The Ashwath has filed a suit in OS 8026 page number 144, where that my lord may kindly look at the prayer.
Page 144 of this edition.
House. That prayer may kindly look out, my lord.
He is the father of this plaintiff.
The father showing that the prayer, my lord, it forthcoming from page number 158.
KN Adopi.
Yes.
Page number.
Directing the defendant to effect the partition of 36th share in the same allotted to Ashwath Lakshmamma daughters Madhavrao branch in item number 6 and
Ashwath Lakshmamma, daughter of Madhavrao.
And the effect.
Got impleaded is defendant number 7 and sought for rejection of the plaint.
No, he is not.
You're
Some other. He is. What I need to say, father has filed some subsequent suit.
Or BL Narayan.
He is the son-in-law of Madhavrao.
Will continue, but
therefore once
when we were going back, we felt that some alienation ಏನೋ ಚಾಲೆಂಜ್ ಮಾಡೋದಕ್ಕೆ ಡಾಟರ್ಸ್ ಬಂದಿರ್ಬೇಕು ಈಗ ಅಂತ ಹೇಳಿ.
One latest judgment of Honorable Apex Court, my lord. May kindly look at the, while considering the 2 rule 2, your lordship, the law, my lord, by quoting the earlier Privy Council judgment, Honorable Court, my lord, Apex Court held para number para 45 may kindly look at, my lord.
It's citation, you know.
AR 2022 Supreme Court 4256.
Only to subsequent suit and would not apply to the amendment sought in the existing suit.
Para 45 may kindly look at, my lord. Internal para 45. the expression omits to show and intentionally relinquishes any portion of his claim given an indication as to the intention of the legislature in framing the said rule. The term shoe can be mean both filing the suit and prosecuting the suit. It's to culmination and depending on the context of the provision. In the present case, legislature, though it is a fit to debar the plaintiff from suing afterwards for relief, which he or she omitted to without leave of the court, or from suing in respect of any portion of his claim which he intentionally relinquishes. Order 2 Rule 1 provides that every suit shall include the whole claim which the plaintiff is entitled to make in respect of the cause of action. And finally, my lord, the
Intentionally relinquishes ಅಂತಾನೆ ಇದೆ ಅಲ್ಲ.
so my lord, my submission in the compromise relinquished all the claim in respect of the properties.
Intentionally relinquish ಅಂದ್ರೆ
ಅಂದ್ರೆ
ಇರ್ತಾ ಇಲ್ವಾ?
ಅದಕ್ಕೆ for that my argument before the court intention is concerned. In the second suit, they contended father was alienated some portion of properties acquired by Madhav Rao. Madhav Rao was acquired 10.
Argued already ಇದೆ.
For that, my lord,
He has argued 75 in the business market.
for that, Supreme Court again held in para 49 and 50. May kindly look at, my lord. So far as by the Constitution bench of this court in the Order 2 Rule 2 in 1964 Supreme Court
Where are you? 49.
49, my lord. So far as the word started, my lord.
ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
That
Gurbaksh Singh case.
Gurubaksh Singh is concerned, we may clarify the entire consideration in the said case by this court was to fact that there was a relinquishment of claim by the plaintiff herein. But the relevant point which was considered by this court was that relief has become time barred. The ratio of the said judgment is the relief barred by limitation. Order 2 Rule 2 of the CPC only came in is an adjunct. However, it is made clear that bar of 2 Rule 2 CPC applies only to the subsequent suits. My lord, my submission before the court, Partition earlier demanding that these are the joint family properties in 2015 suit. Very same cause of action narrated in the present suit state. Not repeating. What's the law says, my lord, is that the Supreme Court held subsequent suit on the cause of action, saying that earlier they demanded refusal to partition, hence they filed a suit, compromise. Second suit again filed for demanded the partition, they refused. That is my submission.
One aspect you'll also please to ask me whether the pendency of this suit was made known before the trial court. Page
It's a
19
writ petition, not
in the writ petition.
Which page?
Page 191 of the appeal papers.
190.
Page one. This is the memo filed by the sixth defendant applicant,
They have produced.
enclosing a copy of my writ petition. This memo is dated 24/3/2023, and the entire writ petition is before the court along with the fact that notice was ordered.
Next. Shri Ashok P. Patil, learned senior learned counsel for the appellants. Referring to Order 7 Rule 11 D and Order 2 Rule 3, you see, submits that to invoke those provisions, the suit should be barred by law only on reading of the plaint and not with reference to other documents. And to invoke Order 2 Rule 2, there should be intentional omission or relinquishment to claim the relief in the earlier suit. He further submits that if further submits that pleadings in the plaint should have that the appellants clearly stated that they had no knowledge of the existence of other immovable other family properties at the time of the compromise in OS number. Notes in
896/15.
OS number 896 of 2015. Therefore, whether they had the knowledge and intentionally and with such knowledge relinquish the shares in the other properties as a matter of trial. So, therefore, Order 7 Rule 11 could not have been invoked. It further submits that Order 7 Rule, Order 2 Rule 2 is applicable only a suit filed by where a party is plaintiff in both the suits, whereas the appellants were defendants in OS number 896 of 2015. On that count also the impugned order suffers infirmity. In support of his submissions, he relies on the Bombay High Court. The judgment, the following judgment: Nanu Radu Patil versus Shripati Radu Patil, 2008, 4 Maharashtra Law Journal, page 931. For contrast, Shri Ashok Harnali, learned senior counselor, appearing for Yarika appear after the Harnali.
Respond number 3 to 5.
Information. ಅಲ್ಲ ಅವರು ಇವ್ರಿಗೆ ಮಾತ್ರ ಆಗ್ತಿದ್ರ KVAT respond number 5 ಅಂತ ಇದೆ.
Subsequently, Wakalat has been filed.
So just R1 and R2. Advocates on record for respond number 1 to
For respond number 3 to 5, Malad.
3 to 5. 1 and 2
1 and 2, I am to
3 to 5. And Shri Vijay Kumar K, learned counsel for respond number 1 and 2. Submit that the plaint itself shows that states that the properties, the alleged that resident Madhavrao and Rangarao had alienated the properties as to para 4 of the plaint. Para 4 of the plaint.
Para 3B.
Page number is to
369, 70, it relevant.
69.
73B. B top left side, my lord.
ಅಲ್ಲ ಅದೇನ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ
That is 3A list of the properties, 3B is sale alienated properties.
3B, not 3A. Alienations ಎಲ್ಲ ಹೇಳಿದ್ರೆ 3B.
ಅದೇ 3B ನಲ್ಲಿ top ನಲ್ಲಿ ಇದೆ first line itself.
ಅಲ್ಲ para 3A B capital ಆಗ್ಬೇಕಲ್ಲ. And other paragraphs and the other arguments in the plaint itself themselves so that the ancestors Rangarao, Madhavrao and Rangarao had alienated the properties starting from 1962, earliest 62 to 80.
69.
And
62.
The business was started in 1975. OS number 896 of 2015 was compromised in the year 2016. That goes to show that the plaintiffs were aware that uh,
One
their fathers
clarification.
dealt with the properties independently.
One clarification, my lords. The businesses which are stated in page 71. My lords may kindly see para 3C at the next page.
75 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
72.
Page number 71 ನಲ್ಲಿ
Talks about the businesses.
Trade mentioned transactions used, the funds were used for the purpose of establishing general
The businesses.
in the year 1975.
Please, the next para, my lords, para 3C. Plaintiff submit that initially partition with respect to 6 items. Only 1 to 6 were, the suit was instituted only with respect to 1 to 6. Whereas the businesses themselves are item number 19 and 20. They're implemented subsequently.
ಅವಾಗ್ಲೂ ನೀವು argument ಒಂದು only they have included the immovable properties where business was allegedly run, but they had sought partition in those properties. Yes. Therefore, with a clear understanding, the plaintiffs entered into the compromise in OS number 896 of 2015, omitting those properties, omitting the present social properties. Thus, the suit was clearly barred by order to rule to CPC. They further submit that after such compromise, plaintiff number ಎಷ್ಟವರು ಈಗ ಸೇಲ್ ಮಾಡಿದವರು?
2 and 3.
Appellant number.
Plaintiff number 2 and 3.
Appellants 1 and 2.
Mother died, mother died.
Mother died.
Grandmother died. Grandmother.
No, appellant 1 and 2.
Grandmother, mother ಅಲ್ಲ.
Appellant 1 and 2.
But appellants 1 and 2 have
They were plaintiffs 2 and 3 in the suit.
ಈಗ anyway, ಈ suit plaintiffs 2, appellants / plaintiffs 2 and 3 sold the properties allotted to their share under the compromise decree. Therefore, it is not open to them to question this, challenge the said compromise decree. Next one. Thus, their father has grandfather Ashwatthaya. ಈಗ ಇನ್ನೊಬ್ರು ಯಾರು ಹಾಗೆ ಅಶ್ವಥ್.
Ashwatthaya is father of the plaintiff 2 and 3. Appellants 1 and 2.
ಏನದು ಸೂಟು?
ಇನ್ನೊಂದು ಸಿಸ್ಟರ್ಸ್ ಫೈಲ್ಡ್ ಸೂಟ್.
ಫರ್ದರ್ ಅಲ್ಲ, ಅಶ್ವಥ್ ಅನ್ನೋರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು.
ಫಾದರ್
Son-in-law of Madhavrao. Son-in-law of Madhavrao.
ಕರೆಕ್ಟ್, ಸೂಟ್ ಹೇಳಿದ್ರಲ್ಲ ನೀವು, ಇಲ್ಲೊಂದಾದ್ರು ತೋರಿಸಿದ್ರಿ ನಮಗೆ.
That is 8026 of 23.
For partition again.
Partition.
Not satisfied with the suit on hand. Father of appellant number 1 and 2 has filed another suit that for partition. Thus, the appellant's plaintiffs are abusing the process of the court. Hence, the trial court was justified in rejecting the plaint. Next paragraph. On considering submissions of both, judgment ಯಾವ್ದು ಹೇಳಿದ್ರಲ್ಲ, in support of their submissions, they rely on ಇವರು ಅಂದ್ಕೊತಾರೆ. ಈ 1995 ಅದೇನು ಹೇಳಿಲ್ಲ ಅವರು. They rely on the following judgments: Devram and another versus Ishwar Chand and another. 1995 6 SCC 733. Senior counsel did not even refer to this 1995 judgment.
One judgment referred, second judgment.
Second refer ಮಾಡಿದ್ದಾರೆ. You want us to again rely on the 2014 SCC.
Yes, ma'am.
ಇಲ್ಲಾಂದ್ರೆ ಒಂದೇ ಬರ್ಕೊಳ್ಳಲ್ಲ, ಸುಮ್ಮನೆ ಮಲ್ಟಿಪ್ಲೈ ಮಾಡೋದ್ರ ಬದಲು.
That is paras 12 ಅದರಲ್ಲಿ ಓದಿದ್ರಿ.
ಕಾಫಿ ಬೋರ್ಡ್ ಕರ್ನಾಟಕದಿಂದ ಹೋಗಿದ್ದ ಹಾಗೆ ಕಾಫಿ ಬೋರ್ಡ್ ವರ್ಸಸ್ ರಮೇಶ್ ಎಕ್ಸ್ಪೋರ್ಟ್ಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ 2014 6 SCC 424. Life Insurance Corporation of India versus Sanjeev Builders Private Limited and another year 2022 SC 4256 of 4256. Next one. and considering the submission of both sides and examining the material under court, the point that arises, the question that arises is whether the suit, whether OS number also, suit in OS number.
846 verse
846.
6.
So again, very helpful. Whether the suit in OS number 896 846 of 2016 before the trial court was barred by order 2 into CPC. The facts of the case are narrated in detail above. Therefore, they do not warrant. There is no need to repeat the same. The trial court has rejected the plaint on the ground that the suit was hit by order 2 in view of the compromise decree in OS number 896 of 2015 between the plaintiffs and the defendants. Defendants 1 to
1
1
to
to
3.
5 ಅಲ್ವಾ?
1 to 5.
1 to 5. There cannot be any dispute, and it is a settled proposition of law that while considering an application under Order 7 Rule 11 CPC, the court is required only to look into the pleadings in the plaint and not the written statement or the other material produced by the parties.
Plaint and the plaint documents.
Just a minute, okay, no, provision. And Order 7 Rule 11 alle ಓದಿಲ್ಲ. Next provision ತೆಗೆದಿದೆ ಅದು Order 2 Rule 2 ತೆಗೆದಿದೆ. ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಈಗ ಹಾಗೆ ಬರ್ತದೆ. Order 7 Rule 11 ಅದಕ್ಕೊಂದು ನಮ್ಮ ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟು ಇದೆ. There is an amendment to the CPC by Karnataka amendment, Karnataka High Court amendment dated 9/2/1967. Order 7 to 11D, which was relied on by the trial court, reads as follows. Some Karnataka amendment ಇದೆ ಅದು ಹಾಕ್ಕೊಳ್ಳಿ. ಅದು ಇನ್ನೊಂದು ಡಿನು ಹಾಗೆ ಇದೆಯಾ? CPC ಅಲ್ಲಿ Order 7 Rule 11 ABC ಇತ್ತು. ಡಿ ಇಂಟ್ರೊಡಕ್ಷನ್ ನಮ್ದೇನಾ ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಅಮೆಂಡ್ಮೆಂಟ್?
C is the only thing which is coming under.
Up to C ಅದು ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಸೆಂಟ್ರಲ್
Karnataka amendment.
Karnataka amendment is C, D, E, F.
Only C, my lords, only C. But there is a line, my lords.
Oh, right, sorry.
Only C.
I'm sorry. Order 7 Rule 11D, which is relied on by the trial court, reads as follows. ಅಲ್ಲಿ ನಾನು ಅಂಡರ್ಲೈನ್ ಮಾಡಿದ್ದೀನಿ. The suit appears from the statement in the plaint. No, that reads where the suit appears from the statement in the plaint to be barred by law ಅಂತ ಇದೆ.
Any law.
ಏನಿಲ್ಲ, ಕರೆಕ್ಟ್. ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಅಲ್ಲ, ಅದು in the Dahiben's case, Honorable Supreme Court has held plaint and plaint documents may have to be examined at the time of.
The reading of the above provisions makes it very clear that what is to be looked into at the time of considering an application Order 7 Rule 11 CPCs, only the statements made in the plaint. Order 2 Rule 2, this is relied by the trial court. Read as follows. don't know.
Para 12 of the impugned order. Para 12 of the impugned order. Court stated that without seeking leave of court, they cannot file. Therefore, 7-2 rule 2 will come in the way.
What ಹೇಳ್ತೀವಿ ಯಾವಾಗ ಲೀವ್ ಕೇಳೋದು ಯಾವಾಗ ಬರುತ್ತೆ?
While compromising the suit, they are not seeking leave and the
A
court.
question of order 2 rule 2 says where plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion of omitted so relinquished ಅಂತ ಹೇಳ್ತಾರೆ. Without leave of the court ಅನ್ನೋದು ಎಲ್ಲಿ ಬಂತು? ಅದಾಯ್ತು. In the provision itself, it is clearly stated. In order 2 itself, it is clearly stated that the word employ, the word intentionally is employed. Therefore, in addition to that, the plaintiffs in para ಎಷ್ಟದು recently came to know ಅಂತ ಹೇಳಿದಾರಲ್ಲ.
Yes.
Is 72 para 3C, my lord.
General rules, ನಿಮಗೆ ಹೇಳಿದ್ರಿ.
Page 72 para 3C.
3C of the plaint, capital C.
Only with respect to item 7 to 20 it is said so, not with respect to 1.
Properties.
Not with respect to.
Learn that several other properties in all 14 properties belonging to the joint family are also available for partition.
With respect to the item 1 to 6, nowhere it is stated that we were not aware.
The said properties are added to the original schedule in the plaint as item number 7 to 20.
70.
Yes,
Therefore,
what
1 to 6 not stated.
1 to 6 they have not stated.
1 6.
ಇಲ್ಲಿ
In para 3C has clearly stated that they were not aware of. They recently came to know. They had sought partition in respect of 6 items of the property set out in the schedule to the plaint. Adre suit file ಮಾಡಿದಾಗ ಬರೀ 6 ಮಾಡಿ ಆಮೇಲೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ವಿ.
ಆಮೇಲೆ ಮಾಡಿ 7 to 20 ಸೇರಿಸಿದ್ರು.
Nowhere in the
But
plaint.
ಇದು ಮೊದಲಿನ 6 ಪ್ರಾಪರ್ಟೀಸ್ ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದಿರಿ?
ಇಲ್ಲ ಪ್ಯಾರಾ 4.
ಪ್ಯಾರಾ 4.
ಹೌದು. ಇಲ್ಲಿ ಪ್ಯಾರಾ
6 properties were earlier.
The defendants had filed the suit in OS 896.
Yes, we are reading.
Para 4 at page 82.
Page
82.
But pertaining to some properties. Now included in the suit were left out without partition.
Knowledge is not spoken of.
Knowledge ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದಿರಿ?
The defendants who are the branch of C. Rangarao managing the affairs of.
Defense are collusive, now the defense are.
ಇಲ್ಲ.
ಅಲ್ಲ,
ಇಲ್ಲೂ
6
ಹೇಳಿಲ್ಲ.
properties ಬಗ್ಗೆ
ಇಲ್ಲ,
you are
denying the
not
plaintiff.
within your knowledge ಅಂತ
ಹೇಳಿಲ್ಲ.
ಈಗ ಅದು 7 to 10, 7 to 14 ಬಗ್ಗೆ ಆಯ್ತದು.
ಹೌದು ಅಷ್ಟೇ. Only that we
ಅಲ್ಲ,
trigger
7 to 20.
14 items.
6 ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದಿರಿ?
ಇಲ್ಲಿ ಪ್ಯಾರಾ 5 ನಲ್ಲಿ we have said that we demanded partition in October 6.
ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ವಿ. ನಿಮಗೆ ಈ ಪ್ರಾಪರ್ಟೀಸ್ ಬಗ್ಗೆ ಪಾರ್ಟಿಷನ್ ಮೊದಲೇ
ಹೌದು ಇದು ಲೆಫ್ಟ್ ಔಟ್ ಅಂತ ಹೇಳಿದೀವಿ ನಾವು ಅಷ್ಟೇ.
ಎಲ್ಲಿ ಹೇಳಿದಿತ್ತು?
ಅದೇ ಪ್ಯಾರಾ 4 foot of page 82, but the properties now included in this suit were left out without partition. Defendants who are the branch of Rangarao.
Why they were left out ಅಂತ
ಅಲ್ಲ ಅದು ಯಾಕೆಂತ ಎಲ್ಲಿ ಬಂದಿಲ್ಲ ಅಷ್ಟೇ.
ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ you are not entitled ಅಲ್ವಾ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಈಗ 7 to 20 ನಾವು ಆಡ್ ಮಾಡಿದೀವಿ, ಅಮೆಂಡ್ಮೆಂಟ್ ಕೇಳಿದೀವಿ, ಅವ್ರನ್ನು ಹಿಯರ್ ಮಾಡಿ ಅಲೋ ಮಾಡಿದ್ದಾರೆ. 1 to 6 are the subject matters of the plaint as filed into 2016.
ಅಲ್ಲ ಈಗ
Now the
1 to 6 were not the subject matter of
earlier partition.
15 suit.
Please.
ಹೌದು.
ಅದ್ರಲ್ಲೇ ಇತ್ತು ಅದು?
ಇಲ್ಲ ಅದು ಇಲ್ಲ ಅಂತ
ಇರ್ಲಿಲ್ಲ.
ಇದಕ್ಕೆ
Now we have not put those properties again for partition. ಅದನ್ನ ತಗೊಂಡಿದ್ವಲ್ಲ.
4 ಇಲ್ಲ.
ಮಾಡಿಲ್ಲ. ಅಲ್ಲ ಈಗ ಜನರಲ್ ಪಾರ್ಟಿಷನ್ ಕೇಳಬೇಕಾದ್ರೆ actually you should have put those properties also for partition.
ಅದು because it had culminated into a decree to local.
ಅದಕ್ಕೆ
If you say that other properties were left out, ಈಗ ಜನರಲ್ ಪಾರ್ಟಿಷನ್ ಕೇಳುವಾಗ ಅವನು ಇದಕ್ಕೆ ಹಾಕೋಬೇಕಿತ್ತು. ಬಟ್ ವಾಟ್ ಅಬೌಟ್ ಐಟಮ್ ನಂಬರ್ 1 to 6 ಪ್ರಾಪರ್ಟೀಸ್?
1 to 6 properties ಗೆ ಅವು averments in paras 1 and 2 and 4.
1 and 2 ನ?
ಹಾ.
Collusive ಅಂತ ಹೇಳಿ.
ಅದು only family tree, 1 and 2.
Correct. That's only
Relationship they
the
stated.
elucidate.
That we generally read that para 4, then recently they came to know another.
ಹೌದು. ಅದು that is the
Oh, 20.
ಅಲ್ಲ
720.
ಸ್ಪೆಸಿಫಿಕ್ ಹೇಳಿದ್ದಾರೆ, only all recently.
Correct, ಅದಕ್ಕೆ ಉಳಿದಿದ್ದು ಅವ್ರನ್ನ ಕೇಳ್ತಾ ಇದೀವಿ.
Yes, ma'am.
ಎಲ್ಲ
I understand. This is the pleading. The submission is only this. Now it is open to them to take up all this contention written statement. 7 to 11 ಗೆ ಇದು
7 rule 11 ನಲ್ಲಿ ನೀವು ಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಹೇಳ್ಕೊಂಡಿದ್ರಿ, there was a partition ಅದರಲ್ಲಿ
ಹೌದು.
ಈಗ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ನೀವು ಮತ್ತೆ ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು ಅಂತಂದ್ರೆ ಏನಾದ್ರೂ ಒಂದು ರೀಸನ್ ಇರ್ಬೇಕು. ಈಗ ನೀವು so far as property 7 to 14 you said that they were not within your knowledge.
ಹೌದು.
What about
1 to 6 they are left out ಅಂತ ಹೇಳಿದ್ವಿ ಅಷ್ಟೇ. This because as it is the plaint which was drafted and filed in 16 is paras 4 to the end of the plaint.
This plaint was filed within 6 months of the compromise. It
Correct,
could have been
correct.
very well said so.
Yeah.
The dates are very clear.
ಅದಕ್ಕೆ ಟೂ ರೂಲ್ ಟು
6 months ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದು that we should also show bona fides.
even
could
for
have
that
said
also
that
we
it
not
was
get-
left out.
should be pleading ಅಂದ್ರೆ
ಈ-
justification.
1 to 6 ಮಾತ್ರ ಏನ್ ಪ್ಲೇಂಟ್ ಇದೆ ಅಷ್ಟೇನ.
Complaint 1 to 6 ರಿಜೆಕ್ಷನ್ ನಾವು accept ಮಾಡ್ಕೋಬೇಕಾಗುತ್ತೆ.
ಅಲ್ಲ ಅದೇನಾಗುತ್ತೆ ಪಾರ್ಟ್ ಮಾಡೋದನ್ನು ಬರಲ್ಲ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದ್ದಾರೆ. ಇಟ್ ಇಸ್ ಓಪನ್ ಟು ದೆಮ್ ಟು ಟೇಕ್ ಎ ಡಿಸಿಷನ್ ಅಂಡ್ ಟೇಕ್ ಅವರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ
There was no statement at all in the plaint. Part ಆಗ್ಲಿ full ಆಗ್ಲಿ. Again,
ಹೌದು.
for this-
7 to 20 ಗೆ we have given some explanation and plaint was amended after the hearing.
plaint ಅಲ್ಲಿ ಓದ್ ನೋಡಿ ಎಲ್ಲಾದ್ರೂ ಏನಾದ್ರೂ ಇದೆ ಅಂತ.
The rights will also not be affected in view of their father's suit now, latest suit.
ಇಲ್ಲ,
All scheduled
no,
for-
that we don't know. How
ಅಲ್ಲಲ್ಲ,
what is
this
the
is
flexibility of the suit?
collusive suit.
Instead of getting tense to ಓದಿ ಅದ್ರಲ್ಲಿ ಏನಾರು ಇರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಓದಿ. ಅದಕ್ಕೆ 4 paras we read Milord.
ನಾವು ಡಿಮಾಂಡ್ ಮಾಡಿದ್ವಿ.
Rule to applied only for that reason.
Kindly appreciate this. Identity of cause of action is very relevant order to rule 2 ಗೆ. ಈ ಪ್ರಾಪರ್ಟೀಸ್ ಗೆ ನಾವು ಅಕ್ಟೋಬರ್ 16 ಅಲ್ಲಿ
ಇಲ್ಲಿ ನೋಡಿ, the plaintiffs are entitled to half share in suit schedule item number 7 and 8 properties ಅಂತ ಹೇಳ್ತಾರೆ 3D ಅಲ್ಲಿ. para 3 ಇಲ್ಲಿ 7 to 20 3C ನಲ್ಲಿ ಆಯ್ತು ಅದು.
Each paragraph with respect to each item is narrated.
ಹಾಗಾದ್ರೆ 3A and ಇದ್ರಲ್ಲಿ ಏನಾರ ಹೇಳಿದಾರ?
ಇಲ್ಲ ಅದರಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ರಿಲೇಶನ್ಶಿಪ್ ಹೇಳಿದ್ದಾರೆ.
ಕರೆಕ್ಟ್.
There is no narration with
1 to
respect to
6
1 to
ಬಗ್ಗೆ
6.
ನೋ ವಿಸ್ಪರ್.
There is no narration with respect to 1 to 6.
whisper is in para 4 only.
ಇಲ್ಲಾಂದ್ರೆ ಇದನ್ನೆಲ್ಲಾನು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಇನ್ನೊಂದ್ಸರಿ ಮಾಡಿ ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗೆ ಹೇಳ್ಬೇಕಾಗುತ್ತೆ ನಾವು ಅಷ್ಟೇ. See, we were thinking that now in view of this is a question of fact, they cannot enter in, I mean, the trial court should not have decided in this way. ಈಗ ನೀವು item number 1 to 6 ಬಗ್ಗೆ ಏನು ಹೇಳಿರಲಿಲ್ಲ.
1 to 6 ಗೆ
to say that direct the trial court only to examine this again.
very well. Now the point is the identity of cause of action what order 2 rule to say
Cause of
even in the
paragraph ಯಾವ paragraph ಅಲ್ಲಿ ಹೇಳಿದ್ರಿ?
cause of action ಇಲ್ಲಿ
Section for the suit arose in the year in the week of October when
ಇಲ್ಲಿ
defense
para 5 plaintiffs
forward to effect amicable.
page 83.
Para 5.
Plaintiffs have demanded the defendants in the first week of October 16 to effect partition of suits properties and to provide the share of the plaintiff. The defendants have denied the same. On account of this, that plaintiffs is not in a position to maintain herself and therefore she is not willing to continue in joint possession and enjoyment of suit properties. Several panchayats were also held in the village and the panchayatdars have advised the defendants to effect division. Therefore, plaintiffs is advised to file the suit for partition and separate possession, claiming her share.
ಅದು plaintiff ಒಬ್ಬರದಾಯ್ತು.
ಅಲ್ಲ ಅದು ಸಾವಿತ್ರಮ್ಮ ಅವ್ರದ್ದು ಆ ಸಿಂಗ್ಯುಲರ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅವಾಗ.
7 to 11 ಗೆ pleading ಇತ್ತು. 1 to 6 ಗೆ pleading ಇರ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ಇದು apply ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳೋದಕ್ಕೆ. ನಿಮ್ಗೆ ಯಾವ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಡನ್ ಪಾರ್ಟ್ಲಿ ಅಂತ?
ಇದಕ್ಕೆ
There is a ruling.
even they cannot claim, split the claim ಈಗ. Once-
ಎಲ್ಲಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ, claim is concerned.
If some law is there, we
Yes.
cannot go against that. ಅದಕ್ಕೆ
The Honorable Supreme Court has held plaint cannot be, rejected in part ಅಂತ.
ಕೊಡಿ ಅಲ್ಲಿ ಯಾವ ಕಾಂಟೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು ಏನು ಅಂತ ಅದನ್ನ ನೋಡಿ.
In the context that the,
Shows the
no, right now I do not have that citation.
ಎಲ್ಲ ನೋಡಿದ್ದೆ ಆದ್ರೆ ಯಾವ ರೀತಿ ಬಿಕಾಸ್ by stray sentence we cannot we have
ಇಲ್ಲ, that is in principle only. They have laid down that principle.
entire plaint ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಈಗ.
ಅಲ್ಲ, in principle that is the law which I'll be able to place it maybe by tomorrow morning, subject to the courts.
ಪಾಸ್ ಔಟ್ ಮಾಡ್ತಿಲ್ಲ ನೋಡಿ. ನಾವ್ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಆರ್ಬಿಟ್ರೇಷನ್ 3ನೇ ಸರಿ ಈಗ
ಇಲ್ಲ,
ಲಿಸ್ಟ್ ಕೊಡ್ತಾ ಇದೀವಿ. ಅಲ್ಲ ಡಿಕ್ಟೇಷನ್ ಗಂತ ನಿಮ್ದು ಹಿಡ್ಕೊಂಡು ಇದು ದಿಸ್ ಇಸ್ ವೆರಿ ಚಕ್ರವ್ಯೂಹ ಇದ್ದಂಗಿದೆ ನಿಮ್ದು ಇದು.
ಇಲ್ಲ, ಅದಕ್ಕೆ submission is only this. In the written statement also, they have taken this contention of order 2 Rule 2 CPC. The Constitution bench says in such an event, issue has to be framed and decided. Now that I'll be able to place that Gurbakh Singh's case.
ಇಂಟೆನ್ಷನಲ್ ಒಮಿಷನ್ ಅಂತ ಅನ್ನೋದು ಒಂದು
I understand. That is
ಅದೇ ನಿಮ್ಮ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅರ್ಲಿಯರ್ ಪಾರ್ಟಿಷನ್ ಆಗಿತ್ತು ಅನ್ನೋದನ್ನ ನೀವು ಒಪ್ಕೊಳ್ತೀರಾ?
ಹೌದು.
ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
ಪಾರ್ಟಿಷನ್ ಅಂದ್ರೆ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ ಅಂತ. ಕಾಂಪ್ರಮೈಸ್ ಆಯ್ತು.
ಕೊಲೂಸಿವ್ ಡಿಕ್ರಿ ಅಂದ್ರೆ ಯಾರು ಕೊಲೂಡ್ ಆಗಿದ್ರು, ಯಾರ ಜೊತೆ ಕೊಲೂಡ್ ಆಗಿದ್ರು?
ಅದಕ್ಕೆ ಅಲ್ಲ, ಅದೇನಾಗಿದೆ,
ಕೊಲೂಸಿವ್ ಡಿಕ್ರಿ ಅಂತ ಹೇಳಿದಿರಿ ನಿಮ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಿಮ್ಮ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ. ಯಾರ ಜೊತೆಗೆ ಯಾರು ಕೊಲೂಡ್ ಆಗಿದ್ರು ಏನು ಅದನ್ನೇ ಹೇಳೋದಿಲ್ಲ. There should be collusion between the plaintiffs and the defendants.
Then only it is collusive.
ನಿಮ್ಮನ್ನ ಬಿಟ್ಟು ಬೇರೆ ಯಾರ ಡಿಪೆಂಡೆನ್ಸ್ ಇದ್ರ?
ನಾವೇ ಇದ್ದಿದ್ದು ಅವಾಗ
ಅಂದ್ರೆ ಇಟ್ ಅಪಿಯರ್ಸ್ ದಟ್ ಸಿಸ್ಟರ್ಸ್ ನ ಔಸ್ಟ್ ಮಾಡ್ಬೇಕಂತ ನೀವೆಲ್ಲರೂ ಕೂಡ ಕೊಲೂಡ್ ಆಗಿದ್ರಿ ಅಂತ ಅನ್ಸುತ್ತೆ.
ಈಗ ಆತರ ಇದ್ದಿದ್ರೆ ಸೇಲ್ ಮಾಡ್ತಾ ಇರ್ಲಿಲ್ಲ ಅವರು. ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟು ಎಲ್ಲ ಆಗಿ ಮತ್ತೆ ಬರ್ತಾರೆ.
All this is
ಎಲ್ಲರೂ ಗೊತ್ತಿದೆ ಸ್ವಾಮಿ.
Differential what my learned friend is contending, that is the defense. Very well. Only the point is, this honorable court wants to know whether we are aware of the other properties at the time of filing the suit, particularly items 1 to 6. 1 to 6. ಅದಕ್ಕೆ ಪ್ಲೀಡಿಂಗ್ ನಲ್ಲಿ ಇರೋದು ಇಷ್ಟೇನೆ. ಈಗ ಇದ್ರ ಬಗ್ಗೆ ನಾವೇನ್ ಹೇಳಿದೀವಿ, ಪಾರ್ಟಿಷನ್ ಅಕ್ಟೋಬರ್ ಕೇಳಿದ್ವಿ, ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಸೂಟ್ ಹಾಕಿದೀವಿ ಅಂತ ಹೇಳಿದೀವಿ. ಅಲ್ಲ, ಅದಕ್ಕೆ ನನ್ನ ಸಬ್ಮಿಷನ್ ಇಷ್ಟೇನೆ. I will place that ruling of the Honorable Supreme Court where the plaint cannot be rejected in part.
ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ಅವ್ರಿಗೆ ಡಿಸೈಡ್ ಮಾಡಿ ಅಂತ ಕಳಿಸ್ತೀವಿ ಅಷ್ಟೇ.
May I clarify with respect to all the schedules apart from this averment, I may be permitted to read 3O, my lords. 3O at page 77.
ಅವಾಗ ಓದಿ
Along in conjoint with para 71,
yes.
I may continue from the last 4 lines of page 71 and I'll continue with 3O. The said businesses, last 4 lines at page 71.
Yes.
The said businesses was commenced at Bangalore and it was later shifted to a bigger place at so and so sometime in the year 2009. The businesses is being carried out in the name of SLN Provision Store, SLN Fertilizer and SLN Hardware. The said business is also the joint family business of Madhavrao Rangarao. Both have equal share. Now, my lords, may kindly see 3O. In continuation of that, at page 77. The plaintiffs submit that the joint family business about which reference is made in para 3A above is being carried out in the name and style of SLN Provision Store, SLN Fertilizer, SLN Hardware are being carried out at number so and so, Ennur Bangalore Main Road at item 1920.
Senior Arnali also read this. We have marked it.
Well, the reason why I'm pointing this out is because the previous paragraph, it is stated that from 1975 investments have been happening in business properties.
It's already argued. We were asking you only about item.
My lords, now I just want to point out one line, my lords. At para 3C,
Yes, 3C.
the third line, recently the plaintiffs learned that several of the properties in all 14 properties, this includes the businesses which they were aware from 1975. From the pleadings itself, it is shown that even the remaining scheduled properties also they were aware of. Their specific plea is that all the properties.
She said that they were aware of it is a matter of fact, then it cannot be dealt with.
It comes out of their pleading itself.
11.
It's 2 rule to cover, my lord. Knowledge is 2 rule to cover.
It is shown from the pleading that they were aware.
Try to understand order 7 rule 11.
Any, yes, my lord.
At the most, you could have sought it as a I do not know whether preliminary issue ಅಂತ ಹೇಳಿ ಅದ್ರ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಮಾಡಿ preliminary issue ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ರೆ ಬರೋದಿಲ್ಲ.
ಇಲ್ಲ, ಅದಕ್ಕೆ ಎಲ್ಲ ಇಶ್ಯೂಸ್ ಮೇಲೆ ಮಾಡ್ಬೇಕು. ಭಗತ್ ಸಿಂಗ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಅದೇ ಹೇಳಿದ್ದಾರೆ. ಡಿಫೆನ್ಸ್ ತಗೊಂಡಾಗ ಕೋರ್ಟ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಎಕ್ಸಾಮಿನ್ ಫ್ರೇಮ್ ಇನ್ ಇಶ್ಯೂ ಅಂಡ್ ಡಿಸೈಡ್. 7-11 ಅಲ್ಲಿ ಆರ್ಡರ್ ಟು ರೂಲ್ ಟು ರೆಸ್ ಜುಡಿಕೇಟ ಬರೋದೇ ಇಲ್ಲ ಅಂತಾನೆ ಅದೇ ನಾನು ರೆಸ್ ಜುಡಿಕೇಟ
ಕೇಸ್ ಕೊಡಿ ನೋಡೋಣ.
This constitution bench ruling.
ಯಾವ ಸರ್ ಅದು?
ಗುರುಬಕ್ಷ್ ಸಿಂಗ್.
ಅದನ್ನ ರೆಫರ್ ಮಾಡಿ 2022 ನಲ್ಲಿ ಮಾಡಿರೋ ಪಾಯಿಂಟ್. Your Lordship, Gurubakh Singh case was referred in 2022 judgment. I referred that for the court.
I am reading that judgment.
Very same point of law has been reappreciated.
Not on this point.
ಇಲ್ಲ, very constitution judgment para 48 of the latest judgment.
Let us read that itself. Let us read Gurubakh Singh.
ಅದನ್ನೇ para 48.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ?
Para 48 may kindly look at me, Lord, please.
ಓದಿದ್ರೆ ಅದನ್ನ.
ಇಲ್ಲ, 48 ಅಂತ ಒಂದ್ ಸೆಕೆಂಡ್ ನೋಡ್ಬೋದು. ಇದನ್ನ ಓದಿಲ್ಲ ಈ ಪಾಯಿಂಟ್ ನ. A constitution bench of this court, considering the scope of applicability of order rule 48 ಓದ್ತಾ ಇದೀನಿ ಸರ್. Order 2 rule 2 in the case of Gurubakh Singh versus Boralal AR 1964 SC held. It is in order that a plea of bar under 2 rule 3 subclass 3 CPC should succeeded in the defendant who raises a plea must make out that second suit was in respect of same cause of action on which the previous suit was based, that in respect of cause of action of the plaintiff was entitled to more than one relief, that being entitled to more than one relief with the plaintiff without leave obtained from the court omitted to sue.
ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್, ಅದರಲ್ಲಿ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಬೇರೆ ಆಗುತ್ತೆ.
ಅಲ್ಲಲ್ಲ, ಅದಕ್ಕೆ ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ದಾರೆ para 49. Your Lordship may kindly look at para 49 1 second. 49 may kindly look at.
ಸಾಕು, ನೀವು ಇದಕ್ಕಿಂತ
Please,
ಜಾಸ್ತಿ you need not
Sorry.
reach the top of this court hall.
ಅದನ್ನು ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ದಾರೆ ಆ ಪೊಸಿಷನ್.
You go by this earlier suit ಅಲ್ಲಿ ಈ suit ಅಲ್ಲಿ cause of action.
ಅಲ್ಲಲ್ಲ, ಅದಕ್ಕೆ para 49 clarified.
ಅಲ್ಲಿ cause of action ಬೇರೆ ಅವ್ರ plaintiff.
Lord may kindly look at para 49
ಆವಾಗ
ಇಲ್ಲ, it is clarified, my lord.
para 49 is about relinquishment.
Clarify the entire consideration of the said case by this court.
Came to know about item numbers. Item number 6 to 7 to 14 properties, and initially suit was filed only in respect of 6 properties, etc. Okay, next one. First of all, in order 381
ಅದರಲ್ಲಿ plaint cannot be rejected in part of the case law ಒಂದು ರೆಫರೆನ್ಸ್ ಇದೆ.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಅದರಿಂದ page 381 of
this book,
civil procedure.
381. ಈಗ ನಾವು
Put up the page 381.
381 provided.
There cannot be partial rejection.
ಇಲ್ಲಿ ನೋಟ್ಸ್ ಯಾವ್ದು ಇಲ್ವಲ್ಲ ಇದರಲ್ಲಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಈ ಕಡೆ ಇದೆ.
381.
381. ಯಾವ್ದು?
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವರು ಹೇಳಿದ್ದಾರೆ.
7 to 11 chapter ನಲ್ಲಿ.
There cannot be a partial rejection of the plaint. 1999 3 SCC. Clever drafting creating illusion about cause of actions is not permissible. Repeated use of the word fraud and plaint in the plaint is not sufficient to found a cause of action. Then, first of all,
I will produce the ruling.
therefore, it was contended that in the plaint there is strictly no mention about order 2 sorry, about item number 1 to 6 property. Therefore, suit is barred by order 2 rule for CPC. Okay. Given to invoke order 2 rule to CPC. ಇಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಆರ್ಡರ್ 2 ರೂಲ್ 2 ನಲ್ಲಿ ಅವ್ರ ಪ್ಲೇಂಟಿಫ್ ಇರ್ಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ? Every suit shall include the whole claim which the plaintiff is entitled to make in respect of cause of action, but the plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction. But the plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted. Within our
Okay.
ಹೌದು, two rule.
That is explained in Constitution Bench ruling in
the reading of
Purvak Singh's case.
the two rule makes it clear that if a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. Presupposes that the plaintiff in the subsequent suit should also be the plaintiff in the earlier suit, technically. ಯಾವ್ದಾದ್ರು ಈ ತರ ಡಿಸ್ಟಿಂಕ್ಷನ್ ಮಾಡಿದ್ದಿದೆಯಾ ಆರ್ಡರ್ ಪ್ಲೇಂಟಿಫ್ ನಾವ್ ಹೇಳಿದ್ವಿ ಅದನ್ನ in the partition suit all are in the area of plaintiff ಅಂತ.
That is for the purpose of raising contention with regard to the share.
Further cause of action ನೀವೇ ಹೇಳಿದ್ರು. Further the cause of action to invoke order 2 rule 2 CPC, the cause of action in the earlier suit and the subsequent suit must be the same. In the earlier suit, the present plaintiff's earlier suit, that is OS number
896/15.
of 2015. The present plaintiffs were not the plaintiffs. They had not stated any cause of action in that suit. Therefore, it cannot be said that the cause of action in OS number 896 of 2015 and 846 of 2016 are one and the same. Our judgment ಕೊಟ್ರಲ್ಲ ಅದರಲ್ಲೇ ಇದೆ. Mr. Vijay Kumar, you were hearing your matters for a long time. ಅದಕ್ಕೆ ನಮಗೂ ಸ್ವಲ್ಪ even in Sanjeev Builders Private Limited, Sanjeev Builders case relied on by the learned counsel for the respondents. In para 48 of the Sanjeev Builders case relied on the learned counsel for the respondents, extracting the earlier constitutional bench judgment of the judgment in Gurubaksh Singh versus Burlal's case, the Honorable Supreme Court discussed 3 requirements to invoke order 2 rule CPC, which are as follows. Number 1, the second suit must be in respect of the same cause of action on which the previous suit was based. Number 2, that should be in respect of cause of action. In respect of that cause of action, the plaintiff was entitled to more than one relief. 3, thus entitled to more than one relief, the plaintiff, without the leave of the court, should have omitted to sue for the relief for which second suit had been filed. Even the above observations so that the cause of action should in the earlier suit and the second suit must be one and the same, and the parties, the plaintiffs must be the same in both the suits. Even assuming that the plaintiffs of the present suit were in the array of the plaintiffs in the earlier suit, whether there was intentional omission or relinquishment The issue, whether there was intention, question whether there was intentional omission or relinquishment required evidence that could not have been therefore that could not have been dealt with under Order 7 Rule 11 CPC, which presupposes the dismissal of rejection of the plaint only based on the plaint averments. Copy boards. In Coffee Board's case, in para 9 of the Coffee Board's case, relied on by para 9 of the judgment in Coffee Board's case, relied on by Shri Ashok Harale, Learned Senior Counsel. It was held that to weed out the vexatious litigations, the courts have to examine Order 2, Rule 2. To exercise the powers under Order 7 Rule 11 CPC. Absolutely, there is no dispute with regard to the said principle. However, still it becomes, however, if the said issue requires evidence to examine the contention of the parties, Order 7 Rule 11 cannot be invoked. ನೀವು ಹೇಳಿದ್ದು ಧ್ಯಾನಸ್ ಕೇಸ್ ಪ್ರಿವಿ ಕೌನ್ಸಿಲ್ ಜಜ್ಮೆಂಟ್ ರಿಲೈ ಆಗಿದಾರಲ್ಲ ಇದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕನ್ಸಿಡರಿಂಗ್ ಸ್ಕೀಮ್ ಆಫ್ in Dhanu's case, in the judgment in Dhanu's case, relied on by learned counsel for the appellants, Bombay High Court, referring to Order 2 Rule 2, held that the contention that once certain properties were omitted, with or without, with knowledge or inadvertence, whether with knowledge or inadvertence, itself debars the second suit, was acceptable. ಅದು ಅವರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಹೇಳ್ತಾರೆ. In saying so, the said court relied on the judgment of the Supreme Court in ಬಹುಶಃ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಬೇರೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲೂ ರೆಫರ್ ಮಾಡಿರ್ಬೇಕಲ್ಲ. ಅವ್ರು ರೆಫರ್ ಮಾಡಿದ್ದು 1867 ಮೂರ್ ಅಪೀಲ್ಸ್ ಕೇಸ್. Another aspect to be noted is that challenging the compromise decree in OS number challenging another thing to be noted is that the plaintiff's appellants had challenged plaintiff's appellants filed WP number
24,544.
24,544.
24,544 of 2022 before this court, seeking quashing of the compromise decree in OS number 896 of 2015. ಏನು fraud ಅಂತನಾ?
Oh, fraud and
The
misrepresentation.
ground of fraud and
Misrepresentation.
misrepresentation, etc. and that said petition was still pending when the trial court passed the impugned order. Admittedly, the petition copy produced ಮಾಡಿದ್ರ
At page 191.
defendant number 6 who had filed I number
6 for rejection of the plaint.
6 for rejection of the plaint himself had produced the copy of the said writ petition before the trial court.
They are sold subsequently. They are sold subsequently.
ಅದನ್ನ ಮುಂದೆ ಬರಿತೀವಿ ಎಲ್ಲರೂ ಮಾಡಿದ್ದೀನಿ ಅದನ್ನ ಮುಂದೆ ಬರಿತೀವಿ ಇನ್ನು
24/3/2023 memo ಜೊತೆಗೆ.
when when that was the case, the trial court in all its propriety should have awaited, should not have resorted to reject the plaint invoking order 7 rule 11 CPC. This court, therefore, the impugned judgment, impugned order of rejection of plaint is contrary to the provisions of order 7 rule 11 CPC and order 2 rule 2 CPC and liable to be set aside. However, at this juncture, this court is compelled to make some observations regarding the conduct of the parties in these cases. ಅದೆಲ್ಲ ಒಂದು ಲಿಸ್ಟೇ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಯಾವ್ಯಾವ ಕೇಸ್ ನಂಬರ್ ಇದೆ ಅಂತ. After the compromise in OS number 896 of 2015, the plaintiffs, appellants who claim that the decree was fraudulent one, etc. have said it ಯಾವಾಗ execute ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ
31/10/2023, 31/1/2023.
ಕೊಟ್ಟಿದ್ರಲ್ಲ
House on page 89, IA along with page 89
and 101.
Page 89. Page 89 your documents.
89 is the sale deed subsequent to compromise.
That is sought to be produced under order 41 rule 27. First
ಸೇಲ್ ಮಾಡಿದ್ರೆ ಅನ್ನೋದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಮಾಡ್ತಾ ಇಲ್ಲ, ನಾನು ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು. ಬಟ್ 21/7 ಕೊಟ್ಟಿದ್ದಾರೆ. On first principle, that application is still pending. It is not yet allowed.
Then
And that they gave us only yesterday evening. And
ನಿಮ್ ಕ್ಲೈಂಟ್ಸ್ ಇಲ್ಲ ಇದ್ರೆ ಕೇಳಿ ಅವ್ರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾರಾ?
ಇಲ್ಲ document ಇರುವಾಗ there is no point in disputing.
These applications.
My only submission is this. All these contentions, they are entitled to raise it in the writ petition. Let them raise it.
ಅಲ್ಲ ಅದು ಬರೋದಿಲ್ಲ.
Decide about the.
ನಿಮಗೆ ಅನುಕೂಲ ಆದಾಗ
ಅಲ್ಲ ಹಂಗಲ್ಲ. ನಂದು ಅಷ್ಟೇ ಸಬ್ಮಿಷನ್, ಮತ್ತೊಂದೇನಿಲ್ಲ. ನಾನು ಐ ಆಮ್ ನಾಟ್, I am also as a member of the bar and officer of the, as a member of the bar and officer of the court, what the plaintiffs have done, alienation, and what circumstances they have done, it's for them to explain.
ಎಲ್ಲಾನು ಒಂದೇ ಕಡೆ ತಗೊಂಡು ಸೂಟ್ಸ್ ಅನ್ನ ಡಿಸೈಡ್ ಮಾಡಬೇಕು, ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಡಬಾರದು, ಕೊಟ್ರೆ ಹೆವಿ ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕು, ಇದೆಲ್ಲ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ತೀವಿ.
ಬಹಳ ಅನುಕೂಲ, ಎಲ್ಲಾ ಪಾರ್ಟಿಗೂ ಬಹಳ ಅನುಕೂಲ. ತಾವು ಏನ್ ಮಾಡ್ತಾ ಇರೋದು, ಇಟ್ ಇಸ್ ಸರ್ಟನ್ಲಿ ಕನ್ವೀನಿಯಂಟ್.
ಆಲ್ ಆಫ್ ದೆಮ್ ಆರ್ ನಾಟ್ ಆಕ್ಟಿಂಗ್ ಫೇರ್ಲಿ. ಇದು ಯಾರ್ಯಾರನ್ನ ಸೆಟಪ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಫುಲ್ ಫ್ಲೆಜ್ ಟ್ರಯಲ್ ಆದಾಗ
ಗೊತ್ತಾಗೋದು. ಕರೆಕ್ಟ್.
ಅಲ್ಲ plaintiffs ಅಂದ್ರೆ 2 and 3 ಅಲ್ಲ, plaintiffs
2 and 3 sold
have sold the properties they received under the compromise under the sale deeds dated
31 page 89
ಅಲ್ಲ ಡೇಟ್ ಹೇಳ್ಬಿಡಿ ಅಂದ್ರೆ ಪಾಸ್
31/1/23 and 11/4/18.
ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಪೇಜ್ ಡೇಟ್ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಇದೆ
31/1/23
ಒಂದು
1/20/2023 and
11/4/2018
1/4/2018
admitting compromise.
Admitting compromise.
ಅಲ್ಲ ಅದು ನಾನು ಇಷ್ಟೇ kindly observe.
ಅದು pending writ petition ಇದೆ.
Whatever maybe it is a matter of record.
Court may only observe the ಅಲ್ಲ ಇಷ್ಟೇನೆ the plaintiffs are liable to explain their conduct.
ಅಲ್ಲ ಅದು every minute
we are aware of that. ನೋಡಿ it is litigations are pending. ಇದ್ರ ಖರ್ಚು ಮಾಡೋದಕ್ಕೆ ಅವ್ರು ಎಷ್ಟು ಮಾಡ್ಬೇಕಾಗುತ್ತೋ ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ. We do not know why at bar these kinds of litigations are encouraged.
ಅಷ್ಟೇ, ನಂದು that's what is my submission. It's for them to explain.
Same legal, sir. That too when the WP number dash actually, so and so 24,244. Filed by them was pending when one of the alienation was effected. Okay. The following, I'm sorry, the parties after sale, the other daughters of, sisters of Madhavrao and
Prior to the sale, madam.
Madhavrao and our local 2019 alla.
Madhavrao sisters,
ಇದು ನೀವೇ
14/10/2009.
ನಾವು ಹೀಗ್ ಕೊಟ್ಟಿದ್ ಹೀಗೆ ತಿರುಗಿಸಿದ್ರೆ ಸಿಗೋದಿಲ್ಲ, ಮತ್ತೆ ಹೀಗ್ ಮಾಡ್ಬೇಕು.
ಅದೇ.
ಎಲ್ಲ ಉಲ್ಟಾ ಪಲ್ಟಾ ಈ ಕೇಸಲ್ಲಿ. They have filed. Narayana is the present applicant.
ಹೌದು.
Narayana is the present applicant.
Please.
ಯಾರ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ ಇದನ್ನ? ಅಗೇನ್ ಸರಸ್ವತಿ.
ಅಲ್ಲ, page 17.
ಈಗ partition
764 of 2019 filed by Vijay Lakshmi and others.
After 764, Vijay Lakshmi is a sister alva?
Also,
Vijay Lakshmi.
They are the sisters of Madhavrao and Rangarao.
mother, sister only.
One of the sisters.
After the sale of one property, prior to the sale of the second property.
Compromise decree ಆದ್ಮೇಲೆ, after the compromise decree and filing of OS number 846 of 2016, one of the sisters by name Vijay Lakshmi, one of the sisters of Madhavrao and Govindrao.
And Rangarao.
Rangarao.
No, one of the sister and the children of the other deceased sisters.
ಅಲ್ಲ, Vijay Lakshmi.
ಅಲ್ಲ ಅಲ್ಲಿ ಹಂಗ ಅಷ್ಟೇ ತೋರಿಸಿದ್ದಾರೆ,
others.
but ಅದು ಅಲ್ಲಿ there are other plaintiffs also.
As per
Only one sister,
One sister
the rest of
and
them are-
others are the children.
Yes, of the other sisters. One sister.
Deceased sister.
Of Madhavrao and ಯಾರು ಹೇಳಿ? ಅಲ್ಲ, Vijay Lakshmi ಅಂತ ಬರ್ತದೆ. Vijay Lakshmi,
And
sister of Madhavrao and Rangarao and
in-laws of others.
the in-laws of other sisters of the said parties have filed OS number 764 of 2019. ಯಾವ ಕೋರ್ಟ್ ಅಂತ ಬರ್ದಿಲ್ಲ ನೀವು ಇಲ್ಲಿ.
Senior civil judge Devanalli.
Additional senior civil judge.
Plaint ಕೊಟ್ಟಿದ್ದಾರೆ ಸೊ.
Additional senior civil judge Devanalli.
Proceedings have been stayed in CR.
ಅದರಲ್ಲಿ
ಅದು ಬೇರೆ ಇದೆ 130.
ಹೌದು
ಅಲ್ಲಿ 7-11 ಆಗ್ತಿವಿ, ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗುತ್ತೆ, ಅದ್ರ ಮೇಲೆ CRP ಆಗ್ತದೆ. ಆ
ನಾವೇ
CRP
ಹಾಕಿದೀವಿ.
ಇದೆ 700.
No, I mean, let me make myself. I filed an application for rejection of that claim on available ground. The trial court rejected it and a CRP is filed before this honorable court. In the CRP, the notice is ordered and what the person stayed. Number ಕೊಟ್ಟಿದ್ದಾರೆ.
Suit.
Pending before additional senior civil judge.
Plaintiff appellants filed application, similar application, namely under order 7 rule 11 CPC, and that was rejected. Against that order, they have preferred CRP number 138 of 2022 before this court. And now the proceedings in OS number 764 of 2019 are stayed. The
Father.
applicant BL Narayana, defendant number 6 alla illi. The present defendant number 6 BL Narayana, who filed on whose application the impugned order is passed, has filed OS number 1061 of 2019 against the plaintiffs of this suit for partition and separate possession of his 1/4 share. ಅದು WPL ಸ್ಟೇ ಆಗಿದೆಯಾ? ಆ WPR
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ ನಾವು IFR ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕಿದ್ವಿ ಅಲ್ಲಿ ಈ ಕೇಸಲ್ಲಿ, ಅದು ರಿಜೆಕ್ಟ್ ಆಯ್ತು. That order is challenged in the writ petition which is mentioned.
against some interim order passed in the said case. ನೀವು appellants ಹಾಕಿರೋದು.
there is ಎಲ್ಲ appellants.
Appellants have filed WP number 19,222 before this court, and the proceedings in OS number 1061 of 2019 are stayed in that writ petition. Thereafter, ಯಾರು ಅಶ್ವಥ್ ಈ ಕೇಸ್
Father of the appellants 1 and 2 ಒಂದು.
Father of the appellant ನಿಮ್ಮವ್ರು ಏನೋ ಜಾಸ್ತಿ
ಎಲ್ಲ ಅವರೇ, ನಮ್ದು ಏನು ಒಂದು ಸೂಟ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ ಬಿಟ್ರೆ ಏನು ಇಲ್ಲ.
has filed OS number 8026 of 2023 against Venkatesh ಅಂದ್ರೆ ಯಾರು?
ಅದೇ ಇದೇ ವೆರಿ ಅಪ್ಪ ತಂದೆ ಮಕ್ಕಳ ಮೇಲೆ ಸೇರಿಸಿ ಹಾಕಿದ್ದಾರೆ.
Present appellants
And other defendants
partition
and others.
and
ಅವರು ಇದರ ಪಾರ್ಟಿ ಇದ್ದಾರೆ.
ಇರ್ಲಿ ನಿಮ್ ತಂದೆನೆ.
dependents of this, other dependents of this suit.
Plaintiffs and defendants all.
that suit is also
This is pending before 14th addition.
ಯಾವ ಕೋರ್ಟ್ ಅಂತ
ಇದು ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಮೇಲೆ
14th additional city civil court.
ಅಲ್ಲ CCH 14 ಅಂತ ಬರೆದಿದೆ.
It is 13.
ಇದರಲ್ಲಿ ಅಡಿಷನಲ್ ಸಿಟಿ
okay.
ಅಂದ್ರೆ ಒಂದು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ ಅವನ್ನೆಲ್ಲ ಒಂದೇ ಕಡೆ ಬರಬೇಕು ಅಂತ
ಆಗ್ಬೋದು.
we can pass order to transfer them.
Yes, ma'am.
Therefore,
13.
appraisal, the list of the said cases are
CCH 13 13.
stated under in a tabular form below ಅಂತ ಹೇಳಿದ್ರೆ ಹಾಕೊಳ್ಳಿ. The above facts go to show that the parties, at least some of the parties, are abusing the process of the court and ನೀವೇ ಸೇಲ್ ಮಾಡಿ ಮತ್ತೆ ನೀವೇ ಒಬ್ಬರ ಹತ್ರ ಕೇಸ್ ಹಾಕ್ಸೋದಾ?
ಅವರೇ ಇದರಲ್ಲಿ ಎರಡನೇ ಮಾತಿಲ್ಲ, ಅದು ಮ್ಯಾಟರ್ ಆಫ್ ರೆಕಾರ್ಡ್.
ನಮ್ ತಾಯಿ ತೀರೋದ್ಮೇಲೆ
ಹೋದ್ಮೇಲೆ ನೀವು ಮಾಡಿ
ನಾವ್ ಹೇಳ್ತೀವಿ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಅಲ್ಲ ಹೇಳ್ತಾ ಇರೋದು ಅವ್ರ 100 ಹೇಳ್ತಾರೆ, ಬಟ್ ಕೋರ್ಟ್ ಮುಂದೆ ಓಪನ್ ಆಗಿ ಕಾಣಿಸ್ತಾ ಇದ್ರೇನೋ ಅವ್ರು ಮತ್ತೆ ಅಬ್ಲಿಗೇಷನ್ಸ್ ಮಾಡ್ತಾನೆ ಇದಾರೆ. Yes, my lord, everything we will take contention in that writ petition.
ಯಾರು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಅದು ಎಷ್ಟು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದು ಅದ್ರಲ್ಲಿ?
ಅಲ್ಲ ತಾವೇ ಈಗ ನೋಡಿದಿರಿ, CRP ಹಾಕಿದ್ದವ್ರೆ, IA ಹಾಕಿದ್ದವ್ರೆ, ರಿಜೆಕ್ಷನ್ ಆಫ್ ಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದವ್ರೆ, ಅದರ ಮೇಲೆ IA ಸ್ಟೇ ಮಾಡಿಸಿದವ್ರೆ, ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದ್ದವ್ರೆ, ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕಿದ್ದವ್ರೆ. ಅದು ಒಂದು ಸೂಟ್ ಅದರಲ್ಲಿ ಇವರೇ ತಾನೇ ರೂಲ್ 10 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು.
ಹಾಕೋಬಾರ್ದು ಅಂತ ಇಲ್ವಲ್ಲ,
ಅದಕ್ಕೆ ನಾವು 2 Rule 2 ಹಾಕಿದ್ವಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೈಟ್ಲಿ ಹೆಲ್ಡ್ ದಟ್ ಇಟ್ ಈಸ್ ಎ ಬಾರ್ಡ್ ಅಂತ ಸ್ವಾಮಿ.
My suit only is with respect to cancellation of release deed. That is a different cause of action. My suit, my lords, by Narayan, OS 1061 is for partition and cancellation of release deed.
ಯಾವ ರಿಲೀಸ್ ಡೇಟ್ ಹೇಳಿ?
My lords, release deed dated.
ನೀವು ಅವ್ರ ಪಾರ್ಟಿ ಯಾಕೆ ಮಾಡಿರ್ಲಿಲ್ಲ? ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ರಿಲೀಸ್ ಡೇಟ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅಷ್ಟೇ. ಅಲ್ಲ, ಸೀಕಿಂಗ್ 1/4 ಶೇರ್ ಇನ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟೀಸ್ ಅಂಡ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ರಿಲೀಸ್ ಡೇಟ್.
18 January 23, my lord.
Clearly show that the parties are abusing the process of the court and indulging in multiple proceedings before the trial court and before this court. There is a great need to curtail this tendency. Therefore, ಯಾವ ಕೋರ್ಟಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬೇಕು ಈಗ? ಅರ್ಲಿಯರ್
ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ಹಾಕಿ ಸ್ವಾಮಿ, ಬೆಂಗಳೂರಿಗೆ.
ಕೋರ್ಟ್ ಅವು
ಇದೆಲ್ಲ ದೇವನಹಳ್ಳಿ ದೂರ, ಇಲ್ಲೇ ಇದೆ ಕನ್ವೀನಿಯಂಟ್.
4 suits are in Devnalli, my lord.
ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲ ದೇವನಹಳ್ಳಿ ಅಲ್ವಾ?
ಅಲ್ಲ, ಇಲ್ಲಿ ಬೆಂಗಳೂರ್ದು ಇದೆ, ಬೆಂಗಳೂರ್ದು ಇದೆ, ಅದಕ್ಕಾಗಿ ಹೇಳ್ತಾ ಇರೋದು.
ಹಾಗಾದ್ರೆ ಯಾವ್ದ್ರ ಒಂದ್ ಕೋರ್ಟಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
My lords, the last suit is pending before CCH 13.
ಫಾದರ್ ಸೂಟ್ ಅಲ್ಲಿಗೆ ಮಾಡಿ.
My suit is pending before senior.
ಬರ್ತಾ ಇರ್ಬೇಕು. ನಿಮ್ದು ನೋಡ್ಬೇಕು ಅಂದ್ರೆ ಈಸ್ ಒಂದ್ಸರಿ
ಲ್ಯಾಂಡ್ಸ್ಕೇಪ್ ಅಲ್ಲಿ ರಿವರ್ಸ್ ಹಾಕಿ ಪ್ರಿಂಟ್ ತೆಗಿಬೇಕಾದ್ರೆ
ಈಗ ಎಕ್ಸೆಪ್ಟ್ ದಿಸ್ 8026 all other courts are pending before
Devnalli, but here all properties are there. ಅಲ್ಲಿ ಸ್ವಲ್ಪ only properties
ತಕೊಂಡಿದ್ದೀರಿ. ಆಮೇಲೆ ಇದು ಯಾವ್ದು? ನೀವು ಫಸ್ಟ್ 896 ಹಾಕಿದ್ದು ಯಾವ್ದು? ದೇವನಹಳ್ಳಿ ಮುಂದೆ ತಾನೆ.
ನಮ್ದು ಅಷ್ಟೇ ಕಾಂಪ್ರಮೈಸ್ ಆಯ್ತು, ಅದು ಕ್ಲೋಸ್ ಆಗಿ. ಅದು 4 ಪ್ರಾಪರ್ಟಿ
in Devnalli.
Part of the properties are in Devnalli jurisdiction and part of the properties are in Bangalore.
ಬೆಂಗಳೂರು ಬರುತ್ತೆ.
ಇಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲಾದ್ರೆ ಅನುಕೂಲ ಆಗುತ್ತೆ ಅಂತ.
Maybe
ಈಗ 20 properties are there. Out of 20 properties, how many properties are in Devnalli?
all matters may be transferred.
ಪೆಂಡೆನ್ಸಿ ಹೇಗಿದೆ ಅಲ್ಲಿ?
ಬಹಳ ಇದೆ.
ದೇವನಹಳ್ಳಿನಲ್ಲಿ
suits and cross suits are plenty in all the courts around Bangalore.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಹಾಗೆ ಇರುತ್ತಲ್ಲ.
All the
Since 846
ಅಲ್ಲ, ಮೈಸೂರ್ದು ಒಂದು ಯಾವ್ದೋ 2 ಹಾಕಿದ್ದಾರೆ. ಮೈಸೂರು ಪ್ರಾಪರ್ಟೀಸ್ 2 ಇದೆ ಲೇಟೆಸ್ಟ್ ಸೂಟ್ ಅಲ್ಲಿ. Item 17 and 18 may kindly look at Millard.
ಮಧ್ಯದಲ್ಲಿ ರಾಮನಗರ ಬಂಡೆ ಕಳಿಸ್ಬೇಕಾ? 2
Since 846
page 160.
The schedule of this case is at page number
85, my lords. 85.
ಇದು ಬಿಟ್ಟು ಇನ್ನೂ ಪ್ರಾಪರ್ಟೀಸ್ ಇದಾವ ಇಲ್ಲಿರೋದು ಬಿಟ್ಟು?
ಹೌದು ಸ್ವಾಮಿ, ಅದನ್ನ ಬಿಟ್ಟು ಇಲ್ಲಿ ಬೇರೆ ಪ್ರಾಪರ್ಟೀಸ್ ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲಿ ಬರೀ ಪ್ರಾಪರ್ಟಿ ಬೇರಿಂಗ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಯಾವ ಊರು ಅಂತ ಹೇಳೇ ಇಲ್ಲಲ್ಲ. ಎಲ್ಲ ಒಂದ್ ಕಡೆ ಎಲ್ಲಾದ್ರೂ ಹೇಳಿದೀರಾ?
ಇಲ್ಲಿ
all above properties are situated at
ಚಾಗ್ಲಟ್ಟಿ ವಿಲೇಜ್,
ಜಾಲಹೋಗ್ಲಿ, ಬೆಂಗಳೂರು ನಾರ್ತ್ ತಾಲೂಕು.
ಅದು ಬಂದು ದೇವನಹಳ್ಳಿ jurisdiction.
1 to 6 ಅದು.
ಹೌದು.
ಇದು ಎಲ್ಲ ಜಾಲಹಳ್ಳಿನೇ ಇದೆ.
7, 8 is also in Bangalore.
7 and 8 are also.
9 also. 10.
Bangalore. Item 12 and 13 ಮೈಸೂರ್ ಅಂತ ಇದೆ.
11 Bangalore ಅಂತಾನೆ.
ಇನ್ನೊಂದು ಕುವೆಂಪು ನಗರ್ ಮೈಸೂರ್.
Again Bangalore.
ಸೊ ಮೇಜರ್ ಇಲ್ಲಿ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ 17, 18 ಎಲ್ಲ ಬೆಂಗಳೂರು ನಾರ್ತ್ ಆಯ್ತು ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗ್ತದೆ ಎಲ್ಲ ಸಿನ್ಸ್ ಮೆಜಾರಿಟಿ ಆಫ್ ದ ಪ್ರಾಪರ್ಟೀಸ್ ಆರ್ ಸಿಚುಯೇಟ್ ಏನಂತ if cases are pending before different courts there is the likelihood of conflicting judgments and multiplicity of the work. Therefore, all the cases can be consolidated and yavralli evidence comments agilla tane innu evidence can be recorded in one suit.
It can be connected with 8026, all of them.
Therefore, adu yavado suit iga case number 846 of 2016 adu pending on idu court number court ಹೆಸರು ಬರ್ಕೊಳ್ತೀರಾ?
Senior civil judge and JMFC Devanalli.
ಅವರು ಈ ಲಿಸ್ಟ್ ನೋಡಿ ಬರ್ಕೊಳ್ಳಿ ಕೋರ್ಟ್ ಹೆಸರು ಅಷ್ಟೇ ಬರ್ಕೊಳ್ಳಿ ಅಂತ 764 of 2019 ಎಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ?
Additional senior civil judge Devanalli.
ಬರೀಲಿಲ್ಲಲ್ಲ ನೀವು ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ದೇವನಹಳ್ಳಿ and this circus ಮಾಡಬೇಕು 1061 is pending before
Senior civil judge Devanalli.
ಓಕೆ ಹಿಂಗೆ OS ನಂಬರ್ ಒಂದೇ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಕೋರ್ಟ್ ಇರೋದು ಅದು
ಇಲ್ಲ
Only the
ಮೂರು ಇದೆ ಈಗ
second matter is in additional.
ಎಲ್ಲ ಬೇರೆ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದಾವ ಒಂದೇ ಸೀನಿಯರ್
ಇಲ್ಲ, ಬೇರೆ.
ಅದನ್ನ ಹಂಗಾದ್ರೆ ಕೋರ್ಟ್
The first suit and the third suit is in senior civil.
OS number 846 of 2016, 764 of 2019, and 1061 of 2019 are withdrawn from the senior civil judges court, Devanhalli, and hereby transferred to ಯಾವ್ದಿದು
14th additional, CCH 13.
4th additional ಅಂತ ಬರೆದಿದೆ 4th additional ಅಂತ
Apologies. 14th.
14th additional city civil and session judge Bangalore into bracket CCH number 13 for common trial and adjudication. The said court shall consolidate all the suits and record the common evidence and dispose of them by common judgment. To avoid further delay, the parties are hereby directed to appear before the 14th additional city civil and session judge Bangalore on
The next hearing date is 31/8, my lords, before.
It's a short day. ಇದು ಹೋಗೋಕೆ
ಅಲ್ಲಿಂದನೂ
ಆರ್ಡರ್ ಕರೆಕ್ಷನ್ ಮಾಡಿ ಕಳಿಸ್ಬೇಕು
ದೇವನಹಳ್ಳಿಯಿಂದ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ಬರ್ಬೇಕು ಮತ್ತೆ
ಅವ್ರಿಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಆಗ್ಬೇಕು ಒಂದು ಡೇಟ್ ಹೇಳಿ ಅದ್ರ ಮುಂದೆ
15
ಸೆಪ್ಟೆಂಬರ್ ಫಸ್ಟ್ ವೀಕ್ ಆರ್ ಸೆಕೆಂಡ್ ವೀಕ್ ಒಂದು ಡೇಟ್
second 12/9/2024 without any further notice. The petition is allowed ಅಂತ ಬರಲಿಲ್ಲಲ್ಲ ಈಗ ಏನ್ ಹೇಳಿದ್ರಲ್ಲಿ ಅಲ್ಲಿ necessary to so and so ಆದ್ಮೇಲೆ they shall be consolidated and common evidence shall be recorded ಅಂತ ಅಷ್ಟೇ. Hence the following order ಅಂತ ಅಂದ್ಕೊಂಡು the appeal is allowed. The impugned
page 26
4/12/2023 in OS number 846 of 2016 on the file of principal senior civil judge ಇದ್ರದ್ದೆಲ್ಲ ಒಂದು ಸಿಗುತ್ತೆ principal senior civil judge ದೇವನಹಳ್ಳಿ is hereby set aside. IA number 6 in OS number 846 of 2016 filed under order 7 rule 11D is hereby rejected.
item 1 to 6 1 observation. 1 to 6 1 observation.
WC it will take care of it.
ಮಾಡಿ ಓಕೆ ಆದ್ರೆ ಅದಕ್ಕೆ ನಾವು ಹೇಳಿದ್ವಿ ಅವ್ರು ಪ್ಲೇಂಟಿಫ್ಸ್ ಅಲ್ಲ ಅಂತ ಹೇಳಿ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಒಂದೇ ಅಲ್ಲ ಅಂತ ಸುಮ್ನೆ ಈ ತರ ಮಾಡೋದ್ರ ಬದಲು ಒಂದ್ಸರಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ಮುಗಿಸ್ಕೊಳ್ಳಿ ಎಲ್ಲೆಲ್ಲ. You may be right. We are also feeling your parties are also not.
They need to be guided correctly. That's what
You are also smelling it now. They set up their father and.
ಇಲ್ಲ ಫಾದರ್ ಸೆಟಪ್ ನಮ್ಗೆ ಇನ್ನೂ ಸಮನ್ಸ್ ಬಂದಿಲ್ಲ. That is a totally different suit. Recent development ಅವರೇ ನಮ್ಗೆ ಹೇಳಿದ್ದು. ಅವರೇ ನಮ್ಗೆ ಹೇಳಿದ್ದು ಈಗ ಗೊತ್ತಾಗಿತ್ತು. ನಮ್ಗೆ ಸಮನ್ಸ್ ಬಂದಿಲ್ಲ.
ಅವ್ರ ತಂದೆ ಬಗ್ಗೆ ನಾವು ಹೇಳಿದ್ದು.
ಮತ್ತೆ ಯಾರೋ ಬಂದು ಆ ಸೇಲ್ ಡೀಡ್ ಅನ್ನ ಕ್ವಶನ್ ಮಾಡ್ಕೊಂಡು ಇನ್ನೊಬ್ರು ಸಿಸ್ಟರ್ಸ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ.
Sisters are a different branch.
ಸರಿ. OS number 846 of 2016 ಅದಕ್ಕೆ ಈಗ ಹೇಳಲ್ಲ ನಾನು 764 of 2019 ಆ ಕೋರ್ಟ್ಸ್ ಹೆಸರು ಮುಂದೆ ಬರ್ಕೊಂಡ್ವಿ 1061 of 2019 on the file of senior civil judge ಒಂದು principal senior civil judge and JMFC Devnalli and ಇನ್ನೊಂದು ಯಾವ್ದು additional
Only 764 is before additional.
Additional senior civil judge Devnalli are hereby withdrawn and transferred to fourth additional city civil and session judge. 14th additional, 14th additional city civil and sessions court into bracket CCH number 13, Bangalore for common trial along with OS number 8026 of 2023 pending before the said court. Illi barkolalla. To avoid further delay, the parties in the above cases are hereby directed to appear before
CCH number 13.
14th additional citizen. In OS number 8020. Before 14th additional city civil and session judge, Bangalore on 12/9/2024 without further notice. ಈಗ ಇದ್ರಲ್ಲಿರೋ ಕೆಲವೊಂದಿಷ್ಟು ನನ್ನ ಪಾರ್ಟಿ ಅವ್ರ ಇದ್ದಂಗೆ
ಇನ್ನು ಸುಮಾರು ಜನಕ್ಕೆ ನೋಟಿಸ್ಗಳು ಒಂದಷ್ಟು
ಇಲ್ಲ
ಹೌದು ಅವ್ರಿಗೆಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾಗತ್ತೆ.
ಸೂಟ್ ನಂಬರ್ ಚೇಂಜ್ ಆಗ್ತವೆ ಇಲ್ಲಿ ಬಂದ್ಮೇಲೆ.
ಹೌದು. That court may take a issue appropriate notice to the other parties who are not there to.
ನಾವು ವಿತೌಟ್ ಫರ್ದರ್ ನೋಟಿಸ್
ಅಲ್ಲ ನಾವು ನಮ್ಗೆ ಸರಿ ಬೇರೆಯವರಿಗೆ
ಸಿಟಿ ಸಿವಿಲ್ ಜಡ್ಜ್ಗೆ ಕಷ್ಟ ಆಗುತ್ತೆ ವಿತೌಟ್ ಫರ್ದರ್ ನೋಟಿಸ್ ಅಂತ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿಂದ
to the parties to this appeal ಅಂದ್ರೆ ಸಾಕು because we are only the parties now.
Yes. ಈಗ ಯಾರಿಲ್ಲ ಇಲ್ಲಿ ಸಿಸ್ಟರ್ಸ್ ಇಲ್ವಾ?
ಸಿಸ್ಟರ್ಸ್ ಇಲ್ಲ, ಅಶ್ವಥ್ ಇಲ್ಲ. ಅಶ್ವಥ್ ಅಂತ ಅಲ್ಲೇ ಇದ್ದಾರೆ. ಈಸ್ ಇನ್ ದಿ ಸೇಮ್ ಕೋರ್ಟ್.
ಅಲ್ಲ ಹೀಸ್
ಫಾದರ್ ಅವ್ರ ಫಾದರ್
ಅವರಿದ್ದಾರೆ, ನಾರಾಯಣ ಇದ್ದಾರೆ. ಈಗ ಸಿಸ್ಟರ್ಸ್ ಮಾತ್ರ
ಸಿಸ್ಟರ್ಸ್
ಟ್ರಯಲ್ ಕೋರ್ಟಿಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡೋದಕ್ಕೆ ಕಷ್ಟ ಆಗುತ್ತಲ್ಲ. ಈ ವಿಜಯಲಕ್ಷ್ಮಿ ಕೇಸಲ್ಲಿ ಇಲ್ಲ ಅಲ್ವಾ? OS 1764 ನೀವ್ ಯಾರು ಅವ್ರನ್ನ ಅಪಿಯರ್ ಮಾಡ್ಸಕ್ ಆಗಲ್ವಾ?
They are all parties in
our 8 members are there in that suit plaint.
They are all parties in CRP 138 of 2022. ಅಲ್ಲಿ ನಾನೊಂದು ಮೆಮೊ ಹಾಕ್ತೀನಿ ಹಿಂಗೆ ಆಗಿದೆ ಅಂತ. Because after all it is in the interest of all the parties.
ಇಲ್ಲ ಒಂದು ಕೆಲಸ ಮಾಡ್ತೀನಿ, ನಿಮಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀವಿ, ಶಲ್ ಸರ್ವ್ ದ ಕಾಪೀಸ್ ಅಂತ.
ಇಲ್ಲ ನಾನು ಇಷ್ಟೇ ಹೇಳ್ತೀನಿ, ಇದನ್ನ 138 ಅಲ್ಲಿ ಅವರೆಲ್ಲ ಪಾರ್ಟೀಸ್ ಇದ್ದಾರೆ, ಯಾರು ಸರ್ವ್ ಆಗಿದೆ. ಐ ಫೈಲ್ ಎ ಮೆಮೊ ಇಂಡಿಕೇಟ್
ಒಂದ್ಸರಿ ಅವ್ರಿಗೆ ಅಷ್ಟೇ ನೋಟಿಸ್ ಕೊಡ್ಲಿ. ಪ್ಲೇಂಟಿವ್ಸ್ ಆಫ್
1 to 8 in that plaintiffs 1 to 9 is that.
Plaintiffs in OS number 764 of 2019
also
are to be notified.
Since the plaintiffs in OS number 764 of 2019 are not parties in this case, the trial court shall issue notice only to those plaintiffs.
And other purchasers ಯಾರನ್ನ ಮಾಡಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ.
ಎಷ್ಟು ಕಾಂಪ್ಲೆಕ್ಸ್ ಇದೆ ನಿಮ್ದು, ನಾವ್ ಏನ್ ಮಾಡಿದ್ರು ಮುಗ್ಸಕ್ ಸಾಧ್ಯನೇ ಆಗ್ತಾ ಇಲ್ಲ
ನೋಡಿ. ಪಾರ್ಟೀಸ್ ಪರ್ಚೇಸರ್ಸ್ ಇದಾರೆ ಸ್ವಾಮಿ, ಅದೇ ಅಗೈನ್ ಡಿಫೆಕ್ಟ್ ಆಗ್ಬಾರ್ದು. ಅವ್ರಿಗೂ ನೋಟಿಸ್ ಹೋಗದೆ ಇದ್ರೆ ಬಿಕಾಸ್ ದೇ ಆರ್ ನಾಟ್ ಪಾರ್ಟೀಸ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ನಮ್ಮ ಪರ್ಚೇಸರ್ಸ್ ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡುವಾಗ
ಏನಾರ ಮಾಡಿ ಒಂದು ರೌಂಡ್ ಅಪ್ ಮಾಡೋಣ ಅಂದ್ರೆ ಅದು
The appellants can serve copies on the council.
ಅಷ್ಟೇ ಅವ್ರದೇ ಸೂಟ್ ಅವ್ರು ಸರ್ವ್ ಮಾಡಿ.
ನಮ್ ಸೂಟ್ ಅಲ್ಲ, ನಾವು ಡಿಫೆಂಡೆಂಟ್ಸ್ ಅದ
ಇಲ್ಲಿ ಅಪ್ಲೆಂಟ್ಸ್ ಅಲ್ವಾ
ಇರ್ಬೋದು.
ಇಲ್ಲ ಅಂದ್ರೆ ಆಯಾ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆ ಕೋರ್ಟ್ಸ್ ಅವ್ರಿಗೆ ನೋಟಿಫೈ ಮಾಡ್ಲಿ ಬಿಡಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಈಗ ನಾವ್ ಎನಿವೋ ದೇ ಆರ್ ಪ್ಲೇಂಟಿಫ್ಸ್. ಇಲ್ಲ ಹಾಗೆ ಮಾಡಿಲ್ಲ, ದೇವನಹಳ್ಳಿ ಕೋರ್ಟ್ ಅವರೆಲ್ಲ ಅಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್
ಅಲ್ಲ. ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆಯಾ ಇಲ್ವಾ ಇನ್ನೂ ಅದನ್ನು ವಿ ಡೋಂಟ್ ಆಕ್ಚುಲಿ ಮಿಲಡ್.
Therefore can send a copy of this order.
ವಿತೌಟ್ ಫರ್ದರ್ ನೋಟಿಸ್ ಅಂದ್ರೆ ಹೀಗ್ ಮಾಡಿದ್ರು. Parties to this appeal shall appear before the court without any further notice. ಅದಾದ್ಮೇಲೆ the trial the alert city civil court ಅಲ್ಲಿ 14th additional city civil judge shall issue court notice
to other
parties in OS number 764 of 2019 as they are not the parties to this.
Yes.
An appearance of such on service of such notice appearance ಬೇಡ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು? The said court shall consolidate all the suits and record the common evidence and dispose of matters by common judgment as expeditiously as possible. ಪಾಪ ಅವ್ರಿಗೆ ಹಾರ್ಡ್ ನಟ್
ಒಂದು ಇನ್ನು ಅವ್ರದ್ದೇ ಟ್ರಬಲ್ ಇದೆ ಇಲ್ಲಿ ಲೀಗಲ್ಲಿ. ತಾವು ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತಾ ಇದೀವಿ ಲಾರ್ಡ್ಶಿಪ್, ಅವ್ರು ಸ್ಟೇ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಇದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈಗ ಕೋರ್ಟ್ಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗೆ ಅಲ್ಲಿ ಇದೇ ಹೈಕೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಅದನ್ನ ಎಕ್ಸ್ಪೀಡಿಯಸ್ ಆಗಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಸ್ಕೋಬೇಕು. ಅದರ್ವೈಸ್ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಇದೆ, ಆ ಕೋರ್ಟ್ ನಲ್ಲಿ ಸ್ಟೇ ಇದೆ.
We can also pass an order requesting the registrar judicial to place these two matters, CRP and WP.
Yes,
One
grateful,
court
my lord.
is
That is a grateful, my lord. Always.
There is an interim stay of this aforementioned suit granted in CRP number one, petition in CRP number 138 of 2022
And WP 254.
number 19,267 of 2022. ಇನ್ನೊಂದು ಯಾವುದು?
ಅದೇ ಎರಡೇ.
ಇವೆರಡರಲ್ಲೇ ಇರೋದಲ್ವಾ? ಒಂದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
The petition challenging the compromise.
ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಒಂದು CRP ನಲ್ಲಿ ಸ್ಟೇ ಇರೋದು.
ಅದಾಯ್ತು. ಸ್ಟೇ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದರಲ್ಲಿದೆ.
ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ಲ, ಬೇರೆದ್ರಲ್ಲಿ ಇಲ್ಲ.
CRP ಅಲ್ಲಿದೆ.
WP 1 Rule 10 ಮೇಲೆ ಹಾಕಿರೋದ್ರಲ್ಲಿ ಇದೆ.
19,267 ಅವ್ರದ್ರಲ್ಲಿ ಏನು ಇದೇ ಇಲ್ಲ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್.
ಅದು ಅವರೇ ಹಾಕಿರೋದು.
And those two matters also have some bearing in the proceedings in WP number ಎಷ್ಟದು?
ಅವ್ರದ್ದು ನಿಮ್ ನಂಬರ್ ಹೇಳಿ ಸರ್.
24544.
24,544 of 2022. Registrar judicial is hereby requested to place the matter before Honorable the Chief Justice for assigning all the matter all the matters to one bench. ಅಲ್ಲ ಹೌದು, ನೀವ್ ಹೇಳ್ದಂಗೆ ಎಕ್ಸ್ಪಿಡಿಷಿಯಸ್ಲಿ ಅಂತ ಇಲ್ಲಿ ಅಲ್ಲಿಗೆ ಇದಾದ್ರೆ ಎಲ್ಲರಿಗೂ ಸ್ಟೇನು ಇಲ್ಲಿದು ಡಿಸೈಡ್ ಆಗಿ ಹೋಗುತ್ತಲ್ಲ.
ವಿ ಡೋಂಟ್ ನೋ ಅದ್ರಲ್ಲಿ ಇನ್ನೇನು ಅಪ್ಲಿಕೇಶನ್ಸ್ ಅವ್ರದ್ದೇ. ಈಗ 1 Rule 10 ಅಂದಿದ್ದಾರೆ, ಅಮೆಂಡ್ಮೆಂಟ್ ಅಂದಿದ್ದಾರೆ. ಇದರ ತರ ಎವಿಡೆನ್ಸ್ ಆಗೋದ್ರೆ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಇಸ್ ವೆಲ್ ಕನ್ಕ್ಲೂಡ್ ಆಗುತ್ತೆ. ವಿ ಡೋಂಟ್ ನೋ ವಾಟ್ ವಿಲ್ ಹ್ಯಾಪನ್. ಪರ್ಚೇಸರ್ ಬಂದ್ ಏನ್ ಮಾಡ್ತಾರೆ, ಆಲ್ ದೇರ್ ಆರ್.
ಏನೇ ಮಾಡಿದ್ರು ಕೇರ್ ಮಾಡೋದು, ಆರ್ಡರ್ ಮಾಡೋದು ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ 7 Rule 11 ಒಂದು ಅಪ್ಲಿಕೇಶನ್
ಕನ್ಸಾಲಿಡೇಟ್ ಆದ್ರೆ ಮಲ್ಟಿಪಲ್ ಕೇಸಸ್ ಅಲ್ಲಿ ಮಲ್ಟಿಪಲ್ ರಿಟ್ ಪಿಟಿಷನ್ಸ್
ಅವಾಯ್ಡ್ ಮಲ್ಟಿಪ್ಲಿಸಿಟಿ ಆಫ್
ಆಗೋದಿಲ್ಲ.
ಟ್ರಾನ್ಸ್ಪರೆನ್ಸಿ ಇರುತ್ತೆ ಅವ.
But this is very inappropriate.
Only one last submission. This honorable court had granted an order of status quo.
We are opposing for that.
That kindly be continued.
Trial court, my lord, has.
For what?
My lord, we oppose for that. Illa, we are opposed for all those things, my lord.
Injunction.
Illa, we are opposing for the.
Not granting. Why are you worried?
No, I'm only
application and now even order 41 Rule 27.
between today's order, today's date and the next date before the trial court. The other side, at least till the next date, then we'll look at.
Application is already
pursue the matter there.
Trial court may take a decision, my lord.
I was correct, but.
ಅವ್ರದ್ದು vacating application pending ಇದೆ.
ಹೌದು.
ಅವಾಗ dispose ಮಾಡ್ಬೇಕು. Yes, my lord.
They are not granting it. This is very, ನಾವು ನೋಡಿದ್ವಿ ಅದು ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ರಿಮೋಟ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಆಗುತ್ತೆ, ಅದು ಬೇಡ. So you advise the parties.
Till 12/9, my lord.
ಕೋರ್ಟ್ ಪಾರ್ಟ್ಸ್ ಆಗ್ಬಿಟ್ಟಿರ್ತಾರ ಅವರು.
12/9 ತನಕ ತಾವು ಅದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರೆ then will I mean.
No, my lord, we are opposed.
Going to do it.
ಅಲ್ಲ ಏನು ಅದು
ನೋಡಿ ಅವ್ರು ಹೇಳಿದ್ದು ನಿಮ್ದು ಐಟಮ್ ನಂಬರ್ 1 to 6 ಪ್ರಾಪರ್ಟೀಸ್ ಇಟ್ ವಾಸ್ ನಾಟ್ ಕ್ಲಿಯರ್ ಕೇಸ್, ಬಟ್ ಏನೋ ಪ್ಲೆಂಟಿಫ್ ಅಂತ ಇದೆ ಮತ್ತು ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅದೆಲ್ಲ ಇದೆ.
that is some fundamental principle.
ಕಾಂಪ್ರಮೈಸ್ ಅದೇ ಸೆಟಲ್ಮೆಂಟ್ ಕರಿಸಿ ಇನ್ನೂ ಒಂದು ಸೆಟಲ್ಮೆಂಟ್ ಎಕ್ಸೆಪ್ಟ್ ಫ್ಯೂ ಮ್ಯಾಟರ್ಸ್. ನಮ್ಗೆ 5 ಗಂಟೆಗೆ ಮೀಟಿಂಗ್ ಇದೆ, ಉಳಿದವ್ರು ಡೇಟ್ ಕೊಟ್ಟು ಯಾವ್ದಾದ್ರು ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಲ್ಲ ಇರೋದು.
Number 51.
ರಿಪಿಟೇಷನ್ ಬೇಡ. ಅತ್ತಡೀರಿ ಒಂದಿತ್ತಲ್ಲ ಯಾವ್ದೋ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಇಂದ ಒಂದಿತ್ತಲ್ಲ, ಇದು ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲ, ಡಿಕ್ಟೇಷನ್ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲ. ಇವ್ರದ್ದು ಒಂದು 2 ದಿವಸದಿಂದ ಡಿಕ್ಟೇಷನ್ ರೀಸನ್ಸ್ ಟು ಫಾಲೋ ಅಂತ ಮಾಡ್ತೀವಿ. ಹಾ, ನಮ್ಗೆ ಡಿಕ್ಟೇಷನ್ ಮಾಡೋಣ ಅಂತ ಮಾಡ್ತಿದ್ರೆ ಇಲ್ಲಿ ಹಾಕ್ತಾ ಇನ್ನೊಂದ್ ದಿವಸ ಇಟ್ಕೊಳ್ಳೋಣ. ಇಟ್ಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್ ಇಫ್ ಯು ಕ್ಯಾರಿ ಇಟ್ ಟು ದ ಚೇಂಬರ್. ಅದಕ್ಕೆ ಇಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ವಿ.
Number 37.
37.
It's not 30.
ಒಂದ್ ನಿಮಿಷ
the-
ರೀಸನ್ಸ್ ಟು ಫಾಲೋ ಮಾಡ್ತೀವಿ. ಕೊಡಿ
Applying for the appellant, my lord.
Accepted classes. ಅದೆಲ್ಲ section
Let's 37, 36 minutes.
One ನಿಮಿಷ, MFA 65 of 6505 of 2017, serial number 37. Heard further, appeal dismissed, reasons to follow. Yes. We are not finding any grounds, Mr. Abhinay.
Very well, madam.
ಯಾವ್ದಿದು 37 ಯಾರು?
36.
ಈ ಕಾಂಪ್ರಮೈಸ್ ಅವ್ರು ಯಾರ್ಯಾರು ಎಷ್ಟಿದೆ ಈಗ ಪಾಪ ಉಳ್ದವ್ರು ವೇಟ್ ಮಾಡ್ಸೋದ್ ಬೇಡ.
ಕಾಂಪ್ರಮೈಸ್ ಸೀಲ್ ನಂಬರ್ 36 ಒಂದಿದೆ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್. ಆಮೇಲೆ 51 ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
36, 51 ಮತ್ತೆ
ಅಷ್ಟೇ ಮೇಡಮ್.
except 36 and 51 other matters will be adjourned.
34 ದಲ್ಲಿ ನಾನು ಒಂದು ಮೂವ್ ಮಾಡಿ ನಿನ್ನೆ ಇವತ್ತು ಮಾಡ್ಕೊಂಡು ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್.
ಹಾಗಾದ್ರೆ ವೇಟ್ ಮಾಡಿ, ನೀವು ವೇಟ್ ಮಾಡಿ, ಉಳ್ದವ್ರಿಗೆ ಯಾರಿಗೆ ವೇಟ್ ಮಾಡಿ.
I will definitely wait. I will definitely wait.
Lord, serial number 25, my lords.
ಆಯ್ತು, ಈಗ ಇಟ್ಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್.
12 ಸೆಟ್ಲ್ ಆಗಿದೆ.
ನಂಬರ್ 12
ಅದು ಬಂದಿಲ್ಲಲ್ಲ ಹೆಗ್ಡೆ ಅವರು.
For the appellants, your lordship.
You are going to withdraw the matrimonial case?
Let it be posted next week, your lordship. We'll keep the parties present and file the compromise petition.
ನೋಡಿ ಅವ್ರು ರೆಡಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ
ಅಲ್ಲ, ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆ, ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ, ಬಟ್ ವಿ ಆರ್ ನಾಟ್ ಅವೇರ್ ಆನ್
ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು?
12.
ಏನು ಸೀಕ್ ಟೈಮ್ ಟು ಕೀಪ್ ದ ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್ ಅಂತ ಬರ್ಕೋಬೇಕಾ?
Settled and
Withdraw ಮಾಡ್ಲಿ.
parties to be present.
ಅವ್ರ ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್. ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ.
ನಿಮ್ ಪಿಟಿಷನ್ ಅಲ್ವಲ್ಲ, ಅವ್ರು
ಅದೇ ಅದೇ ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್ ನಾವು ಇರ್ಬೇಕಾಗ್ತದೆ.
both council that matter is settled. Appellant's counsel seek adjournment. Then keep the party present. ನೀವು ಅವ್ರ ಪಾರ್ಟಿನ ಯಾಕೆ ಪ್ರೆಸೆಂಟ್ ಇಡಬೇಕು? ನಿಮ್ ಪಾರ್ಟಿ ವಿತ್ಡ್ರಾ ಮಾಡೋದಕ್ಕೆ
ನಾವು ಸಿಗ್ನೇಚರ್ ತಗೊಂಡಿಲ್ಲಕ್ಕ ಪಾರ್ಟಿದು ಟು ವಿತ್
ಕರೆಕ್ಟ್. ಯು ಕೀಪ್ ಯುವರ್ ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್ ಇಫ್ ಯು ವಾಂಟ್.
ಪ್ಲೀಸ್ ಓನ್ಲಿ ಫಾರ್ ಆರ್ ಪಾರ್ಟಿ.
ಏನಂತೆ? Appellant's counsel seek time to keep the appellant present. Okay. List all.
Serial number 42.
List 22-8.
22.
21.
Lord, serial number 25, my lords.
May request on
It is
21.
listed for condemnation of delay.
22 ಇರೋದಿಲ್ಲ.
Lord,
21.
serial number 25.
2180.
Not on 21st.
22 ಅಂತ ಹೇಳ್ತಾರೆ.
22 or 23rd, my lord.
ಮೇಡಮ್, ಈಗ ಏನು ಒಂದು ಎಲ್ಲ ಡಿಜಿಟಲಿ ಬರುತ್ತೆ, ಒಂದು ಮೆಮೊ ಸೈನ್ ಆಗಿದ್ ಬೇಕು ಅಂದ್ರೆ ಕರೆಸ್ಕೊಂಡ್ ಹಾಕೋಬೇಕು. ಪಾರ್ಟಿನೂ ಬೇಕಾಗಿಲ್ಲ ಅದಕ್ಕೆ. ಹೆಗ್ಡೆ ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ, ಹಾಗಾದ್ರೆ ಇನ್ನು 2 ದಿವಸಕ್ಕೆ ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ.
2 ದಿನಕ್ಕೆ ಆದ್ರೆ ಪರವಾಗಿಲ್ಲ, ಬಟ್ 21st 2:30 ಮ್ಯಾಟರ್ ಇದೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಮೆನ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಇದು ಖಾಲಿ.
ಇವತ್ತು ಎಷ್ಟು ಡೇಟ್? 21 ಆದ್ರೆ ಪರವಾಗಿಲ್ವಾ ನಿಮ್ಗೆ?
22nd is fine.
20th ಆಗ್ಬೋದು ತೊಂದ್ರೆ ಇಲ್ಲ.
22nd ನಿಮ್ಗೆ
ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್
ಇಬ್ರು ಇದೀರಲ್ಲ, ಒಬ್ರು ಇದ್ರೆ
ಟ್ರಾಲಿಗೆ
ಸಾಕು.
ಹೋಗ್ತಾ ಇದ್ದೇವೆ.
ನೀವು ಹೋಗಿ ಪರವಾಗಿಲ್ಲ, ಅವ್ರು ಇರ್ತಾರೆ.
ಅವ್ರು ಟ್ರಯಲ್ ಮತ್ತೆ ಅಲ್ಲಿ 2 ಕರೆ
ಯಾರೋ 3ನೇವ್ರನ್ನು ಇಟ್ಟಿದ್ರಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್, ಅವ್ರನ್ನ ಕಳಿಸಿ.
ಸರಿ.
ಎಸ್ ಡೇಟ್
ಅಲ್ಲ 21st ಗೆ ಯಾಕಂದ್ರೆ ವಿಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ
21 ಅವ್ರು ವಿತ್ಡ್ರಾ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮುಂದ್ ಬೇಕಂದ್ರೆ ಹಾಕಿರ್ತಾರೆ.
ಪ್ಲೀಸ್.
ಎಸ್
21-8 ಅದು.
Serial number 25, my lords.
One after another we'll call now all the matters because all of you together.
Number 20 pastor matter Kempraju V Pradeep.
Serial number 20.
ಚಂದ್ರಶೇಖರ್ ಅವರು ಒಂದು ಮಾಡಿ ಕಳ್ಸೋಣ ತರೇರಿ, ಬಿಕಾಸ್ he is a senior citizen, there seems to be help. ಎಷ್ಟು 22 ಏನದು? 42. ಅವ್ರಿಗೊಬ್ಬರಿಗೆ ಮಾಡ್ತೀವಿ, ಯಾಕಂದ್ರೆ he is senior citizen as well as some health issue have it seems, no? ಯಾವ ಡೇಟ್?
I'm for appellate.
As requested both by both sides. This turn ಆಯ್ತು.
27-8.
27.
Serial number 50, your lordship.
27 ಬೇಡ, ಅದಕ್ಕೆ 2 ದಿವಸ ಮುಂದಕ್ಕೆ.
ಮುಂದೆನಾ?
29.
ಅವ್ರದೊಬ್ಬರದ್ದು ಔಟ್ ಆಫ್ ಟರ್ನ್ ತಗೊಂಡಿದೀವಿ, ಉಳ್ದವ್ರದೆಲ್ಲ ಎಲ್ಲ ತಗೊಂಡ್ಬಿಡಿ.
Number 20.
Your lordship.
Serial number 20.
We'll call all the matters one after another. ಯಾರಿಗೆ ಕಾಂಪ್ರಮೈಸ್?
Number 20.
Your lordship.
20.
Serial number
20.
20. Yes, serial number 20.
Next 20 ಹಾಕಿ. 20.
ಏನಿದೆ?
My senior is not.
Considering reasons assigned delay of 44 days. ಅವ್ರಿಗೆ ಏನು ಹೇಳಕ್ಕೂ ಬರ್ಲಿಲ್ಲ.
ಅಲ್ಲ, ಅದು ನಂಗೆ ನಮ್ದು ಏನು ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಮನೇಲಿ. ನಮ್ಮ ಹಾರ್ಟ್ ಅಟ್ಯಾಕ್ ಆಗಿ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಒಂದು, ಅದಕ್ಕೋಸ್ಕರ ಅವ್ರಿಗೆ ಏನು ಹೇಳಕ್.
ಹಂಗಂದ್ರೆ ಇದ್ರಲ್ಲಿ
20ನೇ ತಾರೀಕು.
ಅವ್ರು ಇನ್ನೊಮ್ಮೆ ಕೆಂಪರಾಜ್ ಅನ್ನೋರು ಯಾರು ಬರ್ತಾರೆ ಬಂದಾಗ ಇದರಲ್ಲಿ ಅಡ್ಮಿಟ್ ಅಂತ ಅಷ್ಟೇ ಮಾಡಿ, ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ TCRs ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ದ ರಿಸಿಪ್ಟ್ ಆಫ್ TCRs.
Serial number 35.
ಮೇಡಮ್ ಎಲ್ಲಾನು ಒಂದಾದ್ಮೇಲೆ ಒಂದು ಕರೆಸ್ತೀವಿ ನಾವು, ಸೀರಿಯಲಿ ಕರೆಸ್ತೀವಿ ಈಗ.
Serial number 25
For the petitioner, my lords, there's a delay of 32 days, my lords. Notice may be issued on.
Notice of Becca,
Yes, my lords.
issue notice of I-1 of 2024 to the respondent, list on
17-9.
29.
Admission, still number 29. Madam, ಇದು ಬೆಳಗ್ಗೆ time
ರೇಣುಕಾ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ ಸಿದ್ದೇಶ್ ಆಸ್ ರಿಕ್ವೆಸ್ಟ್ ಅರ್ಜೆಂಟ್ ಇಟ್ ದ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ದ ಅಪೆಲೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್ ನೋಟಿಸ್ ಅಂತ ಎಲ್ಲರಿಗೂ ಆಗಿದೆ.
Still number 31. ಚೇತನ್ ಜಾಧವ್ ಇದು ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಪಾರ್ಟಿ ಅಪೋಸಿಟ್ ಅಡ್ವೊಕೇಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀವಿ.
ಬರ್ತಾರೆ
2 weeks time may be granted. Connected
ಅಪೆಲೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್ ಸೀಕ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಯು ಆರ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ ಆರ್ ರೆಸ್ಪಾಂಡೆಂಟ್?
ಒಂದ್ರೊಳಗಡೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದೀವಿ ಮೇಡಮ್.
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಭಾರ್ಗವ್ ಜೂನಿಯರ್ ನೀವು? As Secretary Council for the response submit that the matter is likely to be settled and seek the adjournment. List on 2 weeks bit on the appointment.
49. Still number 32. N.K. Siddeshwara.
32. Total mood anta ide. Iದೇನು admission? TCRs ಬಂದ್ಬಿಟ್ಟಿದೆ ಅಲ್ಲಿ. Admit. List for final hearing after 4 weeks. Adjourn ಇದು ಮಿಸ್ total mood ಅಂತ ಇದೆ.
Still number 33. Rahul is ready.
ರಾಹುಲ್ ರೆಡ್ಡಿ ಇದರಲ್ಲಿ ಯಾರು ಕೇಳ್ತಾ ಇದ್ರ? ಸ್ಟೇ ಏನೋ ಕೇಳಿದ್ದಾರೆ. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ರಾಹುಲ್ ರೆಡ್ಡಿ, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್. ಲಿಸ್ಟ್ ಆನ್ ಇನ್ನು ಸ್ಟೇ ಕೇಳಿದ್ದಾರೆ ಕನೆಕ್ಟೆಡ್ ಮಾಡಿ.
39. Number 34.
I am for the appellant in this case. I am sorry, I am appearing through VC. ಬೆಳಗ್ಗೆ ಅಲ್ಲಿದ್ದೆ. Due to some indisposition, I had to come back here.
Correct.
The suit for partition.
When do you want it?
ಅಲ್ಲ ಅದು admittedly suit is barred by limitation. 90 ಚೆಕ್ ಅಂಡ್ ಕರಿಯರ್
ಹಂಗಂದ್ರೆ ನೋಟಿಸ್ ಮಾಡ್ತೀವಿ.
ಅಷ್ಟೇ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ FDP ಹಾಕಿದ್ದಾರೆ. ಡ್ರಾಯಿಂಗ್ ಅಪ್ ಫೈನಲ್ ಡಿಗ್ರಿ
ಅಲ್ಲಿ ಯಾರು ಕೇವೇಟ್ ಇದಾರಲ್ಲ ಆಫೀಸರ್ ಮಾಡಿ
ನಾರಾಯಣ್ ಶರ್ಮಾ.
ಅಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಅವರಿದ್ದಾರೆ.
ಏನು FDP ಹಾಕಿದಿರಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು
ಯಾಕೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಡ್ರಾಯಿಂಗ್ ಆಫ್ ಫೈನಲ್ ಡಿಗ್ರಿ ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಸ್ಟೇಟ್.
ಇಬ್ಬರೇ ಇರೋದಾ? ಕೇವೇಟ್ ಬಿಟ್ಟು ಬೇರೆ ಪಾರ್ಟೀಸ್ ಇಲ್ವಾ ಇದ್ರಲ್ಲಿ?
ಅಲ್ಲ ಉಳಿದವರು ಇಬ್ಬರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಆಗ್ಬೇಕು.
R1 and R2. How many response are there?
R3 and 4 ಅವರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
Issue notice to response 3 and 4. Appellants council shall submit the paper books within 6 weeks.
ಅಲ್ಲ 6 ವೀಕ್ ಅಂದ್ರೆ ತುಂಬಾ ಪೇಪರ್ಸ್ ಎಲ್ಲ ಇದೆ. ಒಂದು 8 ವಾರನಾದ್ರೂ ಬೇಕಾಗುತ್ತೆ. ನಾನು ಏನ್ ತಿಳ್ಕೊಂಡಿಲ್ಲ
ಅಂದ್ರೆ ಮುಂದೆ ನೋಡೋಣ.
Please.
Stay of interim stay only for drawing up of the final decree. Interim stay till further orders only for the drawing up of the final decree. I number 1 of 2024 is disposed of accordingly.
Records may kindly be called for.
The date code 6 weeks.
Records may kindly be called for.
26/9.
26/9.
26. Much obliged.
Number 35.
Appellant my lord, company's appeal, stay may kindly be granted. 50% ready to deposit.
ಏನಿದು ಪಾಯಿಂಟ್?
ಇದು ಕ್ವಾಂಟಮ್ ಮೇಲೆ there was no doctor's evidence, treated doctor evidence ಇಲ್ಲ. ಆದ್ರೂ ಸಹ 50% ತಗೊಂಡು ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
Interim stay of the execution of the impugned award subject to appellant depositing 50%
Yes,
of the award amount
before this honor.
Tribunal within
Tribunal,
4
yes,
weeks
my
of
lord.
the date of this within 4 weeks,
4 weeks.
the date of this order. I-1 of 2024 is disposed of accordingly. List on
26/9.
26.
Reporting settlement. Still number 36.
ರಿಪೋರ್ಟಿಂಗ್ ಅಲ್ಲ ಅದು ಬಿಟ್ಬಿಡಿ, ಯಾಕಂದ್ರೆ ಸ್ವಲ್ಪ ಟೈಮ್ ತಗೊಳುತ್ತೆ. ಮುಂದೆ ಯಾರೋ ಇನ್ನೂ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ರಲ್ಲ.
Still number 38. Further hearing.
Appearing for the respondent.
ಇದು ನೀವು ಇದನ್ನು ಹಾಕಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತಲ್ಲ?
ಹಾಕಿದೆ. I filed it.
ಓಕೆ, ಯಾವತ್ತು ತಗೊಳ್ಳೋಣ? ಇವತ್ತು may not be possible today.
We need it tomorrow, my lord. My lord, tomorrow seniors won't be there, my lord.
ಇದನ್ನ ರಿಪೀಟ್ ಮಾಡೋಣ. ಆಯ್ತು, tomorrow.
My lord, senior won't be there. He's going to. It's for my submission. I'll have to argue. They can take time to
He has to
reply.
be there, my lord.
You can make notes of that, no?
Or on the 20th, my lord.
ನಮಗೆ 19th to 22nd we are sitting for half day.
I'll conclude my submission.
Tomorrow. ಆಯ್ತು, ನೋಡೋಣ. Let us see tomorrow.
Still number 39 for final hearing.
For the appellant, my lord. For the appellant, my lord.
We'll have it on some other day. Today it's not possible.
Very well, my lord.
Appellant's counsel Nidhi Shri, ನೀವು appellant?
Yes, my lord. I appear for the appellant.
List on
28-8.
28.
Obliged, ma'am.
Number 40, Vanita UM.
Appeal for appellant, my lord. Second. Applied LR's application. Permission to produce the documents, LR application, connected case pending. Yes. Admit final hearing
Final hearing.
that IA is ordered to be heard along with the main matter, production of document. Abatement, appellant is dead. Her response counsel Shilpa Shah and HK Basavaraj. Then we'll take it up on some other day. No representation for the respondent. Response list on
22-8.
22.
Cell number 41, D. Vijay Kumar. KV Shyam Prasad.
For the appellant in 41 and 41.1 and respondent in other two matters.
ಏನಾಗ್ಬೇಕೆಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಅಲ್ವಾ ಇದೆಲ್ಲ
Admit ಆಗಿದೆ.
ಫೈನಲಿ
File hearing.
ಅವ್ರು ಇದಾರಾ ಅದರ್ ಸೈಡ್
ಇಲ್ಲ, ಶ್ಯಾಮ್ ಪ್ರಸಾದ್.
ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ದ ರೆಸ್ಪಾನ್ಸ್ ಲಿಸ್ಟ್ ಆನ್
29-8.
29.
Cell number 42 urgent, cell number 43. P. Pradeep.
ಇದ್ದು ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಪ್ರದೀಪ್ ಅವಾಗ ಬೆಳಿಗ್ಗೆ ಇಲ್ಲ ನನ್ನ ಕೇಸ್ ಅಡ್ಜನ್ ಟೋಟಲ್ ಮೂಡ್ ಅಂತ ಇದೆ ಯಾರು ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಡೇಟ್ ಕೊಡಿ ಲಿಸ್ಟ್ ಆನ್
29-8.
ಬಂದ್ ಮ್ಯಾಮ್ 29.
Cell number 44 urgent, cell number 45.
Appearing for appellant.
Gautam Yam.
But today not possible.
I represent.
45 ಅಲ್ಲ
Please, my lord.
Yes.
There was another matter connected to this. That matter has been closed, my lord. The present appeal doesn't,
merits it is disposed.
please, my lord.
Is that
The
correct?
present appeal doesn't survive for consideration.
ಅದು ಯಾವ ಜಜ್ಮೆಂಟ್ ಕಾಪಿ ಹಾಕಿ
Hakidim, I have produced along with memo. Please, my lord. In
ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂದ್ರೆ
in RFA 1792 of 2007.
ಪ್ರಾಕ್ಸಿ ನಾಳೆ ಹಾಕೊಳ್ಳಿ ಹೇಗಾದ್ರೆ
Please, tomorrow.
ಇದು ಬರ್ಕೊಳ್ಳಿ ನಾಳೆ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಲ್ವಾ ನೀವು
Please, my lord.
ಸಬ್ಮಿಟ್ ಸರ್ ಅಂದ್ರೆ ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ಸೇಮ್ ಜಜ್ಮೆಂಟ್ ದೇರ್ ವಾಸ್
No,
another
my lord. There were two separate suits. Both the appeals were connected in the High Court. One appeal,
position.
please, my lord. Another suit were for specific performance.
A specific performance suit is decreed, no?
No, my lord, that is dismissed. Possession suit is allowed.
Position suit is decreed. Whether that judgment has attained finality,
Please, my lord.
is that
Please.
correct?
In fact, they had even approached the Honorable Supreme Court. Honorable Supreme Court has dismissed their special leave petition.
You are respondent, alva?
Please, my lord.
Submits that in the connected matter, the judgment is passed against the present appellants. But this court has passed a judgment against the present appellants, and the same is confirmed by the Supreme Court. Therefore, this appeal does not survive.
Please, my lord.
Appellants counsel seeks time to submit. ಯಾವಾಗ ನಾಳೆ ನಾಡ್ದು ಯಾವಾಗ ಒಂದು ದಿವಸ ಹಾಕೊಳ್ಳಿ
Tuesday.
Tuesday
28.
28.
Please, my lord.
Cell number 46.
Appeal for the appellant, my lord, serial number 46.
Bharvi Muchandi.
46, yes.
Appeal for the appellant, my lord.
Speak.
Date may be fixed, my lords.
As requested list on
29-8.
29.
29-8, obliged.
47, D. Nagaraj Reddy.
Appear for the appellant. Enhancement, next week any day.
Huh?
Appear for the appellant.
Okay. As no representation or bandilwala for the
Pradeep bandil.
respondents. Pradeep, you are for the claimants, huh?
Yes, claimants.
List on
29-8.
ಮುಂದಿನ ಬೇಕಾದ್ರೆ ಮುಂದಿನ ಇವತ್ತು
Next week ಅಲ್ಲಿ ಯಾವಾಗ?
2019 ಇದೆ ಅದ್ರ ಮುಂದೆ
Case of amputation, Lord, amputation of complete.
is allowed or dismissed?
Allowed.
Partly allowed.
Yes, ma'am.
Everybody knows. Next.
48, Ashok N. Patil. SV Prakash. B. Pramod.
ನನ್ನ ಕೇಸ್ ಅಡ್ಜನ್ ಇದು ಟೋಟಲ್ ಮೂಡ್ ಅಂತ ಇದೆ ವಿತ್ಡ್ರಾವಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಅವರು ಬಂದಿಲ್ವಾ
29.
ಲಿಸ್ಟ್ ಆನ್ 29.
Cell number 49, T. N. Vishwanatha.
And for the
Idara
appellant,
AG.
I pray for some time. The interim order has to be extended.
Who has moved it? You have moved it.
No, my lords, it's the respondent who has moved the memo.
Interim order is there.
Yes, my lords.
None appears for the respondents. As requested by appearance counsel. List on ಇದ್ರಲ್ಲಿ ಹಾಕೊಳ್ಳಿ
11-9.
September 11-9.
Obliged.
Interim order ಇದೆ ಚೆಕ್ ಮಾಡಿ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ವಿಲ್ ಎಕ್ಸಾಮಿನ್ ದಟ್ ಇಟ್ ಇಸ್ ದೇರ್ ವಿಲ್ ಎಕ್ಸ್ಟೆಂಡ್
50, Irshad Ahmad K.
For the respondent.
Madhuri Ghat.
The negotiation is going on.
I am filing memo for proposed settlement, my lords.
already filed no
My
memo
lords,
for
there was some sort of discussion after which I am filing a revised memo, my lords. I may be permitted to be filed the proposed
now-
settlement in the counter.
Both of you have to discuss and file a final settlement report only.
I have given some proposal, she is not accepting. She has given some proposal, I am not accepting on certain points. So we have to sit together, sort out the issue.
No, whether it is possible at your end or it should be referred to mediation.
No mediation, madam.
Now, we will,
Tera,
please.
both council seek time to explore the possibility of, further explore the possibility of settlement and report. List on,
Next week, 19, 20.
ಅಲ್ಲ, is it likely ಮುಗಿಯೋ ಹಾಗಿದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡ್ತೀನಿ.
I have even, let him come back with whatever terms.
19th, 20th, 22nd ವರ್ಗೂ ಆಗೋದಿಲ್ಲ.
27th ಹಾಕಿಲ್ಲ ಸರ್.
27.
Please, better.
ಆಯ್ತು, ಮಾರ್ನಿಂಗ್ ಅವ್ರು ಮಾಡ್ಕೊಂಬಂದ್ರೆ ಆಗುತ್ತೆ ಮಾಡಿ. 22nd you want?
22nd.
22
Please, Lord.
20.
51 ಶಶಿಕಿರಣ್ ಬಿ ಇದ್ರೊಳಗೆ ಸೆಟಲ್ಮೆಂಟ್
Settlement. ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಇದ್ರಲ್ಲಿ?
There was a joint memo filed on 31/7 euros. At compliance madadike compliance memo after the parties are
230 ಇನ್ನಷ್ಟು ಮ್ಯಾಟರ್ ಅದಾವ್ರಿ. ಕೊಡಿ 30.
ನಂಬರ್ 51
There were 2 cases before the trial court.
Yes, ma'am.
both are appeals. One is against restoration of conjugal rights, one is against the dismissal of divorce.
Your petition for divorce is dismissed.
Correct.
And her petition for restitution, they represent husband.
Correct.
appellant.
Both appeals are.
Now, what is the settlement?
They have agreed for 22 lakhs, my lords. Today they are giving through reading
So dissolution,
resolution.
resolution is dissolution. Yes.
The joint memo was filed in 31/7. It was recorded in the previous order.
Today it's been compliance and we supposed to receive one more original bonds, whatever they have, my lords. That is only the pending issue.
So you want the dissolution decree to be passed now only.
Yes, ma'am.
But he said that is check ಅಂತ ಹೇಳ್ತಾರಲ್ಲ,
DD, ma'am.
DD.
Continue.
So demand draft is drawn in the name of daughter.
Yes.
ಯಾಕೆ ಒಂದು FD ನೇ ಮಾಡ್ಕೊಡ್ಬೋದಿತ್ತಲ್ಲ ಹಾಗಿದ್ರೆ?
ಅದನ್ನೇ ಮಾತಾಡಿದ್ರು. Now she is asking to get into DD. ಅದನ್ನ ಮಗು ಹೆಸರಿಗೆ ಇಡ್ತೀವಿ ಅಂತ ಹೇಳಿ.
And your lordship, page number 2, condition number B.
Silver articles.
Page number 2, condition number B, 2B.
2B.
Respondent mother after the realization of the theft sum into the minor account held Canara funds so and so.
ಇದೆ ನೋಡಿ.
Shall immediately.
ಇನ್ನೊಂದೇನು ಸಿಲ್ವರ್ ಆರ್ಟಿಕಲ್ಸ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ತೀವಿ.
ಅದನ್ನ hand over ಮಾಡ್ತಾರೆ.
ಯಾವ್ದು ಕೊಡಿ. ಬೋತ್ ಹೆಸರಿನವ್ರದ್ದು ಕುಮಾರಸ್ವಾಮಿ ಅಂಡ್
ಸಹನಶ್ರೀ.
ಸಹನಶ್ರೀ. Yes. Both parties and their counsel are present. The parties are duly identified by the respective counsel. ಅದೇನು ID proof ಏನಾದ್ರು ಇದೆಯಾ? ಆಧಾರ್ ಕಾರ್ಡ್ ಏನಾರ? ತೋರಿಸಿ ಕೊಡಿ. ಕಾಪೀಸ್ ಕೊಟ್ಬಿಡಿ. ಅವ್ರದ್ದು ಇದೆಯಾ? Ask them to hand over the copies of their ID proof, more particularly wife. They furnish the copies of their Aadhaar cards. Both the parties and counsel file the compliance memo, joint memo.
Joint memo last date ಅಲ್ಲಿ ಹಾಕಿದ್ವಿ.
Compromise petition ಅಂತ ಬರೆದ್ರೆ ಆಗುತ್ತೆ. Why do you write it like that?
Now there was some 45 days time they have taken to give the DD.
Now everything is materialized. No, under this case, now anything was paid earlier?
No, my lords, nothing.
So now this becomes the compromise petition.
But it needs to be read part and parcel of the again joint memo, my lords.
Why?
Some conditions, whatever they have mentioned in the joint memo last time,
Earlier joint memo.
earlier joint memo.
What was they are not there in this memo? Earlier.
Not every clause, my lords, I guess. Not every, because it is 22 lakhs DD.
Now we have mentioned 22 lakhs DD is being paid here.
That was the condition that we will pay, but compliance is what we say, it is already paid now. Ashte irodu.
Correct. Today's, this memo is the final alva.
Correct, correct.
So how many decrees we have to pass? Adanu seriskondu, idunu seriskondu. Decree can be passed in terms of this joint memo.
Correct.
Adu compromise petition anta barada kodi ashte. Ikkade bariskondu. Parties submit compromise petition. Yes, we have voluntarily entered into this agreement on compromise. What they are doing, both of them?
Hello.
What is their?
I want for LNT, ma'am. LNT.
LNT?
LNT
is an executive in LNT.
What is her job?
Executive in LNT.
MBA, na?
No, ma'am. MSc.
MSc. ಅವರು ಏನ್ ಮಾಡ್ತಾರೆ?
Intel solutions ಕೆಲಸ ಮಾಡ್ತಾರೆ.
How do the parties on the compromise fiction / joint memo? 22 lakhs DD have received now?
Yes, ma'am.
Respondent accepts admit receipt of DD number 481869 for a sum of rupees 22 lakhs. 22 lakhs drawn on which bank?
Canara Bank. This is Bangalore City Cooperative Bank.
Bangalore City Cooperative Bank, Jayanagar branch, dated 7/8/2024. She silver articles ತಗೊಂಡಿದ್ದೀರಾ?
ಇನ್ನು ಇಲ್ಲ.
ಅದ ಅಪೆಲೆಂಟ್ ಹ್ಯಾಂಡ್ಸ್ ಓವರ್ ಕೊಡಿ ಅದನ್ನ. ಮತ್ತೆ ಮೊದಲೇ ತೋರಿಸಿ ಚೆಕ್ ಮಾಡಿಸ್ಬಿಟ್ರೆ ಅಷ್ಟು ಟೈಮ್ ಸೇವ್ ಆಗೋದಲ್ಲ. ಈಗ
ಅವಾಗಲೇ ಕೇಳಿದೀವಿ my lords ನಾವು.
ಅಲ್ಲ ಮೊದಲೇ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಈಗ ಅದನ್ನೊಂದಿಷ್ಟು ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. Appellant hands off the silver articles to the respondent as stated in the compromise petition. The joint memo. The respondent submits that after realization of the DD, she is going to invest the same in FD as stated in the name of minor daughter. In our case, what is the name of the daughter? Rohita, na? Rohita, as stated in the compromise petition. Both parties submit that. He goes on paying that LIC subscription. The appellant admits that agrees to go on paying the LIC insurance premium as stated in para 3 of the joint memo. Both parties admit that they have agreed for dissolution of the marriage because of the joint memo. And respondent ಕೇಸ್ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂತೀವಿ ಅಂತ ಒಪ್ಕೊಂಡಿದಾರ ಅವರು.
ಹೌದು.
ಆಯ್ತು ಚೆಕ್ ಮಾಡ್ಲಿ ಆಮೇಲೆ ಸೈನ್ ಮಾಡ್ತೀವಿ ಬಿಕಾಸ್ ಬೇರೆ ಕೇಸ್ ನಲ್ಲಿ ಇರುತ್ತಲ್ಲ ಅದು ಮಾಡಿ. Respondent has agreed to withdraw the cases filed by her against the appellant as stated in para 7 of the joint memo, satisfied that the compromise is admissible under law and the same is voluntary one. Satisfied that the compromise is voluntary one and admissible under law. Therefore, the same is recorded.
My lords, submission. LIC insurance ಏನಿದೆ ಅದು ಒರಿಜಿನಲ್ ಅವರು ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ತಾರೆ ಅಂತ ಬಂದ್ಬಿಡ್ಲಿ.
LIC ಪಾಲಿಸಿ ಅವ್ರ ಹತ್ರ ಇಲ್ಲ,
ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ.
ಇದ್ರಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ವಾ ಪಾಲಿಸಿ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ತಾರೆ ಅಂತ?
ಲಾಸ್ಟ್
ಅದನ್ನ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ತೀವಿ.
ಇದ್ರಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ, ಇದರಲ್ಲಿ ಬರೀ ಪೇ ಮಾಡ್ತಾ ಹೋಗ್ತಾರೆ
ಅಂತ. ಅಶ್ಯೂರ್ಡ್ ಸಮ್ ಮೇ ಬಿ ಅಂತಿದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಅದನ್ನ ಮಾತಾಡಿತ್ತು ಮೈ ಲಾರ್ಡ್ಸ್. ದ ಒರಿಜಿನಲ್ ವಿಲ್ ಬಿ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ಟು ದಿ respondent.
Why did you not mention in this?
Assured sum was handed over ಅಂತ ಅಷ್ಟೇ ಆಗಿದೆ in joint memo ದಲ್ಲಿ.
Agreeable ಇದಾರಾ? ಇದ್ರೊಳಗೆ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಬಿಡಿ.
Yes my lords.
ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ತೀರಿ?
ಇವತ್ತು ಕೊಡ್ತಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಬಟ್ ತಂದಿಲ್ಲ.
Have brought the policy?
I have not brought.
Tomorrow we'll hand it over.
In fact, I agreed that we'll show the bond. Now they're saying they want a position of bond.
Additional ಕೊಡ್ಬೇಕಾಗುತ್ತಲ್ಲ. The appellant undertakes to hand over the original LIC bond mentioned in para 3 of the joint memo within 1 month. ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಕೊಡ್ತೀರಿ?
Within 1 week ಅಂತ ಇರಲಿ.
Within 1 month.
I will coordinate.
ಮೇಲೆ ಬರ್ಲಿ ಅದಾದ್ಮೇಲೆ appeals are allowed hence ಅಲೈನ್ ಮಾಡೋದು. The appeals are allowed. ಇದು ಒಂದು ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ವಾ?
Yes.
Yes. Common judgment, your lordship.
Dated 14/10/2022 in MC number 3 of 2021 connected with MC number 174 of 2021. Passed by the family court Sivamogga is hereby set aside. MC number 3 of 2021 dismiss ಆಗ್ಬೇಕಾಗುತ್ತಲ್ಲ ಅದು.
ಅವ್ರದ್ದು 3 of 21 dismiss.
3 of 2021 is hereby dismissed. The petition in MC number 174 of 2019 is allowed in terms of the joint memo.
Correct.
Joint memo, the marriage of the appellant and respondent solemnized on
13/11/2009.
13/11/2009.
Yes.
13/11/2009.
Nijalingappa Sabhangana action.
Nijalingappa Sabhangana Shivamogga
Correct.
is hereby dissolved. Judgment ಅಲ್ಲೇನೋ ಕರೆಕ್ಷನ್ ಮಾಡಿದ 13/11/2009 ಅಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಪೇಜ್ ನಂಬರ್ 21. ನಾನು ನೋಡ್ತಿದ್ದು ಸರ್ ಟೈಪ್ಡ್ ಕಾಪಿ ಇದೆ. ಇಂಟರ್ನಲ್ ಪೇಜ್ ಎಷ್ಟಿದೆ? 3 ನಮ್ಮದ್ರಲ್ಲಿ ಇಲ್ಲ, ನಮ್ಮದ್ರಲ್ಲಿ 13/1 ಅಂತ ಇದೆ. ಅವ್ರು ಏನಾದ್ರು ಕರೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ ಅಲ್ಲಿ ಅವ್ರ ಮೇಲೆ ಜಡ್ಜ್ ಮಾಡಿದ್ರೆ ಇನಿಷಿಯಲ್ ಮಾಡಿರ್ತಿದ್ರು. ಇನಿಷಿಯಲ್ ಮ್ಯಾರೇಜ್ ಆಗಿರೋ 13/11/2009 ತಾನೆ ಇಲ್ಲ. ಇಲ್ಲಿ ನಿಮ್ದು ಯಾವ್ದು ಸೆಕೆಂಡ್ ಸೆಟ್ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಅಂದ್ರೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿಯಲ್ಲಿ ಇಲ್ಲ ಅದು. ದಿಸ್ ಇಸ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ. ಅದು ನೋಡ್ಕೊಂಡ್ಮೇಲೆ ಅವ್ರು ಹೇಳಂತ ಹೇಳಿ ಆಮೇಲೆ ಸೈನ್ ಮಾಡ್ತೀವಿ. ಅವ್ರು ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅದನ್ನ ಸಿಲ್ವರ್ ಆರ್ಟಿಕಲ್ಸ್ ಎಲ್ಲ.
ಒನ್ ಸಿಂಗಲ್ ರಿಕ್ವೆಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಅದು ಇವ್ರಿಗೆ ಆದಷ್ಟು ಬೇಗ ಡಿಗ್ರಿ ಬೇಕು ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲೂ ಮೆನ್ಷನ್ ಆಗಿತ್ತು ಆರ್ಡರ್ ಅಲ್ಲಿ ಪಾಸ್ಪೋರ್ಟ್ ಅವ್ರು ಇಶ್ಯೂ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ. ಅಗೇನ್ ದ ಸೇಮ್ ಇಶ್ಯೂ ಹ್ಯಾಸ್ ಕಮ್ ಅಪ್. ದೇ ಆರ್ ಆಸ್ಕಿಂಗ್ ಫಾರ್ ದ ಡಿವೋರ್ಸ್ ಕಾಪಿ. ಆಕ್ಚುಲಿ ಇವ್ರ ಮಗಳು ಥೈಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಒಂದು ಭರತನಾಟ್ಯಂ ಇದಕ್ಕೆ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ರೆಡಿ ಆಗಿ ಬರ್ಲಿ, ಬಂದ ತಕ್ಷಣ ಸೈನ್ ಮಾಡ್ಕೊಡ್ತೀವಿ.
ಅದು ಒಂದ್ ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾರೆ.
ರೈಟ್, ಮಾಡ್ಕೊಟ್ರೆ ಜಸ್ಟ್ ಟುಮಾರೋ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಅಷ್ಟರಲ್ಲಿ ಮಾಡ್ಕೊಡ್ತೀವಿ. ಅರ್ಜೆಂಟ್ ಅಂತಾರೆ. ನಾವಿಲ್ಲಿ ಮಾಡಿದ್ರು ರಿಜಿಸ್ಟ್ರಿಗೆ ಹೋಗಿ ಡಿಗ್ರಿ ಡ್ರಾ ಆಗ್ಬೇಕದು. ಡ್ರಾ ಡಿಗ್ರಿ ಅಕಾರ್ಡಿಂಗ್ಲಿ ಅಂತ ಮಾಡಿಕೊಡ್ತೀವಿ.
ತುಂಬಾ ಡಿಲೇ ಆಗುತ್ತೆ. ಟ್ರಾವೆಲ್ ಇಸ್ ಆನ್ September 3rd. ಪಾಸ್ಪೋರ್ಟ್
September 3rd ಪಾಸ್ಪೋರ್ಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತ
ಲಾಸ್ಟ್ ಟೈಮ್ ದೇರ್ ವಾಸ್ ಅ ಮೆನ್ಷನ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು ನಿಮಗೆ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತಂದ್ರೆ ನಾವು ಮಾಡ್ಕೊಡ್ತೀವಿ. ಆಯ್ತು ಅಷ್ಟಕ್ಕೂ ಬೇಕು ಅಂತಂದ್ರೆ ಇವರು ಸಾಲಿಸಿಟರ್ ಜನರಲ್ ಹತ್ರ ಸ್ವಲ್ಪ ಹೋಗಿ ಹೇಳ್ಸಂತ ಹೇಳ್ರಿ.
ಅದ್ ನಾನು ಮೂವ್ ಮಾಡಿಸ್ತೀನಿ ಮಲರ್ಸ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲೂ ಮೆನ್ಷನ್ ಮಾಡಿಸಿದೀವಿ. ದಿಸ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ವಿಲ್ ನಾಟ್ ಕಮ್ ಇನ್ ಟು ದಿ ಪಿಕ್ಚರ್ ಆಫ್ ಇಶ್ಯೂಯಿಂಗ್ ದಿ ಪಾಸ್ಪೋರ್ಟ್ ಅಂತ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೂ ಮೆನ್ಷನ್ ಆಗಿದೆ. ಬಟ್ ದ ಅಥಾರಿಟೀಸ್ ಆರ್ ನಾಟ್ ಅಗ್ರಿಯಿಂಗ್ ಟು ಇಶ್ಯೂ ದ ಪಾಸ್ಪೋರ್ಟ್. ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಅದು ಒಂದ್ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ ಅಂತೇಳಿ ಈ ಡಿಗ್ರಿ ತೋರಿಸಲೇಬೇಕು ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಅಲ್ಲ ಡಿಗ್ರಿ ನಾಳೆ ಈಗ ಈ ಆರ್ಡರ್ ಶೀಟ್ ತೋರಿಸಿ ಡಿಗ್ರಿ ಅಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಡ್ರಾ ಮಾಡ್ತಾರೆ ಅದನ್ನ ಲೋಡ್ ಅಂತ ಇಟ್ಸ್ ರಿಸಾಲ್ವ್ ಅಂತ ಡ್ರಾ ಡಿಗ್ರಿ ಅದು ಕೆಳಗಡೆ ಲಿಬರ್ಟಿ ಇಸ್ ರಿಸರ್ವ್ ಟು ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ದಿಸ್ ಆರ್ಡರ್ ಬಿಫೋರ್ ದ ಪಾಸ್ಪೋರ್ಟ್ ಅಥಾರಿಟೀಸ್ ಇಫ್ ನೀಡೆಡ್.
Grateful.
ಅಷ್ಟು ಮಾಡಿದ್ರೆ ಒಂಚೂರು
Cell number 52.
For the appellant, my lord, it may be fixed to next week.
52. You want it in next week?
Yes, ma'am. There's an IA for early hearing that's pending for consideration.
ಯಾವ್ದು ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF ಎಟ್ಸಿಟ್ರಾ ಇದೆಲ್ಲ ಇನ್ನೂ ಇದ್ರಲ್ಲಿ
That has been complied with.
ಮತ್ತೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಅವಾಗ ನೋಟಿಸ್ ಹ್ಯಾಸ್ ಟು ಗೋ ಟು ದ ರೆಸ್ಪಾಂಡ್. ಹೂ ಇಸ್ ನಾಟ್ ಸರ್? Chandrappa has not filed wakalat.
In the connected matter, they are the appellants, my lord, we are the respondents.
Leela Devadiga. So what is your name?
I am for Leela.
Leela. Chandrappa has filed the connected appeal.
Yeah, we have filed the connected appeal. They are the 232 appellants.
Appearing for Leela Devadiga.
In 226, my lords.
Correct.
I am the appellant.
The other appeal is by them.
Yes, ma'am.
In that Chandrappa advocate has appeared. In this he has not filed wakalat.
Yes.
He is not appearing in the connected case also.
He is appearing, my lords.
Where is he? He is not.
They haven't come.
As requested by the appellant's counsel, list in the next week. ಆಯ್ತು ನೋಡೋಣ.
230 matter.
Next week.
Date may be next, if a date may be fixed, ma'am.
As requested by the appellant's counsel, list on. ಅವರೇನೋ ನೋಟಿಸ್ ತಗೊಂಡ್ ಬರ್ತಾ ಇಲ್ಲ.
28.
28.
Date will be.
And for the claimant respondent.
ಯಾವ್ದ್ರಲ್ಲಿ?
230 matter.
230 minutes.
ಈಗ
Covered by judgment.
ಯಾರು ಅದರ್ ಸೈಡ್ ಯಾರು? ಸೀತಾರಾಮ್ ರಾವ್.
ಈಗ just
ಅಲ್ಲಿ ನಾವು ಯಾವ್ದೋ ಕಾಂಪ್ರಮೈಸ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕಾಗಿದೆ. ಅದಕ್ಕೆ ಇನ್ನೊಂದ್ ದಿವಸ ಹಾಕೊಳ್ಳೋಣ ಇದನ್ನ.
covered by judgment of this honorable court, my lord.
ಅಲ್ಲ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಅಂತ ಸಮಯ. ಇವತ್ತು ನೀವು ಕೊಟ್ಟರು ನಮ್ಗೆ ಜಡ್ಜ್ಮೆಂಟ್ ಡಿಕ್ಟೇಷನ್ ಕೊಡಕ್ಕಾಗಲ್ಲ.
Please, it is left to discretionary power of this honorable court.
Give that copy.
Your lordship has directed me to produce the appointment letter.
Response submits ಏನದು?
Appointment letter.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಲೆಟರ್ ಅಲ್ಲಿ ಏನೋ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಕವರ್ಡ್ ಬೈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ಏನದು?
Only disputed facts is, my lord.
ಏನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಲೆಟರ್?
ಅಲ್ಲ, compassionate, he got compassionate appointment, my lord, after the death of his father in the accident, my lord.
ಈ ಗ್ರೂಪ್ ಎಂಪ್ಲಾಯ್ ಅಂತ
Please, my lord.
Submits memo with one document. Memo with copy of one document. Okay. Copy subsection should comply. Okay. List on
27th.
No representation for the applicant. List on 27. All right.
Please, my lord.
27.
ಅಲ್ಲ, 230.
At 230.
Covered by judgment, my lord.
Right. 230. Lady is crying.
For reporting settlement, cell number 36.
ಅವ್ರಿಗೆ ಕುತ್ಕೊಳಕ್ ಹೇಳಿ, ಕುತ್ಕೊಂಡು ಸೈನ್ ಮಾಡಂತ ಹೇಳಿ. ಯಾರು ಅಡ್ರೆಸ್ ಬಂದಿಲ್ಲ ಆ ಕಡೆ.
Ismail Zabiullah.
Appearing for the appellants, sir. Regarding one non-compliance of that deletion of respondent number 8
36.
36.
in the second set for non-compliance.
It's good.
Solution on. ಇದರಲ್ಲಿ
serial number 230 madam. But covered by your lordship judgment.
ಇವತ್ತು ಈಗ ಎಲ್ರಿ ಅದನ್ನ ಕಾಂಪ್ರಮೈಸ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು ಮಾಡಿಸ್ತಾ ಇದೀವಿ.
Monday.
ಯಾವ್ದೋ ಕೊಟ್ಟಿದೀವಿ ಡೇಟು, ಅದಕ್ಕಿಂತ ನಿಮ್ದೆಲ್ಲ 2024-23 ಕೇಸಸ್. ಎಸ್ ಯಾವ್ದು ಡೇಟ್ ಹೇಳಿದ್ರಲ್ಲ?
27th.
27/8. Please.
ಎಸ್ ಇದೇನು?
230.
ಇದ್ರಲ್ಲಿ ಏನು ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ದ ಕಾಸ್ಟ್ ರೇಟ್ ಯಾಕೆ ವೇಟ್ ಮಾಡಿಸಿದ್ವಿ ಅಂದ್ರೆ ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದೀರಾ ಕಾಸ್ಟ್ ರೇಟ್ ಅಲ್ಲ ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನೋ ಪಾರ್ಟ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಅಂತ ಹೇಳಿದ್ರು.
Partly compromise. Not this.
ನೀವು ಇದನ್ನೆಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡದೆ ನಾವು ಕಾಂಪ್ರಮೈಸ್ ಹೇಗ್ ರೆಕಾರ್ಡ್ ಮಾಡೋದು?
During the course of the day, I'll just.
You have done it now?
No, I'll do it now. We have filed.
Why did you not do that?
Amendment cost has been filed, your lordship. Only it has to be carried out in.
Why did you not carry out? You were sitting since morning.
Yes, sir.
Anyway, appeals will continue. But it is a partial compromise, my lord, only in respect of two items of the properties in RFA number 2
2325 of 2019, arising out of OS number 7558 of 2008. ಅದರಲ್ಲಿ ಎರಡು item lord. What happened in lord? The trial court has partly decreed the suit for partition, holding that in most of the suit settled properties, the shares have been given to the plaintiffs and defendant. Now, out of that lord, because the parties have been in court for the last 24 years. So therefore, as there is some necessities as arisen in the family. So in order to sustain that, two items of the properties, they are jointly selling it to a commonly identified prospective purchaser, to whom they have entered into agreements for sale and have received certain amounts. To in
558 ಇನ್ನೊಂದು ಕೊಡಿ ನೋಡೋಣ. ಯಾವುದೋ ಒಂದು ಸೂಟಲ್ಲಿ ಯಾರು ಮೈನರ್ಸ್ ಇದಾರಲ್ಲ, 2008 ನಲ್ಲಿ 12 and 18 ಇದ್ರಾ?
Minor applications have been filed already.
Discharge ಆಗಿದಾರಾ?
ಅದು applications have already been filed. ಅದು compromise ಅಂತ ಹೇಳಿ ಸುಮಾರು ದಿವಸದಿಂದ ಹೋಗ್ತಾ ಇತ್ತು.
ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದೆ, ಅವರ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ಡರ್ ಆಗಿದೆ. ಡಿಸ್ಚಾರ್ಜಿಂಗ್
Orders ಆಗಿಲ್ಲ, applications have been taken on record. Orders are.
ಯಾವತ್ತಾಗಿದೆ?
5-6.
ನೀವೇ ಹಾಕಿರೋದು.
ನಮ್ಮನ್ನು ಸೇರಿಸ್ತಾರೆ ಅಷ್ಟೇ, ಅವ್ರ ದೇರ್ ಫೈಲ್ ಇವ ಫೈಲ್
ಮಾತಾಡಿ.
ಇಲ್ಲೆಲ್ಲ ಏಜ್ ಮೇಜರ್
5-6-24, the order has been.
ಉಷಾ ಅಂಡ್ ಶ್ರಾವಣಿ and ತೇಜಸ್.
6B ಮೇಡಮ್.
ತೇಜಸ್.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6B.
ಅಪೀಲ್ ಅಲ್ಲೇ
ಮನ್ನೇಗೌಡ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ್ರಾ? ಹೇಗೆ? ಇಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 died. ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 ಗೆ ಅಲ್ಲ
6B ಗೆ
ಹೇಳಿ ಸರ್, ಯಾರು ಹೇಳ್ಬೇಕು.
2008 ಅಲ್ಲಿ 12 years ಅಂದ್ರೆ ಅಫ್ಕೋರ್ಸ್ ಎಷ್ಟೊತ್ತಿಗೆ ಆಗಿರ್ತಾರೆ ಹೇಳಿ.
ಇವು ಗೊತ್ತಲ್ಲ, ಹೇಳಿ ಸರ್.
ಆರ್ಡರ್ ಆಗಿದೆ. This is respondent number 6. Respondent number 6 NRC ಯಾವ್ದು ಅಪೀಲ್?
6B ಮೇಡಮ್.
2325. 2325.
6B is a minor.
ಇಲ್ಲಿ ನಮ್ಗೆ ಏನು ಕರೆಕ್ಷನ್ ಇರೋದಿಲ್ಲ. ನಮ್ಗೆ ಹೇಗ್ ಗೊತ್ತಾಗುತ್ತೆ ಯಾರು 6A 6B ಅಂತ ಹೇಳಿ? ಅಮೆಂಡ್ಮೆಂಟೇ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ, ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ. And you call the parties and you make them to sit since morning.
I apologize. I'll carry out the amendment.
No blame on us ultimately.
No, Your Lordship.
ನಾವು ಕೋರ್ಟ್ ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡಲಿಲ್ಲ ಅಂತ.
I apologize for that. I'll carry out the amendment, right?
ಅಪ್ಲಿಕೇಶನ್ ಏನಿದೆ ಈಗ? ಅಪ್ಲಿಕೇಶನ್ ಹುಡುಕ್ಬೇಕು ನಾವೀಗ ಮತ್ತೆ. ಯಾವ್ದಿದು? IA ನಂಬರ್ 22
Application filed on
3/23/24
ಮೇಡಮ್.
Connected matter.
2325 ನಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ. ಎರಡರಲ್ಲೂ ಆರ್ಡರ್ ಆಗಿತ್ತು. What are these IA number?
3/24, Your Lordship.
2-4 of 2024.
Acknowledgement ಇದೆಯಾ?
ಇಲ್ಲ 2-4 ಅಂತ ಇದೆ. ಎಲ್ಲ ಹೆಸರು ಬರ್ದಿದ್ದಾರೆ ಅಂತ. ಆರ್ಡರ್ 1 Rule 10 ಇದೊಂದೇನೋ ಬೇರೆ ಇದೆಲ್ಲ. ಆರ್ಡರ್ 1 Rule 10 ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ಡರ್ 1 Rule 10 ಅಲ್ಲಿ ಹಾಕೊಂಡಿದ್ರಾ? ಯಾರು 6A and B ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ನೋಡಿ. In view of death of respondent number 6 by name Sudhakara died on 7/5/2000. Hence respondent number 6A and 6B are the LRs of first applicant husband. Applicant and husband for the company. What is this? Have you read that application?
No, that application was pending. ಈ application ಆಗುತ್ತೆ.
ಯಾವ್ದೆಲ್ಲ
ಆಮೇಲೆ ಹೆಸರು ಏನ್ ಬರೀತಾರೆ? IA number
ಅವ್ರು ಹೇಳ್ಬೇಕು ಸರ್, ಅವ್ರ ಅಪೆಲೆಂಟ್.
ಭೂಲಕ್ಷ್ಮಿ and Martin.
IA 3 of 24, Your Lordship. The order is dated on 5/6/2024.
5/6/26.
Yes,
It
5/6/20.
says that the applications are allowed.
Yes, Your Lordship. Application is of IA number 3 of 24.
Only amendment is to be carried out, my lord.
Yes.
ಯಾರೋ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6 ಅಂತ ಹೇಳ್ತೀರಿ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6 ಭೂಲಕ್ಷ್ಮಿ ಅಂಡ್ ಮಾಸ್ಟರ್ ಕಿಶನ್ ಅಂತ ಇದೆ.
Yes, ma'am.
ಹೌದು ಹೌದು.
We should, ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಇಲ್ಲ ಅದು ಆರ್ಡರ್ 1 ರೂಲ್ 10 ಅಂತ ಇದೆ. They themselves came forward and filed the application. You represent appellant.
Appellant, sir.
ಇವ್ರು ಹಾಕ್ಲಿಲ್ವಾ ಅಪ್ಲಿಕೇಶನ್?
ಅವ್ರು ಫಸ್ಟ್ ಹಾಕಿದ್ದಾರೆ. ಅವ್ರು ಹಾಕಿ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಗಿದೆ. In the meanwhile, we filed the application.
You represent those LRs?
Yes,
DSL Law Associates.
yes, madam.
ಅವ್ರು ಹಾಕಲು ಆಗಿದ್ರೆ ಮತ್ತೆ ನೀವ್ ಯಾಕೆ ಹಾಕಿದ್ರಿ?
ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಅವ್ರು ಹಾಕಿರೋದು. In the meanwhile, ನಾವು ಫೈಲ್ ಮಾಡಿ.
ನಾನ್ ನೆಕ್ಸ್ಟ್ ಅಂತ ಅವ್ರು ಹಾಕಲು ಆಗಿದ್ರಿ ಇಲ್ಲ ಅಪೀಲ್ ಮೇಲೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಇರ್ಬೇಕಿತ್ತಲ್ಲ. ಆ ಆರ್ಡರ್ ಯಾವತ್ತಿಂದು? ಅವ್ರು ಹಾಕಿ ಅಲೋ ಆಗಿದ್ದು?
Our application was allowed on 5/6/2024, Your Lordship.
5/6/24, that is IA number 2 to 4 of 2024.
Yes, IA 3 is for the amendment. It's
23-24 IA number 2 to 4 of 2024 ಕೊಡಿ. ಇದು 23-25 ನಲ್ಲಿ ತಾನೆ. IA 2 to 4 it's filed by them. IA ಒಂದಲ್ಲ 2 to 2. IA 2 to ಏನೋ ಒಂದು ಡಿಲೀಷನ್ ಬೇರೆ ಹಾಕೊಂಡಿದ್ದಾರೆ.
Revision.
Deletion.
Only impleading application.
Deletion ಗೆ ಅನಿವಾರ್ಯ. ಹೇಳಿ.
ಆರ್ಡರ್ 1 ಇದ್ರ ಮೇಲೆ ಆರ್ಡರ್ 1 ಅಂತಿಲ್ಲ 2 to 4 ಅಂತ ಇದೆ. IA 1 ಏನು it is submitted by none of us for the applicant. IA 1 of 2024 will be dismissed as not pressed ಅಂತ ಆಗಿದೆ. Your application was dismissed as not pressed. 6A and 6. ಈಗ 6B minor ಅಂತ ಇದೆ ಅಲ್ಲ 15 years ಅಂತ ಇದೆ. Master Kishan.
Master Kishan 15 years ಅಂತ ಇದೆ. ಹೌದು.
Now his mother is representing on his.
Yes.
ಏನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ advocate it is for his welfare ಅಂತ.
Appellant has to.
No, it is for the respondent because respondent is a minor. He is represented by the natural guardian.
6 represent, you represent.
Yes, ma'am.
You have filed the certificate.
Advocate certificate file ಮಾಡಿದ್ದೇವೆ ನೋಡಿ.
ಇಲ್ಲ ಮಾಡಿ.
ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡೋದಕ್ಕೆ ಸರ್ಟಿಫಿಕೇಟ್
ಹೌದು ಹಾಕ್ಬೇಕು ಅವ್ರು ಹಾಕ್ಬೇಕು.
ಈಗ ವಾಟ್ ಇಸ್ ದ ಕಾಂಪ್ರಮೈಸ್? ವಾಟ್ ವೇರ್ ದ ಸೂಟ್ ಏನಿತ್ತು?
Suit is for partition and separate possession.
ಎರಡು ಸೂಟ್ ಆ ಪಾರ್ಟಿಷನ್.
ಎರಡು ಸೂಟ್ ಇದೆ.
Why 2 suits?
Why? Because my lord, the first suit was filed only in respect of a few properties for partial partition. So thereafter a separate suit was filed by one of the dependents in the other suit, incorporating all the properties.
ನೀನ್ ಯಾಕೆ ಬೇಕಿತ್ತು? ಅಲ್ಲೇ ಮಾಡ್ಕೊಳಕ್ ಬರ್ತದೆ. ಯಾವ ದಿಸ್ ಇಸ್ ಫ್ರಮ್ ಬೆಂಗಳೂರು ಓನ್ಲಿ.
Also,
that actually the suits.
ಶ್ರೀನಿವಾಸ್ ಅನ್ನೋರು ಯಾರೋ ಶ್ರೀನಿವಾಸ, ಭಾಗ್ಯಮ್ಮ, ನಾಗರಾಜ್.
ಹೌದು ಅದು I appear for them.
ವೇಣುಗೋಪಾಲ್.
I appear for them.
What was their rank in the first suit? Srinivas was defendant number 1 there.
ಹೌದು.
ಇವರು ವೇಣುಗೋಪಾಲ, ನಾಗರಾಜ, ಭಾಗ್ಯಮ್ಮ ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಅದರಲ್ಲಿ only a few properties were included, not all the properties. Therefore, a separate suit was filed. Both suits were.
OS 75/58 of 2008 was filed by you.
ಹೌದು. That is why Srinivas and others.
ಶ್ರೀನಿವಾಸ ಒಬ್ಬರೇ ಇರ್ಲಿಲ್ಲ. ಶ್ರೀನಿವಾಸ, ಭಾಗ್ಯಮ್ಮ, ವೇಣುಗೋಪಾಲ, ನಾಗರಾಜ್.
ಹೌದು.
They are the parties.
ಹೌದು.
ಆದ್ರೆ ಇವರು ಭಾಗ್ಯಮ್ಮ is the wife of Srinivas.
ಹೌದು.
And other 2 are their children.
ಹೌದು ಮಕ್ಕಳು.
ಪಾರ್ಟಿ ಮಾಡಿದ್ರಿ ಅದ್ರಲ್ಲಿ?
ಬೇಕಾಗಿರ್ಲಿಲ್ಲ at that time the trial court.
ಅಡ್ವೊಕೇಟ್ ಯಾರು ನೀವಲ್ಲವಾ?
ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಲ್ಲ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಲ್ಲ ಬೆಂಗಳೂರಿಂದ ಅಲ್ಲ.
ಆಮೇಲೆ NOC ಬಂದ್ಮೇಲೆ then it was the evidence stage reach ಆಗಿತ್ತು, that continued. In any way, only the branch head was sufficient.
ಅಲ್ಲ ಇವನ್ ಮಕ್ಕಳು ನಾಳೆ ಏನಾದ್ರೂ ತಕರಾರು ಮಾಡ್ತಾರೆ ಅಂತಂದ್ರೆ ಅವ್ರನ್ನ ಮಾಡಿದ್ರೆ why wife was necessary party?
Not necessary.
And one first suit was of 2007. ಅಲ್ಲೇನೆ ಆ ಪ್ರಾಪರ್ಟಿನ ಇನ್ಕ್ಲೂಡ್ ಮಾಡೋದಕ್ಕೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೇಳ್ಬೋದಿತ್ತು ಅಥವಾ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಆ ಪ್ರಾಪರ್ಟಿ ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ಕೋಬಹುದಿತ್ತು.
ಮಾಡ್ಬೋದಿತ್ತು, ಕೌಂಟರ್ ಕ್ಲೇಮ್ ನಲ್ಲೇ ಹಾಕೊಳ್ಬೋದಿತ್ತು. ಹೌದು. But only thing is that now that the suits were already filed, both were clubbed and by common judgment.
ನಮ್ಗೆ ಆದ್ರೆ ಅನ್ನೆಸೆಸರಿ ಎಕ್ಸರ್ಸೈಸ್ ಗಳೆಲ್ಲ ಆಗುತ್ತಲ್ಲ.
ಹೌದು. Common evidence, common argument, that was only the saving of judicial time.
The contesting defendant here.
Contesting defendant in my suit, my lord, was Srimati Jagdamba and the other members of the family.
The appellants here in the.
Jagadamba, Usha, Shravani and Tejas. How they are related to this G. Srinivas?
One of the Jagdamba's husband is one of the brother of Srinivas.
Jagadamba, andre sister-in-law.
Srinivas ಅವ್ರ ತಮ್ಮ ಮತ್ತು ಅವ್ರ ಫ್ಯಾಮಿಲಿ.
ಅಲ್ಲ, ಈ ಶ್ರೀನಿವಾಸನ್ ತಂದೆ ಹೆಸರು ಗುರುಮೂರ್ತಿ ಅಪ್ಪ ಅಂತ ಇದೆ.
Gurumurthy was the propositors.
So Ramaya and Srinivas are the sons of Gurumurthy appa.
Yes,
ಹೌದು.
And
Narayana also.
No, there is no dispute regarding the relationship.
ಇವರೆಲ್ಲ they are the sister, children of this Ramaya.
ಹೌದು.
Who are this Shantamma, wife of Narayanappa?
So Nanappa is the son of Gurumurtappa. 4 children, sir.
Oh, he was also not alive. Narayanappa was not.
No.
Sudhakara Narayanappa, Manjula Narayanappa.
Why plaintiff number 2, Bhagyamma is not party to the compromise petition?
Compromise petition and our signature ilva iga.
Plaintiff number 2, Bhagyamma.
Bhagyamma.
ಅಲ್ಲ, ಆಕೆನ್ ಪಾರ್ಟಿ ಮಾಡೋ ಅವಶ್ಯಕತೆನೇ ಇರ್ಲಿಲ್ಲ because she is the wife of a living.
Bhagyamma expired. The husband is Srinivas and their entire family is represented.
ಅದನ್ನ ಇಲ್ಲಿ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಬಂದಿದೆಯಾ ಅದು?
Respond number 2.
ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ she was ಭಾಗ್ಯಮ್ಮ. ಆಕೆ ಹೆಸರು ಮತ್ತೆ ಇಲ್ಲೇನು ಡಿಲೀಟ್ ಆಗಿಲ್ಲ, ಡೆತ್ ರಿಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ. Both appeals are filed by the same party, no?
ಹೌದು.
ಇನ್ನೊಂದು ಕೊಡಿ, ಇಲ್ಲೇ ಇದೆ. ಯಾವುದು 23-25. ಅಲ್ಲ, ಆ ಕೇಸಲ್ಲಿ ಅವ್ರ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ಲ, ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಪಾರ್ಟಿ.
Milord, Bhagyamma's husband and children are already on.
ನಾವು ಅವಾಗ ಹೇಳಿದ್ವಿ she was not necessary party ಅಂತ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ವಲ್ಲ.
ಹೌದು.
But having made her party, either her death should be reported if she is not alive, or her name should not be shown here. ಮಾಡ್ಬೇಕಲ್ಲ.
Not necessary.
ಇದೇನೋ ಗ್ಯಾರಂಟಿ ಸ್ಕೀಮ್ಗಳ ತರ ಇದೆ ಅಲ್ಲ, ಇದೆಲ್ಲ ನಿಮ್ಮ ಕಾಂಪ್ರಮೈಸ್.
Milord, may I make one suggestion, Milord? The presence of the parties may kindly be recorded, and if we'll assist this honorable court with necessary clarifications tomorrow.
Of the plaintiffs in OS number 632/2007 for the relief of partition and separate possession is partly decreed in respect of B schedule property only, and it is further decreed and declared that plaintiffs are jointly entitled to 1/3 share, and defendant number 1 is entitled to 1/3 share, and so also defendants 2 to 4 are entitled 1/3 share in schedule B property.
Schedule B properties ಯಾವ್ದು?
Plaintiffs jointly entitled to 1/3. Defendant number 1 is entitled to 1/3. Defendants 2 to 4 are jointly entitled to 1/3 in B schedule. It is further declared and directed that defendants to partition the above schedule B property by meets and bounds.
B schedule
Plaintiffs
property,
be
yeah.
allotted their share 1/3 share in B schedule property. The suit of the plaintiffs in OS 75/58/2008 for partition partly decreed in respect of subschedule item number 1 to 4 and 5. Plaintiff number 1 is having 1/4 share. Plaintiffs 2 to 4 having 1/4 share, and 1 to 3 are entitled to 1/4 share in 1 to 4 and 5 property. Declare that sale deed dated 25/8/2008 executed by define number 3 in respect of item number 2 property in respect of define number 8 is not at all binding on the plaintiffs. Define ಈಗ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳ್ತಿರೋದು ಯಾವ ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ?
Blood, the two items, blood, survey number 65/2A.
ಯಾವ್ದು?
Rescheduled property nalli, that is in respect of two properties.
ಅಲ್ಲಿ ಯಾವ ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳ್ತಾರೆ?
Compromise ಮಾಡ್ಕೊಳ್ತಾ ಇರೋದು two survey numbers, blood. The item number 1 and 2 in the.
ಡಿಕ್ರಿಯಲ್ಲಿ ಯಾವ್ದು ಹೇಳಿ? ಐಟಮ್ ನಂಬರ್ 1 ಆಫ್ ಸೂಟ್
ಹೇಳ್ತೇನೆ.
ಸರ್ವೆ
2 and 3 1.
ಸರ್ವೆ
Sorry.
2 and 3.
1 and 2 in the.
ಒಬ್ರು 1 and 2 ಅಂತೀರಿ, ಒಬ್ರು 2
ಎಲ್ಲ
and 3
ಹೇಳ್ತೀನಿ.
ಅಂತೀರಿ.
I will confirm, Lord. I will confirm. Decree ಕೊಡಿ.
ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಮೊದಲೇ ಫೈಲ್ ಮಾಡಿದ್ರೆ
Item number 1.
Item number 1 and 2.
ಇದು OS ಬೇರೆ sir.
My lord, the two items, my lord, that is survey number 65/K, measuring 2 acres 16 guntas.
ಐಟಮ್ ನಂಬರ್ 1 and 2 in schedule RFP 2325.
ಹೌದು 2325. ಎರಡು ಐಟಮ್ ಇದೆ, ಒಂದು ಸರ್ವೆ ನಂಬರ್ 65/2A.
ಅಲ್ರಿ ನೀವು RFP ಶೆಡ್ಯೂಲ್ ಯಾಕೆ ತೋರಿಸ್ತೀರಿ? ಸೂಟ್ ಅಲ್ಲಿ ಯಾವ
ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ನಾನು ತೋರಿಸ್ತಾರೆ.
ನಿಮ್ಮ ಇದ್ರಲ್ಲಿ ನೋಡಿ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಗೆ ಶೆಡ್ಯೂಲ್ ಅಂತ ಬರ್ದಿದ್ದೀರಾ.
ಹೌದು.
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಆಸ್ ಡೀಟೇಲ್ಡ್ ಅಂಡರ್ ಐಟಮ್ ನಂಬರ್ 1 and 2 of suit schedule in RFA number 2325.
RFA number ಅಲ್ಲ, RFA number arising out of 75 suit number ಅಂತ ಬರಿಬೇಕಿತ್ತು.
ಮಾಡೋದಿಲ್ಲ ನಾವ್ ಇದನ್ನ. ಈಗ ಅದು ಎಲ್ಲ ಇವನ್ನ ರೆಕ್ಟಿಫೈ ಮಾಡ್ಕೊಳ್ಳಿ. ಏನದು ಆ ಕಾಂಪ್ರಮೈಸ್ ವಾಟ್ ಇಸ್ ದಿಸ್ ಅಪೀಲ್ ಮೆಮೋ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡೋದು. ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಕೇಸಲ್ಲಿ ಒಬ್ರು ಮೈನರ್ ಇದಾರಲ್ಲ,
ಹೌದು, ಸರ್ಟಿಫಿಕೇಟ್ ಒಂದು ಕೊಡ್ಬೇಕು.
ಸರ್ಟಿಫಿಕೇಟ್ ಬೇಕು, ಅದು ಮೊದಲು ಅಮೆಂಡ್ ಆಗ್ಬೇಕು. ದೇ ಆರ್ ಬ್ರಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಎಸ್ ಏನಂತ ತಗೊಂಡ್ ಬಂದಿದ್ದಾರೆ ರೆಕಾರ್ಡ್ ಮೇಲೆ
LRs of deceived respondent number 6.
ನಂಬರ್ 6 ಅದು ಇಲ್ಲ, ಅಮೆಂಡ್ಮೆಂಟ್ ಇಲ್ಲ.
ಇಲ್ಲ.
ಅದಕ್ಕೆ ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಬೇಕು, ಗಾರ್ಡಿಯನ್ ಅಡ್ವೊಕೇಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಬೇಕು. ಅದನ್ನೆಲ್ಲ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಈ ಆ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲೂ ಅದನ್ನ RFA ಶೆಡ್ಯೂಲ್ ಅಲ್ಲ, ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಅಂತ ಮಾಡಿ ಅಥವಾ ಡಿಕ್ರಿ ಶೆಡ್ಯೂಲ್ ಅಂತ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ಮಾಡ್ತೀವಿ.
ಆಗ್ಬೋದು.
ಅಂಡ್ D8 ಒಬ್ರು ನಾವು ಉಮಾ ಪ್ರಸಾದ್ ಅಂತ ಹೇಳಿ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ಒಬ್ರು ಪರ್ಚೇಸ್ ಅದಕ್ಕೆ ಆ ಶೆಡ್ಯೂಲಿಗೆ ಅವ್ರು ಮಾಡ್ಕೊಳ್ಳಿದ್ರೆ ಅವ್ರಿಗೆ ಪರವಾಗಿಲ್ಲ.
ಇಲ್ಲ, ಅದನ್ನೆಲ್ಲ ಒಬ್ರು ಡಿಲೀಟ್ ಮಾಡಿರೋ ಪ್ರಶ್ನೆ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ, ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಬರಿಬೇಕಾಗಿತ್ತು ಅದು. Because that was already resold to our family only, so it has become.
In turn, defendant number 8 has reconveyed the property. Defendant number 8 ಹೆಸರು ಏನು? ಅದು
ಉಮಾ ಪ್ರಸಾದ್.
8 ಉಮಾ ಪ್ರಸಾದ್.
ಹೌದು, ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ,
ಈ ಅಪೀಲ್ ಪಾರ್ಟಿ ಇದಾರಾ ಇಲ್ವಾ?
ಇಲ್ಲ, to whom it was sold, my lord, thereafter it was repurchased. ಹಾಗಾಗಿ he is not a necessary party ಅಂತ ಡಿಲೀಟ್ ಮಾಡಿದ್ರು.
Property sold to him 25/8/2008 executed in suit item number 2 property. So ಈ ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ತಿರೋದು ಅದ್ರ ಬಗ್ಗೆ
ಅಲ್ಲ, ಈಗ ಅವ್ರ ಕಡೆಯಿಂದ ವಾಪಸ್ ನಾವು ತಗೊಂಡು
ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋದು ಅದ್ರ ಬಗ್ಗೆ ತಾನೆ.
ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಐಟಮ್ ನಂಬರ್ 1 and 2 only 2 items.
ಮತ್ತೆ 2 ಈಗ if compromise is with respect to item number 2 also, he should also be present.
ಅಲ್ಲ, ಅವರು he has executed a sale deed. He has
ನಮಗೆ ಗೊತ್ತಾಗಬೇಕಲ್ಲ
ಅಲ್ಲ,
this appeal or
ಅದನ್ನ ಕಾಂಪ್ರಮೈಸ್ ನಲ್ಲಿ we should have disclosed it. It should have been mentioned.
Sale deed is executed when? ಯಾವಾಗ sale deed?
6/10/2023.
6/10/2023.
Pending this appeal.
Exactly.
ಹಾಗಾದ್ರೆ ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬಂದು ಹೇಳಿಸ್ಬೇಕು, ನಾವು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳಿ.
ಸೇಲ್ ಡೀಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಆಗ್ಬೋದು.
ನಮಗೆ ಅದಕ್ಕೆ ನಾವ್ ಹೇಳಿದ್ವಿ, ನಾವು ಕಾಂಪ್ರಮೈಸ್ ಈ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿ ಅಂದ್ರೆ ನಮ್ಗೆ ಡೌಟ್ ಬರಕ್ ಶುರು ಆಗುತ್ತೆ.
ಇಲ್ಲ, we will clarify that.
It will be very clear in this. ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ, ಸೇಲ್ ಮಾಡಿದ್ರೆ ಯಾ ಮೇಡ್ ಇನ್ ಪಾರ್ಟಿ ಟು ದ ಸೂಟ್ ಅಪೀಲ್ ಸೂಟ್ ಎಲ್ಲದಕ್ಕೂ ಮಾಡಿದೀರಾ. ಈಗ ಎಮರ್ಜೆಂಟ್ ಆಗಿ ಕಾಂಪ್ರಮೈಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅದೆಲ್ಲ ಶುಡ್ ಬಿ ಇನ್ ಆರ್ಡರ್.
Allowed me kindly, next week we will clarify and
ಇವನ್ನೆಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಏನೇನಿದೆಯೋ ಅದು ಮಾಡಿ.
That compromise, fresh compromise petition we will file along with all details.
ಇನ್ನು ಮಾಡಿ, ಏನು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ raised on the memo for deletion of R8. ಇಲ್ಲಿ ನೀವು ಡಿಲೀಟ್ ಮಾಡಿದ್ರು he has not preferred appeal.
ಇಲ್ಲ.
ಮತ್ತೆ ಅವ್ರನ್ನ ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ರಿ ಹಂಗಿದ್ರೆ? The
ಮಾಡಿ
sale deed
ಅವಶ್ಯಕತೆ
was- sale deed was declared as not binding on them, alva? He did not prefer any appeal.
ಇಲ್ಲ ಇಲ್ಲ ಯಾಕಂದ್ರೆ ಸಿನ್ಸ್ he has sold it, he has no surviving interest ಅಂತ ಹೇಳಿ therefore we have deleted because sale deed copy is produced. But here no, there is no order is passed on the memo.
25, ಅದೇನೋ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಮೆಮೊ ಮೇಲೆ.
ಅದೇ ಎರಡನೇ
I
ಎರಡನೇ
furnished-
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಡಿವಿಷನ್ ಬೆಂಚ್ ಆಗಿದ್ರಿಂದ
Second
ಇನ್ನೊಂದ್
set
ಸೆಟ್
ಕೊಟ್ಟಿಲ್ಲ.
I have furnished it now, furnished it.
ಏನ್ ಕೊಡ್ಸಿಲ್ಲ? Have a meeting at 5 o'clock, oh, sorry.
Next week, my lord, may kindly give a date, my lord, we will furnish the
Board counsel. ಈಗ
Fresh
ನಾವು
compromise.
compromise petition ತಗೋಬೇಕಾ?
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಅದರಲ್ಲಿ modify ಮಾಡ್ಬೇಕು. Instead of some correction, we will file a fresh compromise petition.
Date may fix ಮಾಡೋಣ.
Both
That may be
counsels
given
will
back
time
to us.
to comply the pending office objections. ಆ ಸೆಕೆಂಡ್ ಸೆಟ್ ಅಲ್ಲೇ ಕೊಡಿ, ಅದೇನಿದೆ ನೋಡ್ಕೊಳ್ತಾರೆ. ಲಿಸ್ಟ್ ಆನ್ 28.
ಆಯ್ತು.
ಮತ್ತೆ
28.
Great.